see everyone. I'm Sandy Chom. I'm Vice President for Research and Policy Programs here at the Environmental Law Institute. We're really delighted to welcome you here today. And we really want to thank our co-hosts, the British Institute of International Comparative Law and the MIT CEPR, Center for Energy and Environmental Policy Research. We're really looking forward to a rich discussion over the next day and a half around trends related to corporate climate litigation. At ELI, we work to identify solutions, law and policy solutions to urgent environmental problems. And a key way that we do that is the comparative approach, working with partners to identify what works and then to move from theory to practice. Based in Washington, D.C. and operating globally, ELI draws on principles of good governance to work at the local, state, national, and international levels. Of course, the biggest challenge complicating and exacerbating all other challenges today is climate change. In our constitutional democracy, when other branches of government, our legislative and executive branches of government, have not sufficiently responded to a challenge, we have recourse to the courts. And that's why there are long roots in our common law system, as in other systems, of recourse for injury, for harms that underpin our modern environmental law legal framework and give us recourse for harm. When new challenges have historically arisen with legally confounding fact patterns and unprecedented humanitarian or financial stakes, the law has innovated. Litigators and courts have had to modernize and evolve legal doctrines to address those challenges. And they've done that historically, and that seems to be the situation we're in today. In spite of long established understanding of the causes and impacts of climate change, our governments have been struggling to take the steps necessary to respond. As a result, litigation, and thus courts, are playing an increasingly important role in solving the climate puzzle. Climate issues are reaching courts in an enormous range of ways, from bankruptcy to insurance to building codes. One critical part of this legal puzzle is identifying standards of care for private actors, foreseeability and liability for the harms we're all facing. As such, there's a growing trend in climate litigation of lawsuits against corporations on a wider variety of issues, as you'll hear from my colleagues Jared Page and Christine Perry later. Many of these cases are still in the procedural phases here in the United States, but they are proceeding to the merits. Climate change is a global problem, and so the value of understanding legal approaches beyond national borders and learning from each other to address this problem is especially critical for meeting this challenge. It's a thrill to get to talk today about how corporate litigation regarding climate change is taking place across the Americas. We're very grateful to this community and to BIICL and CEPR for this event. And I look forward to hearing from this amazing faculty about the picture across the Americas and to discussing with you the opportunities and challenges these cases present. Michael.
Continue. Thank you, Sandy. Thank you very much to Environmental Law Institute for hosting the event today and making it possible. To Jared, Helene, and other colleagues at the Institute for helping us set it up. I'll only very briefly say a few things because Ivano is really the architect of the project. But I'm also grateful to him for having invited me to participate in the Corporate Climate Litigation project. When I started out studying law in exactly 30 years ago in the mid-90s, my first sort of serious engagement with environmental law, you have to go through all the usual stuff, private law, criminal law, etc., public law, was actually access to justice in environmental litigation. And I had a chance, and Ivano, Francesco, and some might know the European Law Students Association, to go to Sweden and hear a sort of veteran pioneer of environmental litigation there. So that really inspired me. But in the decades since, I've worked more on instruments, climate policy instruments, and the legal aspects of implementing them and sort of intersections with other areas of law. But one thing that intrigued me was, as a German, born in Germany, raised, in the legal system in Germany, I was, of course, fascinated by the court case of the Bundesverfassungsgericht a few years ago that essentially compelled the government to further accelerate what is already one of the most ambitious climate legislative frameworks in the world. But still, my work on trade and on sort of global flows of emissions, etc., pretty much show me that there's only limited progress you can make there. It's 1% of global emissions, and this is the largest economy in Europe. And really, a lot of the emissions are, of course, happening in other parts of the world, the growth in particular. We already know that countries like Switzerland and Sweden, they have reduced their domestic emissions so far that they're now importing more emissions in goods from countries like China, Indonesia, Vietnam, etc. So there's limits to how much you can go, how far you can go with strategic litigation against countries. But corporations, of course, are active around the world. And so even in Indonesia, if it's a US-based or European company, and you can compel them, this will have ramifications even in jurisdictions where I think strategic litigation against the government, given the legal system, given the judicial system there in process, might not be so promising. And I think especially in the current day, in the current day and age, where international coordination and cooperation on these matters is threatening to fall, to really sort of recede, and the global economy is fragmenting, geopolitical diversity or rivalries are escalating. This is really an avenue of potential progress on climate in an area where we need it very much. And so I'll let Ivano say more about the project. Thank you.
Thank you very much, Michael. Thank you very much, Sandra. And I would like to thank also the Environmental Law Institute to host us here, and the great team, Jared, Hélène, Christine, everyone. It's been really a pleasure to organize this together. So I'm going to talk to you about the reason why we are here, in the sense there is a project that we started from London that is called the Global Toolbox on Corporate Climate Litigation. I don't know if you can. Oh. Maybe it's yeah.
What, okay at the top? You have to accept that.
Okay.
Yeah.
Perfect. So this is the project, and it's a project that we started actually a couple of years ago, and last year was presented as the Global Toolbox on Corporate Climate Litigation in London. The idea was to explore a part of climate litigation that at that moment was a little bit less studied by the scholar community. So here on our panel, there is people that contributed to a previous project that was called the Model Statute on Climate Change Litigation, which was by the International Bar Association. Great initiative, talking about the climate litigation against governments. And that is the moment in 2020 where at BIICL we had the idea of trying to create something around this, but litigation involving business, which in this moment is also taking place a little bit all over the world. And so this is really something that we wanted to do together. So this is the initial name of the project, an academic name, because we are an academic institution, an independent research institute. So global perspectives on corporate climate litigation tactics. And we started immediately with a comparative analysis with 17 countries, all the jurisdiction that at the time was September 2020 to add this kind of litigation in their legal system. And basically what we did is to create around these people, the rapporteurs that are great academic group of experts. So the collective goal, as you see, we are working on comparative law. So the idea was to map and to have a comparative analysis of what was done everywhere in the world, because in a way this is we are at the beginning of this field, so we really need to understand the lesson learned also from other fields, not just from climate litigation, because as we said in against corporation, this was still at the beginning, and the idea is to create some prospects, to propose something new, also trying to take advantage of discussion between experts in different legal systems, experts from different areas. So if you see, every one of the 17 national groups that are participating in this project are made of practitioners, judges, scientists, academics from different fields, and experts, of course, in environmental law. And the idea, of course, is also to encourage corporate actors to mitigate the risk. This is a little bit the idea that at a certain point will come in probably in the next years. And okay. This is the working group. As I said, there is a core group with some of the most renowned people around the world working in this field. So we have, for example, Professor Michael Gerrard that we will hear about in a few minutes. And of course, we will have also we have in this group also great scientists like Rikidi, like Naomi Reskes. We have judges, I would say, really very interesting judges from the point of view of the knowledge that they continue to transmit also to the other courts on environmental law topics, like Brian Preston. We have really a fine group of people from all over the world. Emmanuel Ugere-Shebuya, who is now the Minister of Justice in Rwanda, is also part of the group, and many others. So, and around that, as I said, we're organizing an international expert group, which is made of all the experts in the different countries. This is the core group, but please go on the website and you will see a little bit clearer. And yeah, these are the 17 countries. And this is the first version of our Corporate Climate Litigation Toolbox. So there you will find all the different national reports that we produce with the help of our expert, and all these comparative analysis that you see here. And we work on the three main axes of this kind of field. So all the causes of action, all the possible causes of action that we can find when we are working on this field. And of course, which could be climate change, environmental statutory provisions, could be all the different kind of tort law. And this was, of course, comparatively something quite difficult, because we have to deal with the definition of tort law, the different definition of tort law in civil law systems that are not adopting that, of course. And as you see, there are many others, and I invite you just to go and check our work. And of course, the procedure and evidence, all the different aspects related to justiciability, to standing, and anything that might be really relevant to make this work a little bit better. And of course, the remedies. We are still at the beginning, but also an analysis, a comparative analysis of what are the remedies available in this moment around the world could really help us, you know, push this knowledge a little bit further. And yeah, these are the national reports. You can find them, of course, they are downloadable. And from this year, we are going to have a version where we are let's say, updating each national report. So you will find each team that with a web page with all the different participants and the different outputs, including the national report, which will be updated every few months. And yeah, this is part of the dissemination strategy for this project, which in a way we are really arriving toward the end. This is was made in the last year, about 17 national conference. The last one will be in a few days in The Hague, of course, in the Netherlands, will be in Utrecht, as you can imagine, also for the symbolism of that. And this is the last regional summit. So we try to bring together, as you will see today, the national reporters from the different countries that participated in the project in that region. And we try to create a discussion and exchange. And yeah, and another part that is quite interesting about our project is we contribute as, you know, but we arrived very late because Eli is doing that since many years, to this judicial training effort. So we've done training for Asian, African, European, and tomorrow we will have also a training for American judges on this topic. And this is just to finish the newest version of our global toolbox that you will see on our website. And I hope that you can take advantage of these resources, and that you will join also, you will like this conference. So without further ado, I will just introduce, since I'm the one speaking here, I introduce our keynote speaker. We have the honor and the pleasure of having with us Professor Michael Gerrard. I wouldn't say it's unnecessary to present Professor Gerrard because it's true, everybody knows him. But I want to have anyway a short introduction of him. So he's the founder and faculty director of the Sabin Center for Climate Change Law at Columbia University, and is one of the foremost environmental lawyers in the nation, and I would say also one of the most important climate and environmental lawyers in the world. Michael Gerrard is an advocate, litigator, teacher, and scholar who has pioneered cutting-edge legal tools and strategies for addressing climate change. He writes and teaches courses on environmental law, climate change, and energy regulation for 3 decades before joining the Columbia Law School faculty in 2009. Michael Gerrard practiced law in New York, most recently as the partner in charge of the New York office of Arnold and Porter. And as an environmental lawyer, he tried numerous cases, argued many appeals in federal and state courts and administrative tribunals. And he also handled the environmental aspect of diverse transaction and development projects and provided regulatory compliance advice to many clients in private and public sector. And of course, several publications rated him as one of the leading environmental lawyers in the world. And I'm really honored to finally have him in person here with us. Thank you very much, Michael, and the floor is yours.
Thank you so much. It's a great pleasure to be with all of you today. I'm going to talk about where we are with corporate climate litigation, how we got here, and some thoughts on what the future might look like. And most of you are probably familiar with the Sabin Center's database of climate litigation around the world. By latest count, we have 3,018 cases on this database. About 2/3 of them are from the United States. As you can see here, Australia is a distant second. The UK is a distant third. These are cases by latest count in 53 different countries around the world and 22 different international and regional tribunals and other bodies. The number of climate change cases has been increasing. On this chart, the dark blue bars are the US cases, and the lighter bars are the non-US cases. The non-US cases really began taking off around 2018, 2019, 2020. I think that one of the inspirations for the cases outside the US was the very important Urgenda decision from the Netherlands, which I'll talk about more in a minute. Most of the cases are from the global north. As of about a year ago, 87% were from the global north, only 8% were from the global south, and 5% were international. But the number of cases in the global south has been increasing considerably, which is a very important sign, and which is, of course, part of the subject of today's conference. So the definition we're using for corporate climate litigation from Manu, cases before domestic courts, whether brought by plaintiffs, such as NGOs, individuals, cities, or states, against corporations, or initiated by corporations themselves. So if we start by looking at the cases in the US, since 2/3 of all the world's climate cases are in the US, the most numerous cases are under the National Environmental Policy Act, NEPA, and its state equivalents, mostly California. This, of course, are our laws requiring environmental impact assessment. And these cases are mostly challenging specific projects. And so corporations are defendants. They sue the government, plaintiffs sue the government, but they also sue the corporations as defendants. We have a large number of cases under the Clean Air Act, and many of those are cases brought by corporations challenging EPA regulatory action. Cases under the Endangered Species Act are mostly brought by NGOs, but often corporate interests intervene because they don't want certain species to be listed as endangered in a way that would inhibit the construction projects that they want to undertake. Sort of the most famous lawsuits against corporations are not very large in number. The common law claims that I'll be talking about, they are of great prominence, but they're not large in number. So looking at the overall scheme of climate litigation, a significant portion of these cases involve corporations on one side or the other. Let's get that. So one important line, probably the most prominent line of cases, was lawsuits brought by states and cities against fossil fuel companies, initially under the federal common law of nuisance, the idea that the federal courts could establish requirements or liabilities because of pollution, of interstate pollution. State of Connecticut and state of New York and others sued American Electric Power and several other electric utilities. They sued in federal court in New York, seeking an injunction requiring these power companies to reduce the emissions from their coal-fired power plants. The case went up to the US Supreme Court, and in a decision written by Justice Ginsburg, the court said that this case could not proceed, that the federal common law of nuisance exists to fill in gaps in the law, but the Congress enacted the Clean Air Act, which gave the Environmental Protection Agency the job of controlling greenhouse gases, and therefore it was not appropriate for the federal courts using the federal common law of nuisance to set emission standards. There was simultaneously a case pending brought by the village of Kivalina, Alaska, against Exxon and several other fossil fuel companies. Kivalina is endangered by the melting of the sea ice. They need to relocate to higher ground. They were suing not for an injunction, but for money damages. The Ninth Circuit, relying on this Supreme Court precedent, said, no, this precedent applies not only to injunctive actions, but also to actions for money damages. So it became clear that the federal common law of nuisance was not available, but the courts left open the question of the state common law of nuisance and other state claims. So beginning in 2017, we started to see a large number of cases brought by mostly by states and cities against the fossil fuel companies seeking money damages. There are now, by my count, 38 of those cases that have been brought around the country. They initially focused on the state common law of nuisance. More recently, the cases have focused on the deception by the fossil fuel companies. None of these cases has gotten to trial. For several years, there was a major controversy over whether they belonged in state court or federal court. The plaintiffs wanted to be in state court. The defendant fossil fuel companies wanted to be in federal court in the hopes that the American Electric Power decision would govern and would lead to the dismissal of the cases. After years of litigation about that, they are now in state court. One of them, the case brought by Hawaii, survived the motion to dismiss at the Hawaii Supreme Court. The oil companies asked the US Supreme Court to take the case. Somewhat surprisingly, the US Supreme Court refused. And so that case is moving forward in Hawaii, although there are other procedural motions ahead. In Massachusetts, a case that is based solely on consumer deception survived various appellate challenges and is now getting ready for trial. So we may see a trial in Massachusetts in the next year or so. In Hawaii, the next case that's furthest along, there will be motion practice, so probably won't see a trial there for a while. But these are important cases, but as I say, none of them have gotten to adjudication of the merits. They've entirely been on procedural issues and on purely legal issues. We're seeing a new front in that two states, New York and Vermont, have enacted what they call state climate superfund laws. And these are laws patterned after the US Superfund law on hazardous waste, which would hold the fossil fuel companies strictly liable for their past emissions. And the idea is that each of the major companies would have to pay a certain amount of money. In New York State, the law is a total of $75 billion over 25 years, so $3 billion a year. These are new laws. They're already being challenged in federal court. We'll see what happens with them, but it's an interesting development that tries to impose liability on the fossil fuel companies through entirely different theories. The issue of disclosure by corporations of their climate impacts and their greenhouse gas emissions and so forth is also very important. The Securities and Exchange Commission issued under President Biden, issued draft regulations that required the disclosure of Scope 1 and Scope 2 and Scope 3 emissions. There was a big pushback. The SEC dropped the Scope 3 requirement in its final rule. The Trump administration is clearly going to withdraw the rule altogether. But California has adopted its own law, which requires Scope 1 and Scope 2 and Scope 3 disclosures. It applies not only to public companies, which were what the SEC rule would apply to, but also to private companies. And unlike the proposed SEC rule, it does not have a materiality requirement that you don't have to disclose only those emissions that are material. This California law applies to companies that do business in California. California is a very large economy. It's the 5th largest economy in the world. And so most big companies are subject to the California law, which applies not only to emissions within the state of California, but also globally. Unsurprisingly, this California law is also the subject of a lawsuit in federal court. So far, it has survived some initial motions. We'll see what happens with it, but it's an interesting example of subnational governments taking their own actions that can have a broader impact. Another major round of litigation, major source of litigation, of course, is challenging the actions of the federal government. On the day that Donald Trump was first inaugurated in 2017, the Sabin Center launched this website, the Climate Deregulation Tracker. We ended up having 176 items on this tracker. Most of these were challenged in court. On the day that Biden was inaugurated, we rebranded it the Climate Re-Regulation Tracker. And on the day of Trump's second inauguration, it became the Climate Backtracker. And our staff is very, very busy populating this with new items. We also, early in the Trump presidency, the first Trump presidency, we teamed with the Climate Science Legal Defense Fund to launch the Silencing Science Tracker, which was also very busy during the first Trump administration, quiet during Biden, and now very noisy again. So all of these are leading to challenges in court. And the environmental law organizations in the United States that litigate, groups like Earth Justice and NRDC and the Environmental Defense Fund, are very, very busy and many others are very busy litigating against all these actions. During the first Trump administration, the Trump administration lost most of these cases. So this was an analysis done by NYU of the win rates by presidential term in challenges in court to major regulatory actions. And the Trump administration, the first one, won only 31% of the cases. Their terrible record was mostly because they were very sloppy procedurally. They didn't carry out the requirements of the Administrative Procedure Act and the National Environmental Policy Act and other procedural laws. We'll see whether this time around they're more careful. Exercising due care and following all the procedures is very time consuming. We don't know if they'll have the patience to do that. Additionally, in order to revoke a regulation, you need a new regulation. In order to issue a new regulation, you need a staff, and they are firing much of the staff. So whether they actually will have the capacity to revoke all these old regulations and issue new ones, and whether they will be able to do that in a judicially survivable manner remains to be seen. So far, their legal efforts have not been very impressive, but we'll see how that turns out. A very concerning development in suits by corporations just occurred. Back in 2016 and 2017, there were protests in North Dakota against the construction of an oil pipeline that was being built by a company called Energy Transfer. The pipeline would have been near the Sioux Indian reservation. There were tremendous protests by the Native Americans who live there, and several other groups around the country participated in the protests. Energy Transfer, the company, decided to sue Greenpeace. Greenpeace had played a role in sort of training some of the demonstrators. They said that they did not condone vandalism. There was some vandalism and other actions. Energy Transfer sued them. They sued initially in federal court, but that case was dismissed because of insufficient evidence. So Energy Transfer went back and sued them in North Dakota State Court. The trial just occurred, and 2 weeks ago, the jury awarded $660 million in damages against Greenpeace to Energy Transfer. Now, there's Greenpeace USA, and there are some European-based Greenpeace entities. They're based in the Netherlands. In Europe, there is a law against SLAPP suits, strategic lawsuits against public participation. Most US states have similar laws. North Dakota does not. Greenpeace has started a lawsuit against Energy Transfer in the Netherlands, saying that this lawsuit violates the European law. Now, I don't think that'll have much effect on the collection of this judgment against Greenpeace USA, but most of the assets of Greenpeace internationally are outside the USA, and this lawsuit may inhibit the ability of Energy Transfer to get the rest of this. Now, this decision is being appealed by Greenpeace to the North Dakota Supreme Court. We'll see what happens with it. The Trump administration just a few days ago announced another effort to try to inhibit climate change litigation by directing its lawyers to the Department of Justice to ask the courts to impose financial sanctions on lawyers who bring frivolous lawsuits against the administration. Now, it'll be up to the judges whether to grant these sanctions, and these kinds of sanctions are rarely granted, although it may be that there are some judges who will be more inclined than others to grant this. But it's clearly an effort to inhibit these kinds of lawsuits. One reason why there is so much environmental litigation in the United States is that in the United States, unlike many other countries, each side bears its own attorney's fees. We're not a country where the loser has to pay. But this effort by the Trump administration is, in essence, an effort to try to turn that around. Another action by the opponents of climate regulation, mostly corporations, is to go after scientists and lawyers and others who are fighting them. One important tactic is the use of the public records laws to try to get the emails of all of these people. And so Rachel Rothschild is a professor at the University of Michigan Law School. She assisted in the drafting of the state climate superfund laws that I talked about a minute ago. The University of Michigan is a public entity, and so it is subject to the state's public information laws. So they're trying to go after the emails on her personal email account. So there's a fight about whether those are official government records. But in general, we see climate scientists who work for public institutions are being harassed by the opponents of climate regulation. That's one of the reasons why the Climate Science Legal Defense Fund, which I mentioned, was formed, was to help these climate scientists. One extremely important case in the world of corporate climate litigation is Mena Defensie versus Royal Dutch Shell. This was brought by an environmental group in the Netherlands. They sued in the Sabin port that handled the Urgenda case. The Urgenda case, as most of you know, was a decision in which the courts and ultimately the Dutch Supreme Court said that the government of the Netherlands needed to do considerably more to reduce its greenhouse gas emissions, even more than its Paris pledge. So these plaintiffs sued in the same court in The Hague in the Netherlands. And the trial level court in May 2021 issued a remarkable decision saying that Royal Dutch Shell needed to reduce its emissions, and not only the emissions by the corporate parent, but also all of its subsidiaries globally. And not only its scope 1 and 2 emissions, but also its scope 3 emissions, the emissions by its customers. So that decision received a great deal of attention in the corporate world. And when it was issued, it was seen as triumphant. Here's the head of the organization that brought it. But the decision was reversed by the Intermediate Appellate Court in the Netherlands in November. And the Intermediate Appellate Court said that you couldn't really bind a Shell to a numerical requirement, this 45% reduction in scope 3 emissions by 2030. There wasn't really a strong basis for that. And requiring any one company to reduce its emissions wouldn't reduce the overall amount of fossil fuels produced. Somebody else will do it. So this was initially seen as a real defeat for the plaintiffs. However, in some ways, it could be seen as a Pyrrhic victory because of the other language that was in the appellate court's decision. The appellate court decision said that corporations do have a responsibility to reduce their greenhouse gas emissions. They were relying in part on the European Corporate Sustainability Due Diligence Directive, but the decision also had many references to human rights doctrines and to the human rights treaties that many of the countries, that all the countries of Europe have signed on to, and that are similar to treaties that many countries in other parts of the world have signed on to. So this court found that companies have a duty to protect human rights, that they must make an adequate contribution to achieving the Paris climate goals. The companies have responsibility for scope 1 and 2 and 3 emissions, and regulatory compliance may not be enough. It may not be enough if the law, if these companies are following all the statutes that and regulations that apply to them. The court concluded that corporations have an obligation to limit CO2 emissions, and they have their own responsibility to achieve the targets from the Paris Climate Agreement. So this is a decision who's obviously not binding elsewhere in the world and is subject to the further appeal to the Netherlands Supreme Court. But I think the ideas in this decision may be helpful globally. There are several cases pending around the world against fossil fuel companies. Many of you are probably familiar with the case brought by Mr. Lua, a resident of a farmer in Peru, who is saying that his farm is being endangered by the melting of the glaciers in the Andes. He's suing RWE, the biggest electric utility in Germany, in the courts of Germany. This survived some initial motion practice. The judges actually went to the Andes to see the glaciers. They had hearings starting last week. So this is a very active case. We'll see what happens with that. Most countries in the world have a right to a healthy environment written into their national constitutions. The US does not, but most countries do. And most countries in the world have ratified numerous human rights treaties. And those treaties have often been interpreted by various UN bodies and others as embodying a right to a healthy environment, including climate change. So these constitutional doctrines and these human rights theories are of great significance, and I think may be very helpful in corporate climate litigation. Finally, as you're all aware, there have been 4 important more than four, but important cases before four international tribunals. The European Court of Human Rights, in a decision in a case brought by a group of elderly Swiss women, held that the government of Switzerland was not doing enough to reduce climate change. The International Tribunal for the Law of the Sea ruled that the provisions of the UN Convention on the Law of the Sea that require countries to prevent pollution from harming the marine environment, they held that that applies to climate change, and states have an obligation to act on that. We're now awaiting decisions from the International Court of Justice and the Inter-American Court of Human Rights. And it may be that emerging from these decisions will be further explication of legal doctrines that will be very helpful in corporate climate litigation around the world. Other than the European Court of Human Rights, these other tribunals can only issue advisory opinions, but these advisory opinions can be very influential in domestic courts. And we've already seen around the world quite a few domestic courts finding that these sorts of doctrines compel their governments, their national governments, to do more on climate change. I think what we saw in the Mayo Defensi case and some others shows that some of these doctrines may also apply to corporations. So thank you all.
Welcome to the first panel, State of Play and Emerging Trends of Corporate Climate Litigation Across the Americas. So this first panel is in a way the introduction to this conference in terms of the knowledge that we have in the different legal system, because we have gathered together the rapporteurs from Brazil, from Canada, with joining us online, and our colleagues from ELI are going to play as our US rapporteurs, even though the rapporteur from the US is Michael Manning, our co-organizer, and the co-writers of this report that you find on the website is Lisa Benjamin and a professor from, she's a professor in the US. So yeah, this will be, let's say, is a patchwork of people that have been working on the US part, and it's great to be in ELI because in a way we are going to have also people that are working in practice in this area. So let me just introduce with the first speaker, with Gerrard Page. He's a staff attorney at the Environmental Law Institute, where he works at the intersection of climate change, policy research and education. And he brings experience in domestic and international environmental law and policy to his work on the Climate Judiciary Project, public lands management, and coastal resilience. And Gerrard also written and lectured widely on climate litigation topics. He's been published in different law journals like Harvard Environmental Law Review and the Georgetown Journal of International Law. He's also the co-author of a forthcoming book chapter on Health versus Montana, which is, as you know, a very important case here in the US. And he received a JD with honors from George Washington University Law School here in DC. And Gerrard, I will just leave you the floor to you, and thank you very much for everything, also for organizing this.
No, of course. So thank you all for joining. Delighted to be here today to talk to you about sort of the US perspective in terms of where we are and emerging trends. Some of this will have just been covered by Professor Mike Gerrard, but I hope to give a little bit more detail in a couple of these areas. And I think you'll hear some additional detail in other areas about US corporate climate litigation in forthcoming panels. So as Ivano said, my name is Gerrard Page. I work at ELI as a staff attorney, and I work a lot on our Climate Judiciary Project, which trains judges about climate science impacts and solutions, and how that climate science arises in the law. We are a research and education organization, so we don't tell judges how to rule in any particular case. We don't tell them how to rule on any particular issue. We provide them factual information in order to help them make the best decisions possible. So you just saw this slide a minute ago in Mike Gerrard's presentation, but I just want to sort of linger on it a minute. This is really the most definitive and best place to go for information about climate litigation generally, and especially corporate climate litigation. There's two databases here. There's a US database and a global database. They are very user-friendly. You can search them, you can filter them by jurisdiction, by year, by claim, and they have descriptions of the cases and links to a bunch of different documents within each docket. And so if you haven't visited this resource, I'd encourage you to. This chart shows the number of climate cases by year filed. This graph represents all climate litigation, not just corporate climate litigation. But I sort of have marked out a couple areas where I think the BIICL National Report does a really good job of sort of breaking down corporate climate litigation in these waves. And so, you know, the first wave starts in, you can see 2006 and lasts until about 2012. And that wave was really that first AEP versus Connecticut wave, where plaintiffs were bringing cases against corporations based on federal common law. A lot of these cases in this early wave were dismissed on political question or on preemption grounds, like the AEP versus Connecticut case was. The second wave actually sort of starts after the AEP versus Connecticut case. Federal common law sort of gets closed off as a door, and plaintiffs start bringing cases based on state common law. And that second wave really starts getting going in 2017, and we're still seeing that wave take place. And a third wave of corporate climate litigation is sort of separate. It started in 2015, and that wave really represents a broad diversity of claims that are being brought. So sort of beyond the federal common law and the state common law cases, you're starting to see a much greater diversity of theories. And so I'll show you what a few of those are here. I think I just want to make one more comment about this slide before moving on. It relates to this asterisk here. You heard Mike Gerrard say there's already over 3,000 cases that are in this database. And I'd like to just sort of note that I believe this is like undercounting the degree to which climate change is impacting courts. One, because it's not always difficult in terms of collecting data to find out where cases are, especially at the local and state level. And the other reason is the definition that you need to meet to be a climate case and make it into this database says that climate science, policy, or law has to be a central or material issue to the case. And there's many cases to which climate change is relevant, but not necessarily a central issue. You can think about a lot of cases following climate impacts, like thousands of insurance claims and cases that are filed after a hurricane, for example. The database similarly doesn't capture some permitting cases, for example, like a fossil fuel fired power plant. If climate isn't a material issue in the case, it's not captured in the database, even though, of course, the outcome of the case has some relevance for mitigation or adaptation. So just sort of keep that in the back of your mind. So this is a chart you just saw a minute ago, and just to sort of highlight the fact that I don't think there's any one typical climate case. Climate cases, again, it's sort of in general, they implicate a wide variety of legal theories. There's constitutional, statutory, regulatory, administrative, common law cases. And that range of cases and theories is reflected in the corporate climate litigation category as well. I've sort of highlighted a couple of pieces of the pie. These are a couple that Mike Gerrard called attention to. The common law claims and the other state law case categories is where you can find a lot of the corporate climate litigation. But the other categories can be relevant too. As Mike Gerrard said, there's NEPA cases and there's Clean Air Act cases that involve corporate defendants. So one thing I really like about the BIICL national reports is they try to provide some level of consistency among the national reports. And so here are the types of claims that are, I think, studied for each one of the national reports. And so I'm not going to walk through every single one of these 9, but I want to touch on a couple of them and highlight a couple areas where I think, again, we are at with the state of play or emerging trends. One is environmental law. So the United States doesn't have any overarching, climate change act or climate act. And so a lot of cases that are brought under environmental laws are brought under media specific laws like the Clean Air Act or Clean Water Act, Endangered Species Act. The federal common law, right? This we already touched on. This is like the American Electric Power case. Not really seeing any more cases brought on this theory because of that Supreme Court case. What we really are starting to see more of is cases in that central bucket, tort law, and then over to the right as you're shifting in this chart into consumer protection and fraud laws. And one thing I'd say is even though these boxes are showing up as discrete, items on the screen, there's a lot of interplay between these legal theories, and many, many cases bring claims on more than one of these boxes, right? So a case might bring a consumer protection claim and a tort law claim and a fraud, right? So there's a lot of interconnection between these two. The fraud cases, that includes things like greenwashing, which I think are becoming more prominent, and I'll say a word about those in a second. The human rights law cases, I think these are interesting, and I know Christine will talk a little bit more about these this afternoon, right? The US, even though we may be signatories to some of the treaties you saw on the map, we don't have the sort of robust human rights framework that a lot of other countries have. And so this is sort of a disconnect, I think, between a lot of the emerging trends in other jurisdictions where you're seeing a lot more cases brought on human rights theories, and that's not necessarily the case in the United States. I do want to say one thing about environmental rights amendments. So Mike Gerrard said, we don't have a right to a clean and healthy environment in our federal constitution, but there are a handful of states in the US that have rights like that in their state constitutions. And so these environmental rights amendments, or green amendments as they're sometimes called, are increasingly being seen as a hook for litigants to bring cases. Most of them so far have been brought against governments, that the government of a particular state isn't doing enough. That's the Held versus Montana case that Evado mentioned a second ago. But I will call your attention to one case that's reported in the report, and that's out of Hawaii. And Hawaii is a really interesting state. One, they do have a constitutional right to a clean and healthy environment. And that was relevant in a case that was looking at an agreement for a biomass power plant to provide power to a utility. And that case went up to the Hawaii Supreme Court, and the Hawaii Supreme Court said that the Public Utility Commission that was reviewing the agreement didn't look enough at the greenhouse gas emissions implications of approving that biomass plant. And the Hawaii Constitution, which guarantees a clean and right to a clean and healthy environment, requires a more robust analysis. And so you are starting to see some movement in this area, but I do think those are sort of rarer examples in the US. The company and financial laws, I think, is an increasingly important area, especially as you move into the third wave. So these are cases brought often by shareholders alleging a sort of a breach of a fiduciary duty, suggesting that the investments that are made on their behalf, investments in fossil fuel companies, for example, aren't in the best interests of the investor, for example. And many of those cases are ongoing. Just want to talk specifically, I have 2 slides on this. Tort law is really where you'll find the bulk of the information in this report. And so I think there's about 10 different types of tort law claims that are being brought in these cases. On this particular slide, I want to highlight some sort of splits that are happening. And so in the public and private nuisance category, you've seen there's been one federal court of appeals who's come out one way on this issue and one federal court of appeals that's come out the other way. And so in the city of New York for Chevron case, the Second Circuit US Court of Appeals found that those state law claims that were brought, they were brought in federal court, which sort of makes this city of New York case a little different than a lot of the other second wave cases that were filed with state law claims in state court. The city of New York court found that these claims were preempted and the case was dismissed. The San Francisco Bay cases, that's the city of Oakland and the city of San Francisco, those cases were not preempted. And so those were allowed to move forward, and those sort of represent a circuit split. The US Supreme Court has so far declined to get involved in any of these cases. And so we'll see if that continues to hold true. And I just want to also mention the split in this little blue box here on the negligent strict liability or failure to warn. Again, just suggesting that these cases don't allege only one of these claims, and often, many claims are included in one particular complaint. I'm just lifting up a couple of cases within each category there. So the mayor and city county of Baltimore and the board and the county commissioners of Boulder County, both of these are second wave cases. So that means they were brought by cities, states, municipalities against fossil fuel companies based on state law claims and filed in state court. And now that the Supreme Court has sort of declined to get involved in the jurisdictional question about whether or not federal courts or state courts are the right venue, you're starting to see many of these cases proceeding back in state courts, right? Mike Gerrard mentioned the one in Massachusetts might go to trial soon, and the Hawaii one may be sort of shortly behind it. So state courts are starting to rule on the various motions to dismiss in these cases, which are sort of the first opportunity, the first hurdle that plaintiffs have to get over. And the the Baltimore case, we'll just call it the Baltimore case, the state court judge in that case did grant defendants' motion to dismiss. And so that case has been dismissed. It's appealed and undergoing appeal in the state appellate court. But in contrast, very similar case, very similar set of claims in the Boulder County case, the Colorado court denied the motion to dismiss in that case, and it is moving forward. And so what we're seeing is sort of a variety of approaches by these state law or by these state courts into how to handle these cases. And I've got a slide here in a minute that'll sort of show you an update about that. One more slide on the tort law, though, just to sort of note that I think these conspiracy claims are an emerging trend, right? Things like RICO claims or racketeering claims, that this is sort of a broader effort. There's something bigger going on here than just the actions of one particular actor at one particular moment. Boulder County is an example of that, as well as a couple of cases in Puerto Rico. And Puerto Rico is sort of also a hotbed of climate litigation. There's several cases that are pending there. I'm actually going to skip over this slide in the interest of time here. So let me just show you this update here. This is the sort of patchwork of decisions that are coming out of state courts on those motions to dismiss. And so there've been a dozen or so of these, and the majority of them have had the motions to dismiss denied, but there's quite a few who've granted the motions to dismiss. And so these cases are still continuing to make their way through state courts, and all decisions sort of that everyone in this area will be watching closely. And so I think this is really the next sort of pieces on the horizon are what are happening in the motions to dismiss in these cases, and what's happening after them. So I'll wrap up here and turn it over to Ivana.
Thank you very much, Jared. So, and you managed to also give another very interesting overview of what we have there. And yeah, it's true, the report for the US by Lisa Benjamin and Alexander Guillot is really well done, and I encourage you to read it because it's a valuable resources. we just go to the second speaker who is online with us, joining with us. Hassan, are you there?
I'm here, yes.
Perfect. So Hassan Ahmad is an assistant professor at Osgood Hall Law School in Toronto, where he researches and teaches on topics related to corporate governance, business human rights, transnational law, tort law, international law, and climate change litigation, of course. And prior to joining Osgood Hall, Professor Ahmad was an assistant professor at the Peter Hallard School of Law at the University of British Columbia. And his research has been recognized by a number of prestigious scholarly organizations, and is the co-editor of the forthcoming Cambridge Handbook of Litigating Business Human Rights, and is, of course, the author of the Canadian report for the Toolbox project. So, Hassan, thank you very much for being with us online, and the floor is yours.
Thank you very much, Ivano, and thank you everyone who organized this and for having me. My apologies, I wasn't able to join you in person and be a part of this wonderful event. Some of what I'm going to say is going to echo what's been mentioned in the American context, both by Professor Gerrard and also what Jared talked about right now with regard to some of the US claims, and then some of it is distinct to the Canadian context. So let me go through that. I did want to divide my presentation between three different topics today, looking at some of the trends that will implicate Canadian corporate climate litigation, some of the doctrinal opportunities that will be available to litigants, again, which overlap with the US, given that we're also a common law system, and then look at some of the doctrinal challenges that are there. So, there we go. Okay. So as Ivano mentioned, I authored the Canadian report for the Institute's Global Climate Change project. So that's online there. The report goes into far more details about the causes of action. I'm going to just discuss a few of them and some of the challenges. It also goes into the various procedures that are available in Canada, again, much of which overlap with other common law jurisdictions, whether it's the US or the UK. And then the last part of the report looks at the remedies that are available, again, which are not unknown to people who come from common law jurisdictions. So, okay, let's start with the trends. So, distinct from other jurisdictions, whether it's the US or even the Netherlands, milieu défensif has been brought up by the speakers today. We don't per se have what I would call a global corporate climate case in Canada yet. We don't have anything akin to a milieu défensif. So much of what I'm going to be saying is going to be perspective of the doctrines and the legal principles that may apply, but we don't have a case like that yet. What we do have in Canada is an Urgenda-like case against the government. Actually, we have a couple of them right now. We have one, Mathor, against the Ontario government, looking at the rollback of climate mitigation efforts that were undertaken by the most recent administration in Ontario. Now, that case brought a constitutional challenge under Canada's constitution. Particularly, we have something called the Charter of Rights and Freedoms. So that case was brought pursuant to a contravention of Section 7 of the Charter, which is contravention of rights, a contravention of life, liberty, and security of the person. The other part of that claim was an anti-discrimination claim. So we have Section 15 of the Charter. So it was a claim brought against the Ontario government that the rollback of climate mitigation efforts disproportionately harmed younger and future generations, similar to claims like Juliana in the US, which are youth-led climate lawsuits. So that's Mathor, the case against the Ontario government. It, by and large, was dismissed, even though there were some redeeming statements by the lower court in Ontario. It was dismissed by the lower court. And likewise, recently, it was dismissed by the Ontario Court of Appeal. I will tell you that the plaintiffs, the youth plaintiffs in Mathur have sought leave to appeal, or what you would call in the US certiorari, to Canada's Supreme Court. So we are waiting a decision from the Supreme Court on that. Briefly, I will say the other claim, the other climate case against the government has been brought against the federal government. Now, different than Mathur, LaRose, which is the claim against the federal government, has not been brought pursuant to any particular piece of legislation or particular government conduct. By and large, LaRose is an argument alleging that the federal government in Canada has not adhered to its climate targets under the Paris Agreement. Now, this case as well has been brought pursuant to the Charter of Rights, so again, Section 7 and 15, but also pursuant to something that hasn't been brought up today, which is the public trust doctrine, which I know is a part of certain state constitutions in the US. The right to a clean and healthy environment is not per se something that is outlined in Canada's Constitution, but the common law doctrine of the public trust doctrine in the common law has been argued in previous cases. It has implicitly been acknowledged by the Supreme Court of Canada in an environmental case about 20 years ago. So that has also been argued in LaRose. Nonetheless, LaRose, like Mathur, was dismissed by the lower court, by the lower federal court in Canada, and also dismissed by the Federal Court of Appeal. So it hasn't really moved forward on the merits yet. So both of these cases, again, against governments, why I bring them up is like the Urgenda case in the Netherlands that provided legal principles, what we would call horizontal effect, provided human rights principles that then applied in milieu défensif. The success of cases like LaRose and Mathur can have potential implications for corporate climate litigation in Canada using human rights principles, using what we call in Canada charter values. The values that come out of human rights law can potentially have some currency in claims against corporations. There have been claims against corporations brought pursuant to environmental harms, similar to the US, the UK, and other jurisdictions. We had claims against car manufacturers. We had the Dieselgate scandal in Canada, just like you did in other jurisdictions as well. We've had claims against deforestation companies. The claim I mentioned about that involved the public trust doctrine concerned a deforestation a dispute around deforestation. We've had other environmental claims, both within courts, but also in tribunals against corporations, but we have not had, as I mentioned, per se, a climate-related claim like you have in Urgenda and in other jurisdictions where the claim is writ large that corporations, one or more corporations, have not done enough to mitigate their climate impacts. Okay, so I mentioned this about Mathur. I'm gonna skip over this to get into what I see as the opportunities, similar to what Gerrard talked about. The opportunities really come out of the various causes of action, both statutory and the common law causes of action that exist or can potentially be argued in Canada through an expansion of current, whether it's tort law principles, whether it's equitable principles like unjust enrichment. Where I will start, though, is something that arguably is unique to Canada. In the US, you've had, for a number of years and decades, you've had alien tort statute litigation, not necessarily in the climate context, but in the human rights context, which has largely been dismissed and negated through various Supreme Court decisions. And the argument is that customary international law can actually form a tort claim that can apply to corporations now in Kiobel and in Jesner, in Nestle. This has been dismissed by the US Supreme Court. We did have a case in Canada, though, Nefson Resources Limited and Araya, that in theory allowed for this kind of claim, this kind of argument to be pursued against corporations. The idea that customary international law, particularly international human rights law, provides fodder for tort claims against corporation was implicitly allowed by the Supreme Court of Canada. Now, I will say that, you know, in the 5 years that since Nefson has been decided, it was decided by the Supreme Court in 2020, there has not been a lot of uptake when we look at whether it's human rights litigation or even climate litigation. There hasn't been any uptake yet on using the theory that was implicitly allowed by the Supreme Court in Nefson and applying it to human rights or environmental claims. But nonetheless, the theory is there to be potentially used in corporate climate litigation. So that is something that is somewhat unique. That I do not believe there's been a Nefson-like decision in other jurisdictions around the world. The other opportunities I see, as Gerrard mentioned as well, really lie in traditional causes of action in tort law, whether it's trespass. Now, trespass does not require, in the common law, trespass does not require harm, but with that, the damages awards that have resulted from trespass claims, whether against corporations, whether due to environmental harms, have been relatively, in Canada at least, have resulted in lesser quantum of damages than other causes of action. Other than trespass, the main, and I'll get into public and private nuisance in a moment, but one of the other main causes of action lies in negligence. Negligence law works similarly to the state law of negligence in the US, but also in other common law jurisdiction. It's developed in much the same way. There are certain idiosyncrasies, obviously, to the Canadian story of negligence, but ideas around the duty to warn, negligent misrepresentation, and also just general negligence claims are similar in Canada as they are to other jurisdictions, and therefore the barriers that result around these types of claims are similar as well. I'll get into some of those when we look at ideas of causation or standing. But one that I'll mention here is establishing proximity, this direct connection that is required under Canadian doctrine between the alleged tortfeasor and the victims. That is something that is difficult given the attenuated nature of greenhouse gas emissions, and connecting that to particular plaintiffs can be difficult in a negligence claim. Let's go back. They're again not necessarily in the climate context, because these kind of claims have not been brought yet, but in environmental claims there is some precedent that can be relied on. I have the Burgess decision up there, but all in all, there are minimal legal principles out there. So this is somewhat of a risk part, and that might be in part why we haven't seen corporate climate cases in Canada, because these are risky cases to bring. Distinct from the US, we do have a loser pays system when it comes to costs in Canada, so there is more risk involved. We also have third-party litigation funding. We have some government funding when it comes to covering costs for civil litigation. But these are risky cases to bring, and the doctrine remains ambiguous and has not been tested yet. So that might inform in part why these cases have not been brought in Canada to date. Nonetheless, we do have, both on the negligence side of things, but also on the intentional torts, we have ideas of fraud and fraudulent misrepresentation. We have torts that have to do with conversion and assault and battery, all of which contain principles that could potentially be used in corporate climate litigation. But like I said, these causes of action were not traditionally formed for the widespread and attenuated nature of corporate climate impact. So there are a number of risks, doctrinal risks at least, in terms of trying to fit in these traditional causes of action into the novel fact pattern that climate change presents. I mentioned public nuisance. Public nuisance, when it comes to mass harms, has been utilized both in the environmental context and otherwise. So it's been defined by Canada's Supreme Court as any activity which unreasonably interferes with the public's interest in questions of health, safety, morality, comfort, or convenience. So the idea of substantially interfering with the health and well-being and the safety of Canadians, that definition can, again, in theory, play a role in corporate climate litigation in Canada. So the two basic requirements in the Canadian doctrine is that there has to be a substantial interference with your use and enjoyment of public property, and that interference has to be an unreasonable interference. So it's not, the Canadian case law makes it clear it's not the conduct per se. So for instance, fully legal and reasonable construction projects, because courts have determined them to result in unreasonable interference with people's businesses, with people's reasonable enjoyment of public property, those types of cases have been successful on public nuisance grounds. So again, it's not the activity per se, it's the interference the activity has with people's daily lives. So public nuisance can, again, in theory, form a part of corporate climate cases. Similarly, private nuisance, relies on similar principles, but it has to do with the use and enjoyment of one's own land. So we have ideas around toxic torts in Canada, similar to other common law jurisdictions. Okay, I won't stay on this for too long, but in the literature around corporate climate litigation and climate change litigation, there's this idea of stealth litigation using these niche areas of law, whether it's consumer protection laws or planning and permitting laws, to go after one particular act or conduct or project. But in doing so, you can have these ripple effects on how corporations make decisions that will ultimately have an impact on the climate. So we have this idea as well in Canada. And again, there hasn't been a great quantity of these cases brought in Canada, but there are certain examples that we can point to. Again, not bringing a case that directly implicates climate impacts, but potentially implicates a potential project or an act or course of conduct that can have ripple effects on climate change. And then lastly, I mentioned the public trust doctrine that's been brought up in LaRose. The public trust doctrine can, in theory, also be used by governments to bring claims against corporations. This is what the Supreme Court, again, implicitly, not directly because it wasn't a case about climate change, but the Supreme Court of Canada implicitly endorsed this kind of approach. So the idea that whether it's provincial or federal governments bringing claims against fossil fuel companies, against companies in the extractive sector, this has been utilized, I will say, and is being currently utilized in other areas of litigation, whether it's opioids litigation, tobacco litigation, and we also have novel litigation against social media companies in Canada. So not per se the public trust doctrine that is limited to the protection of natural resources, but the idea that governments in their parents patriae standing can bring claims against corporations on behalf of the public. So again, that approach and that theory could be used in corporate climate litigation in Canada. I'll just say this quickly. We don't have a federal securities regulator in Canada, but the idea of having more expansive disclosure laws and that being used in whether it's negligence or public trust or customary international law claims is an approach that can be taken. And lastly, using the theory that was brought up in Client Earth in the UK, not going after the corporate person per se, but going after the directors and officers of a corporations for the decisions that they've made that ultimately have climate impacts. Okay. The challenges, the doctrinal challenges, again, are going to be similar as we see in other common law jurisdictions. The first relates to standing. Who can actually bring these claims? This was an argument that was brought up in the youth-led claim against governments. I know it's been brought up in Juliana and the atmospheric trust litigation in the US and also in other parts of the world as well. Who has standing to bring these claims against corporations, especially when corporate climate impacts, greenhouse gas emissions really affect everybody, not necessarily in the exact same way, but there is this global effect felt by the entire population. We do have notions of public interest standing in Canada, where an organization or a particular plaintiff can stand in place of a group of people, represent their rights and arguments before a court. There is a three-part test the Supreme Court of Canada has laid out that has to be fulfilled. And really, the way the case law has shaken out is that it's the third prong there, convincing a court that there's no other reasonable and effective way to bring the case before courts, that you do need a litigant that has public interest standing, that is standing in the place of a group of people. That's really been the tension in public interest standing. All of this said, standing doesn't appear to be the major issue in the Canadian doctrine when it comes to climate change litigation in general, but putative corporate climate litigation as well. I think standing is something that can be overcome, given that we do have expansive notions of standing in Canada. Statutory defenses. I know this this arose in the recent Supreme Court decisions around climate litigation in the US as well. The idea that you can preempt claims because there are statutory defenses, it's rich of plaintiffs to say this is the argument that corporations make. It's rich of plaintiffs to say that corporations should be held accountable for their climate impacts, when that's exactly what they've been incorporated to do, that they are just conducting the business that they have received their charter of incorporation to conduct. So there are statutory defenses, both extractive industry companies, but also companies in other sectors have utilized these arguments, sometimes successfully so. Justiciability, what you would call in the US the public question, or the political question doctrine. The idea that a global impact, a widespread impact on the population is better dealt with by the political branches of government, whether it's through legislation or executive orders, rather than the judiciary, which is meant to hear discrete disputes among particular parties for particular conduct. Just the global nature, the fact that climate change, as I mentioned, affects a large swath, if not the entire population, rather than particular parties, suggests that it's better dealt with, that it's not best dealt with by the courts. This was an argument brought up in the climate litigation against governments in Canada. It was dismissed in Mathor because there was a particular piece of legislative action that was being challenged. It was ultimately successful, as well as other arguments in the LaRose case, because LaRose, as I mentioned, was not brought pursuant to a particular piece of legislation or conduct. It was just saying, in general, Canada's government hasn't done enough. And the court said, well, that's better addressed by the legislative branch of government. So justiciability, likewise, will likely be a barrier when it comes to corporate climate litigation. Okay, I know I just have a minute or two left, so I will wrap up. Causation, when we look at particularly the tort law causes of action, establishing what in Canada we call both factual causation. Did A factually cause B? Courts are able to make what's called an adverse inference, but that is an exception rather than the rule. And then ideas around foreseeability. Is the impact that was felt just too far distant from the actual conduct? You do have to convince courts of both factual and legal causation to make out tort causes of action in particular. And I'll end on that. So again, thank you very much for inviting me and listening to this, and I look forward to your questions. Thank you.
Thank you very much, Hassan. So we just go directly with the next speaker, Professor Daniel de Andrade Moreira, who is an associate professor at the Pontifical Catholic University of Rio de Janeiro. And she's also the founder and coordinator of the Law, Environment and Justice in the Anthropocene research group, which you may know as JUMA. A great publication from them, and we use a lot of their materials. So great. Thank you very much for this. And she's also serves as director of the Law for Green Planet Institute and academic coordinator of the Association of Environmental Law Professors of Brazil. And she's now part of our project as the National Rapporteur for Brazil in the Toolbox project. So thank you very much, Dani, for being with us, and the floor is yours. Thank you again.
Thank you, Ivana. Thank you. Good morning to all of you. I'm very happy to be here to join you in this conference. I'd like to thank Ivana and Michael for the invitation. It's also a great pleasure to share this session with Gerrard and Hassan, and to have the opportunity to bring some ideas and some information about corporate climate litigation in Brazil. So Ivana said that I coordinate a research group called JUMA, is the nickname, it's JUMA, and we are responsible for developing and maintaining the Brazilian climate litigation platform. It's a database that gathers information about climate litigation cases in Brazil, and we are happy that we have the opportunity to feed the Sabin Center's platform with Brazil, with information about Brazilian cases. And I'll share my slide. They already here. I have 15 minutes. This is the roadmap. I'll start with a quick overview about how Brazil fits within the world climate litigation scenario. And then I'll talk a little bit about the climate litigation, Brazilian climate litigation profile, but focusing on, of course, on corporate climate litigation. And when focusing on the main trades and of this specific type of cases. And to finish, I'll bring some ideas and about the key trends and emerging patterns for the development of this topic in Brazil. So we have seen a few of this number before. We have Brazil, we have like more than 3,000 climate cases reported globally. And although we see that they are concentrated much more in the global north, in the global south, we're seeing a growing number of cases being brought, and Brazil is in the third place now, as the jurisdiction in the global south with the highest number of cases, and also is the third country in the world with the highest number of reported cases. And it's growing. We now have 128 lawsuits cataloged, registered in the platform. We always have a few cases being analyzed. So in a few months, we'll have like more than 130, and we never stop and analyzing new cases. We have launched this platform in August 2022 with 50 cases, and now we have 128 cases cataloged. This is the link to the website, to the platform. As I said before, it is dedicated to gathering information on Brazilian climate litigation cases. We have the goal as an academic, a research group, to not only to disseminate information that enables research and action to fight against social, environmental, and climate injustice in Brazil. And climate justice is a cross-cutting topic for us, but we also want to produce analysis about the profile to see which arguments are being brought or could be brought in the cases. But we do have, as Gerrard said, something about the concept, the different definitions for climate litigation. We have this limitation. We had to limit our scope when we were developing the platform. So we intentionally do not include indirect climate cases. No. Although we, particularly in Brazil, we have the right to a stable environment provided by the as a human right, as a fundamental right provided by our Constitution. And we have a long history of development of environmental law and environmental litigation in general. Many of these cases, they are important also for climate. Deforestation cases, for example, they could be all of them classified as climate cases, although they not expressly mention climate and GHG emissions. But of course, it wouldn't be feasible to build a platform with all the cases, and we would not be able to analyze the specificities and particularities of direct climate cases. So we decided to limit the scope of the platform, and we include cases in have two different approaches, cases in which the climate issues is a central issue or one of the central. This is something that's interesting about Brazil. Sometimes it's not easy. Sometimes we don't find a case that's only about climate. Climate always comes together with other environmental topics. So climate might be one together with others, one of the main issues of the claim. But there are other approach that we found interesting to include, that the climate approach, when climate concerns are brought to the case as we call contextual argument. So it might not be the central issue, but it's something that brings context, and those cases, they have to mention climate change, to mention GHG emissions, one of these expressions. And we found them very important to see how climate is being dealt by the courts and how it's being brought to the analysis by the judicial system. And we developed a methodology to classify the cases, to analyze the cases. And these categories allow us to identify parameters and to develop this analysis on Brazilian climate litigation peculiarities. These are the bulletins and reports we have already published. The bulletins, they bring a more quantitative analysis and an initial qualitative analysis, but we have just one report that brings an in-depth analysis on the cases. It was published in March 2024, when we had 80 cases, and now we have 128 cases. But we have this bulletin published last December, analyzing the 120 cases we had back then in the platform. This is how the platform looks like. We only have it in Portuguese until now, but we are working on developing a translation, automatic translation. So in a few months, we'll have everything in English and in Spanish as well. This is an overview of the timeline. We can see in this graphic that after 2018, 2019, there is an increasing number of cases in climate cases in our judicial system. Those earlier cases, it seems interesting to see the different patterns of those cases. The earlier cases were typical environmental litigation cases in which climate was not mentioned in the claims. Climate appeared in a high Superior Court of Justice decision when dealing with air pollution, with water pollution and forest code, and the tribunal brought the climate issue as an important issue together to be analyzed and to be considered together with other issues, other environmental issues. So we could not let them, and we had to include those cases that brought the climate issue in the final decision sometimes, but they were not brought as climate litigation cases. So there's a difference between those earlier cases and the most recent cases filed, especially after 2018, 2019. Those cases started bringing the climate issue as a central issue, as I mentioned before, or even if as a contextual argument, but with much more in-depth analysis and developing the climate concerns in the complaints and also in the decisions, but they were brought to be climate cases. And it's something it's interesting to note as well, is that climate litigation in Brazil comes together with environmental litigation. It's impossible to segregate those. Although we do need to see the peculiarities and specificities of climate litigation and climate concerns, they bring much more challenges to the environmental litigation, the general environmental litigation, but it's a branch, it's like a subdivision. And our National Council of Justice had already said that climate litigation, we have a resolution about the judiciary political practice on environment. I don't remember exactly the name in English, but climate litigation is a subject of environmental litigation. So it's not something that comes a part of it. This is to have an overview about who is bringing those cases, the types of plaintiffs. We have the Federal Public Prosecution Office as and together with the cases brought by the State Public Prosecution Office, we have the main protagonist of environmental litigation. But in climate litigation, we can see that public administration bodies like our EPA, our Federal Environmental Agency and other federal agencies, together with civil society, with NGOs, they are bringing cases. Although they had already standing since 1981, when our Public Civil Action Act was enacted, we didn't see that before. They didn't have the tools or the capacity of bringing cases. They didn't act that much as litigants, but now they do. So it's something that it's a peculiarity of climate litigation that we didn't have and we didn't see in environmental litigation in general. In terms of types of defendants, and here we can see the companies, we still have the majority of cases brought against the government. I mean the public sector. We have many different types of categories that are encompassed, but what I can say here, a public sector. But we have been seeing a growing number of cases being brought against companies. And sometimes those cases brought, especially cases about on environmental licensing procedures and challenging and saying that there were flaws in the environmental licensing procedures, they are brought against companies, but together with the public sector, together with the environmental agency. So we have like this diverse type of defendants in some corporate cases. And we have been seeing a growing number of cases being brought against individuals. Those are small, not that small, but smaller cases on deforestation against individuals. But then sometimes we have like small companies being sued for that. They are much more individuals than companies. I mean, they are like really, really, really small companies. So sometimes it's not easy in terms of, especially when we're talking about deforestation cases, to divide cases brought against companies and against individuals. They are almost the same arguments and the same everything. In terms of the types of actions, we can see here that we have 90 cases that use the public civil action. That's the procedural tool we have in Brazil since 1981. But if we sum up the set of constitutional judicial review actions, we have 21 cases. Those constitutional cases are brought directly before the Supreme Court, and most of them, not all of them, but most of them are cases that were brought during Bolsonaro government to try to refrain to challenging the setbacks that we were seeing back then. We have I'm not going to show you all the categories. We have just a few of them. We have this classification. We divide the cases. The case can be either systemic or routine. Systemic cases are those cases that seek adjustments, structural adjustments and changes in public policy or private policy. So we have those cases against setbacks, are most of them systemic cases. And we have the routine cases, the cases that deal with a specific project or activity. They are more like routine litigation, but they are very important. I mean, they can be used after, when you have many routine cases, they can be replicated to and change a way of modus operandi, a way of working of a specific sector. For example, those cases about climate damage, cases about environmental licensing as well, they can be replicated and they can produce a change, induce a change in the whole sector. So they are, although they are not sexy cases, they have this potential to be replicated. We have, in the systemic cases, we have it's a set of cases with a more not that diverse, a more, we can understand the profile easily. Cases they usually are fighting setbacks, the use of constitutional arguments and constitutional actions. We have, for example, that's a number that stands out. We have 43 systemic cases, and 32 of them were filed between 2019 and 2022, the years of Bolsonaro government. So this is peculiar. And we have routine cases. Most corporate cases are routine cases. In those cases, they deal with a variety of issues. It's not easy to find a specific profile of these cases. They can deal with different kinds of issues, but we can see a few of recurrent issues bringing in these routine cases, and two of them are civil liability for climate environmental damage and environmental licensing as well, and cases brought mostly against companies. In terms of greenhouse gases emissions, the sector which are being challenged in the judicial system, we have land use change and forest as the main sector, and this is something that we can understand, considering the profile, the GHG emissions profile of Brazil. In Brazil, we have around 48% of our emissions are from land use change, and around 28% from agriculture and cattle raising. So, of course, we would have this profile cases challenging land use change and forest, but we are seeing a growing number of cases being brought, cases that deal with the energy sector, especially cases about environmental licensing procedures, and also industrial processes. And in terms of the measures addressed in the cases, mitigation is the measure most addressed, but we are seeing, again, a growing number of cases about in which the measure addressed is related to civil liability for climate harm, and also climate risk analysis. So every category, every niche classification we have brings us to civil liability for environmental damage and to environmental licensing procedures. This is how our report looks like. I am not the author of this report. Kai Borges developed the report. I have just helped with me and the other co-rapporteur, Carolina Garrido. She's a researcher in Juma research group. We have just helped with the executive summary. And I'm very, very happy to join the team. We can see, so some information that I will bring in the second part of the presentation. We can see you find in the report, and there are something new findings that's interesting to see them. We have a growing number of corporate climate litigation in Brazil. Now we have 35 active cases targeting companies. And those companies, which companies? Companies that are involved in deforestation and other high emission activities, especially in the energy sector, especially coal-fired plants and coal mining. These cases, this is something important. it's one of the main takeaways. The cases draw upon established legal avenues. For more than 40 years of environmental law, development, environmental litigation, we are using the same tools that we already had. Just we're bringing the climate issue to see it through another lens, like to see the specificities of the climate issue. And most cases are brought by the Public Prosecution Office and also civil society. That's something particular for us, new for us. We have among the defendants, timber, energy, and mining companies accused of promoting or contributing. We have a broad notion of polluter that includes indirect polluters in Brazil. So they might only contribute to deforestation, and also companies being accused of non-compliance with environmental litigation, regulations, flaws in environmental licensing process, for example. And the vast majority of those cases brought against companies are routine cases. So they focus on a specific project or a specific activity. And as I said, we replicate strategies and arguments that were already being employed in general environmental litigation. So to see the most recurrent topics in climate litigation against private sector. And here I include individuals, especially in cases about 2 minutes.
2 minutes.
Environmental civil liability and environmental licensing. I'll skip this and go straight to the civil liability. So we have 53 lawsuits based on civil liability. We have, I won't have the time here, but we have peculiar traits in our environmental civil liability in Brazil. They are peculiar, they are different from, we have strict liability, we have absolute risk liability, we have another way of seeing the causation with much more flexibility. We have the direct and indirect polluter, but I won't have time to talk about that today. But we also have this preventive function of the civil liability. Civil liability arguing for measures to be addressed for preventing future harms. So we have this view to the future and view to the past. We have, and I have to condense here, not to keep on going about the traits, but we have those restorative and preventive dimensions in civil liability, and those dimensions are being brought in those cases, deforestation cases. And we also have what we call a multifaceted nature of environmental damage. So environmental damage in Brazil has many dimensions, and climate dimension, climate is one of the dimensions of environmental damage, and that's the way we are dealing with climate damage in Brazil right now. We have cases, in some cases, the climate dimension of the environmental damage is developed more in a more deep way. In other cases, environmental damage is, they don't say much when they are asking for the compensation for the environmental damage, but they do demonstrate the damage also considering the GHG emissions, for example. We have, among this 53 cases, we have 39 cases that explicitly develop the climate damage argument. We have been seeing different methodologies for valuing this climate dimension of environmental damage. The main issue being brought to the courts is deforestation. It's the most questioned pollution activities. We have one case that it's a new case. It's interesting, that challenges environmental licensing of a coal-fired power plant, and they are arguing, they are using both ways, both cause of actions, environmental licensing regulations. The licensing of the power plant was not, well, has many flaws, and because of that, the emissions, the GHG emissions, were not considered, and they became a harm, a climate harm. So they have to be repaired using all that we have in terms of civil liability for environmental harm. And something interesting as well these lawsuits, especially suits about deforestation, they can be brought against deforestators themselves, like direct polluters, but also those responsible for other activities in the deforestation chain, indirect polluters. So those who keep in deposit, for example, timber from illegal deforestation, they are responsible together, joint and severally with the direct polluter. And many of these cases are against those that have timber in deposit. And I'm finishing just to just a few words about licensing. We have 16 lawsuits that address directly environmental licensing with the climate issue as a cause of action or a claim. We have been seeing these cases, particularly in the south of Brazil, the state of Rio Grande do Sul and a case in Paraná. They deal with the energy sector of emissions of TNT, and they are related to projects related to fossil fuels, coal extraction or coal-fired power plants. And something interesting we see in those cases, the climate issues being brought together in association with other environmental impacts like air pollution, water issue, participation of affected populations, consultation with indigenous peoples, etc. And that's, I swear that's the last one. Perspectives. We have been seeing already, and I think we'll keep on this trend for the next, at least until the end of next year. The reduction of systemic cases brought against the federal government. We had many of these type of cases during between 2019 and 2022, and then there's a reduction. We have been seeing an increasing litigation against the private sector in general, increasing number of cases related to environmental licensing and civil liability for climate environmental damage. We don't have yet, but I think we're going to see them cases that are related to climate disasters. I mean, civil liability for climate environmental damage related to climate disasters. We call like indirect climate damage. And we can also say that's just to finish, to wrap up, in terms of how the profile of corporate climate litigation in Brazil, a consolidation of the strategic use of foundational and long-standing environmental law in corporate climate litigation. So we have climate litigation in Brazil, and also corporate climate litigation in Brazil builds upon over 4 decades of environmental law development and litigation practice. We use the same foundational legal principles and long-standing procedural tools to serve as a legal toolkit for corporate climate litigation. I've seen that these instruments are being reinterpreted and applied in light of the specificities of climate change. Sorry, I was like running out of time, and I know that my English is not that good. I hope I could express myself.
Thank you very
Thank
much,
you.
Dan. It was great, and a wealth of information. And yeah, the Brazilian legal system is really like super interesting for analyzing how what kind of direction we're taking around the world. And it's especially in Brazil, it's really important to consider this as a fundamental key part of the climate governance. So no, it was absolutely sorry that we didn't allocate more time for that, but as Danny said, there is a national reports there. You can go and also see the work that she and her colleagues at Juma have done, and really it worth the reading. So I would say, without further ado, if you have any questions, so we open the floor to the audience. If you have any question about this, because we know that we are a little bit late, but yeah, if you have any question before taking just a little break. So do you have any question for our speakers? I think that this was, yeah.
Yeah, so Danny, thank you so much for the presentation. One of the things that you mentioned was that the cases brought by civil society are newer in Brazil. Could you talk about that a little bit more, about what those cases are and maybe how they sit in the context of what you're seeing in some other countries as well?
Sure. As I said, civil society already had standing for bringing those cases since the 1981. based on the Public Civil Action Act. But in terms of environmental litigation as a whole in general, we didn't see NGOs as protagonists in bringing those cases. They didn't have the capacity installed to follow a case from the beginning to building a case from the beginning to the end. But we have been seeing a strengthening process of civil society also in Brazil for climate issues in terms of climate, not only climate litigation, but for climate action, I would say. So I think we have this specificity. NGOs in Brazil that work with climate, they have the capacity of bringing those cases. They are, for example, helping public parties to bring cases. So part of the cases that we see here, I don't have the numbers in here in my head, but are brought by public parties. These systemic cases against that are brought directly in the Supreme Court. Those public parties, they are there officially, but NGOs worked to help building those cases. So the numbers are even higher. And in terms of corporate climate litigation, cases that those set of cases about environmental licensing processes, they are much more brought by NGO. There's much more than the public prosecution office, for example. So we see that this pattern, deforestation cases are being brought much more by the public prosecution office, and environmental licensing disputes being brought by much more, not only, of course, but much more by civil society.
Any other questions? Yeah, please.
Yeah, my question is also to Danny. So I found it really fascinating that that Brazil is ranked 3rd in the world for climate change litigation. So the US, not surprised, right? Very litigious state. Australia, very, very active group of environmental scholars. What's special about Brazil, and are there lessons that the rest of us can learn from?
Actually, I'll be honest with you. I don't think, I think we have because of, we are working to find those cases. So we have the capacity of reporting those cases. I think that's one reason. Many other countries, they don't have a platform for their cases. They don't have groups studying and with this purpose. This is a simple answer, but I think that means a lot. Gerrard said something about the capacity of reporting. I don't remember exactly.
Data collection.
The data collection. They might be underestimated.
Yeah.
And in Brazil, we are working, we have like 6 people just trying to find those cases. This, of course, this is not the only answer, but this is one factor, the capacity of finding cases and analyzing those cases. But we also have this, as I said before, 40 years of development of environmental litigation in general. So I usually say that what we use the environmental litigation like as a shortcut for climate litigation, because we already have those legal avenues paved for climate litigation. So we have these opportunities. That's why another reason. One is more simple reason, but this one I think it's more consistent. Where we have a fertile ground. I use this expression. I don't know if it's a good expression in English, but a fertile ground for climate litigation. And this ground is being fertilized because it's fertile. Yeah. So that's something in terms of the foundations we need to bring those cases.
Yeah, and so this will help us also cross-fertilize other jurisdictions. Yeah, please.
So how successful have these cases been, and is the difference between the public prosecutors, the NGOs, the winning war, or the combination? And you talk about where they're working together.
Actually, it's not easy now to talk about. We have just a few cases concluded, but we do have a extensive case law on environmental legislation based on civil liability and environmental licensing, those most recurrent topics in climate litigation as well, that says to us that we might be successful in those type of cases. But what I mean, I know I'm not answering exactly what you asked, but going to your question, I don't think there's a big difference between, or different chances of winning in cases brought by the civil society and the public prosecutors. I think it depends on the arguments, on how solid and how already tested are those arguments. And we have in both current types of cases, solid case law that can be, so I think the difference won't be who is bringing the case. I don't know if my friend Gabriel, the federal judge, is going to talk after in the afternoon. I don't know if he agrees with me, but you can.
With you.
Another question, please.
I was about cases that involve greenwashing in Canada, the US, and Brazil. Is that a fertile ground? I understand there have been some wins in Canada, although not mentioned. But I know that there have been cases even about greenwashing for corporations that are Brazilian corporations in the US. So I'm just interested, is that an area where are you seeing successes? Are there differences in the different jurisdictions? That's one question. And then I just have a second question around methane. I know maybe there are issues with how what is a climate litigation case or not when it comes to agriculture, etc. But are there cases that look at methane as a gas in any of the jurisdictions?
I'm happy to address the greenwashing in Canada. So I'm speaking about this tomorrow morning. So do try to attend that panel if you're able to. In terms of successes, I wouldn't really say there have been any kind of major successes. And then the other part of this is these are not necessarily court cases, but we do have tribunals who do have jurisdiction to consider these kind of claims. So we have claims that have been brought in, for instance, the competition tribunal, pursuant to claims made by banks, for instance, or insurance companies. But I can't really think of any major success when it comes to the courts in looking at these claims. There have been some attempts to bring claims against airline companies for their assertions around being net zero. But again, there's been nothing brought in the courts so far. So, all in all, this ties to what I was mentioning in my presentation. When it comes to the corporate side of things, Canada has been, as compared to Brazil or the US or the Netherlands, more conservative in this regard in terms of using the laws that are already there to bring corporate climate cases. And I think greenwashing is very similar. There's potential theories out there, but nothing's really been brought to the courts.
I just add briefly for the US perspective, something very similar, right? I know there was a DC case that was brought against Coca-Cola that was eventually dismissed because the court found that Coca-Cola's claims weren't sort of binding promises. They were just aspirational claims. There is an ongoing lawsuit right now, a class action suit against Evian for claims about their carbon neutrality. And so sort of we'll see how that one plays out. But I similarly can't think of sort of any big high profile greenwashing cases where the plaintiffs were successful in the US.
I would say the same in Brazil. I don't think we have a case about greenwashing yet. I might be wrong because when we launched the platform, I knew all the 50 cases, but now we have 128. I don't know. But actually, not remembering of a case about greenwashing, I think I would know. But we don't have it. Although we have a consumer law that's also developed and can be mobilized for together with environmental regulations, but we still don't have any case. Do you know, Gabriel, if we have? No.
And actually, this is the kind of cases that around the world are, skyrocketing. So in the last years, greenwashing cases are really multiplying everywhere in the world. And we had also some interesting decision, like as usual in the Netherlands with the KLM case. So I think this would be also something potentially interesting. But as we said, in each legal system, it's quite different. So it depends also on how we are approaching them through consumer law, could be also something else, could be also something related to fraud claims, be something also related to tort sometimes. So this is also something that is interesting about this toolbox, and the kind of research you can do about it is the fact that you can really take stock of what the legal system itself can provide and trying to, let's say, create a sort of bricolage, and so learn something from other experience and trying to bring your own legal system. So maybe we will have something also, positive in the Americas. And I didn't say, but you will see this is just the first panel, and in the next ones you will see other experts from Brazil, from Canada, from the US, and also from other countries, from Peru, Chile, Mexico, which are the new countries that we're adding to the toolbox. So this is just to say that probably we can also close here because we are already very far behind. But thank you very much for your questions, and see you in 15 minutes. Yeah. Thank you very much, everyone.
It's my great pleasure to moderate this panel. I will keep introductions very short. I got the green light from the three amazing speakers, but I really want to give them time to give their presentations, but very importantly, time to you in the room to engage in an active discussion with our three speakers. So we're going to start in the order of the program. We are really delighted to have also from Brazil, but from another side of the spectrum, not the civil society or organizations like we saw before, but a judge, Gabriel Vedi, federal judge at Rio Grande do Sul. He will be followed by Barnali Chuduri. She's a professor of law at Osgood Hall Law School at York University in Canada. And we'll be finished by our host, in a way, by Christine Perry, who is a staff attorney at the Environmental Law Institute. So without further ado, I give the floor to Gabriel.
Dear Professor Francesco, Professor Barnali, Professor Christine, I'm a federal judge and professor of climate and environmental law at Unicinos University in Brazil. It's an immense honor to be here at the Environmental Law Institute to address a topic that has involved my research for almost 12 years. Thank you very much, Professor and friend Ivano Alone, for inviting me. In 2023, I wrote with two dear colleagues the first handbook on climate law in Brazil in Portuguese, which was published by Thomson Reuters. Several of my friends, professors, and judges complained that it lacked something in English. Yes, as a result, together with my colleague, federal judge Rafael Moreira, I wrote with Rafael the first handbook on environmental law and climate law in Brazil, written in English, which was published 2 months ago by Springer. We wrote in these books that it's not very complicated to understand environmental and climate law in Brazil, like Daniele told before me, because our own constitution, as interpreted by our Supreme Court, recognizes a clean and balanced environment as a fundamental constitutional right to be preserved in the interests of present and future generations under the terms of Article 225. We also have Act 1287, passed by Congress in 2009, which establishes the national climate policy and enshrines important legal principles in our legal system, such as the precautionary principle, the principle of prevention, and the principle of ecologically sustainable development. I'm, as the former president of Association of Federal Judges of Brazil at the time, 2009, 2010, I closely followed these debates inside of the Congress. I often reiterate to our judges in the commissions in which I participate, in which I have participated in the National Judicial Council, the Federal Judicial Council, and the Brazilian Federal and State Judicial Schools, that our constitutional legal framework is rich and sufficient for judges to decide the climate case well, although it is clear that a broad knowledge of theory of civil procedure and collective actions is necessary. The operator of the law, whether judge or lawyer, must have a profound knowledge of jurisdiction and competence and authority, as the late Justice of the Supreme Court of Justice, Superior Court of Justice, and author of historical book, Atos Guzmão Carneiro, used to say in the past. With these initial considerations, the Brazilian Supreme Court has progressively narrowed the scope of administrative discretion, imposing substantive constraints on the interests of present generations in favor of safeguarding the rights of future generations, particularly in ensuring the preservation of a healthy and intact climate system. Such cases on the protection of two of Brazil's most vital biomes, the Amazon and the Pantanal, the judicial focus was bound to happen given the land use change, primarily deforestation and wildfires, constitute the leading source of greenhouse gas emissions in Brazil. Beyond their role in exacerbation pollution, this destructive activity severely compromise the ability of native vegetation to function as carbon sinks, a function essential to mitigating climate change. In the case concerning the Amazon found, the Supreme Court even mentioning a doctrinal paper of my own, identified a regulatory omission in the state's fulfillment of its constitutional duty to protect the Amazon, ruling that the paralysis of the fund constituted an unjustifiable environmental setback. Consequently, the court ordered the reactivation of the fund's governance mechanisms, condemning the dismantling of environmental policies that had previously been in place. The court held that the government's failure to implement adequate public policies for the protection of the Amazon, coupled with the institutional dismantling of existing environmental programs, amounted to a normative omission in violation of Article 225, paragraph 4 of the 1988 Constitution. The judgment explicitly recognized that the suspension of the Amazon Fund's operations in 2009 and 2020 are a result of unilateral executive action which dissolved the fund's governance bodies, led to the interruption of international donations. This governmental inaction, the court emphasized, undermined Brazil's supralegal international commitments and had tangible devastating consequences for the legal Amazon, as evidenced by the escalating rates of deforestation during the period of inaction. Consequently, the current state of affairs in the legal Amazon fails to fulfill Brazil's domestic legal obligations as established by law, by Act 1287, which instituted the national policy on climate change. Moreover, it contravenes Brazil's international commitments to fight deforestation and climate change, as set forth in the 1992 United Nations Framework Convention on Climate Change, the Kyoto Protocol, and the Paris Agreement. By failing to effectively enforce environmental protections in the legal Amazon, the state has fallen short of both constitutional and international obligations, undermining the legal and institutional framework to curb deforestation, regulate emissions, and promote climate resilience. This regulatory inertia underscores the urgent need for judicial intervention to ensure compliance with binding environmental commitments at both domestic and global levels. In another significant decision, the Supreme Court ruled that while the current state of environmental policy for the protection of the Amazon biome does not yet reach the level of an unconstitutional state of affairs, the court nonetheless identified structural deficiencies requiring urgent governmental action. The ruling acknowledged that process of restoring constitutional compliance is underway, yet it emphasized the need for the federal government to assume meaningful engagement in combating illegal deforestation in the Amazon rainforest. The court further noted that the process of reconstitutionalization of efforts to curb illegal deforestation and fulfill the state's protective environmental duties could be observed through the reactivation of key environmental programs and the reinstatement of prior commitments, particularly those outlined in the action plan for the prevention and control of deforestation in the legal Amazon. Thus, while it acknowledged the persistence of structural flaws in the implementation of public policies by federal government, it refrained from declaring a massive violation of fundamental rights in environmental governance. Instead, the judgment underscored the imperative of continued and enhanced state action to remedy deficiencies in environmental protection, ensuring that the public policies align with constitutional and international commitments to safeguard the Amazon. The instance marked the first explicit recognition by the Brazilian Supreme Court of the fundamental right to a clean, healthy, and safe climate. This judicial acknowledgement reinforces the constitutional justiciability of climate rights, aligning Brazil's legal framework with emerging global jurisprudence on environmental protection. Furthermore, in his opinion, Justice Edson Fachin emphasized the necessity of a new transgenerational constitutional pact, declaring in environmental law, amid the current climate emergency, the imperatives for a new social pact, one that binds present and future generations. This statement underscores the intergenerational dimension of constitutional environmental protection, reaffirming the state's obligation to safeguard climate stability for those yet to come. Additionally, Justice Carmen Lúcia, in her concurrent opinion, highlighted the multi-level nature of contemporary environmental and climate governance, recognizing that climate regulation operates across different legal spheres, national, regional, and international, requiring an integrated and cooperative approach. In a similar pronouncement concerning the Amazon and the Pantanal, the Supreme Court determined that while the current state of environmental protection policies for these biomes does not constitute an unconstitutional state of affairs, it nonetheless identified critical shortcomings that necessitate immediate governmental action. To address these deficiencies, the court mandated the adoption of specific measures, including: one, the federal government must, within 90 days, develop a publicly disclose a comprehensive plan for preventing and combating wildfires in both Pantanal and the Amazon. Second, federal and state environmental agencies must ensure transparency by publishing all authorizations for vegetation suppression. Three, the National Council of Justice must monitor judicial proceedings that have a major impact on deforestation, reinforcing judicial oversight in environmental matters. In a final case, specifically concerning the Pantanal biome, the Supreme Court recognized a legislative omission in the regulation of its protection, and as a corrective measure, ordered the National Congress to enact a law within 18 months to establish the necessary legal framework for safeguarding this critical ecosystem by issuing this directive. The court reinforced the binding nature of the constitutional duty to protect the Pantanal biome, ensuring that the absence of specific legislative action does not result in regulatory paralysis or continued environmental degradation. This and other decisions exemplify the judiciary's resolute commitment, particularly that of Brazilian Supreme Court, to the preservation of Brazil's most critical ecosystem, the Amazon and the Pantanal, for the benefit of future generations. Through these decisions,
We have an interesting AI.
through these decisions, the court has reinforced the constitutional duty of environmental protection, ensuring the government accountability and affirmed the justiciability of climate rights. By doing so, the court has positioned itself as a key arbiter of intergenerational justice, contributing not only to the strengthening of Brazil's environmental governance, but also to global jurisprudence discourse on climate and biodiversity protection as fundamental rights. Thank you very much.
Thank you very much, Gabriel, and also for dealing very staunchly with the interruptions. We all heard some beautiful Brazilian, but not many of you understood it. But... So moving to our second speaker, I'll give the floor now to Bernardi Chuduri, and the floor is yours.
All right, so thank you very much to Ivano and Michael for having me here today. I'm really going to be talking about the human rights impacts of climate change and talking about how they can form the basis of corporate climate change litigation, mostly because I'm a human rights lawyer, but I'm also a corporate lawyer, so you're going to get some corporate stuff as well. So let's start first by talking about what are human rights-based arguments in the area of corporate climate change. So this is really litigation that's based on violations of international human rights law. And there are a number of international human rights documents that would be relevant to this kind of litigation. We really draw from the International Bill of Human Rights that includes things like the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, as well as the ILO core conventions that are found in the Declaration on the Fundamental Principles and Rights at Work. And the rights that I would say that are most relevant that stem from these documents would be things like the right to life, food, health, adequate standard of living, water or sanitation rights, housing, and security of person. I think all of those things would nicely encompass the things that happen, unfortunately, from climate change. There can also be some specific rights as well. So we would see things like indigenous rights, or maybe the rights of children or the rights of women that could also be implicated in these kinds of issues. But I think really the most important right that would form the basis of these kinds of arguments would be the right to a healthy environment. And I'll talk about that a little bit more as we go on. Just as a reminder, there is a business role for human rights in climate change. So we know that the United Nations Guiding Principles on Business and Human Rights applies not only to human rights, but that it also applies to the impacts of climate change. And so specifically, businesses are expected not to harm human rights, and they are expected to engage in human rights due diligence, meaning that they should take proactive steps to identify, prevent, mitigate, and address the adverse impacts of their business activities. And that now includes the impacts that arise from climate change. And the important thing to note here is that these responsibilities for businesses exist even if the state itself does not impose a domestic climate change obligation. So it's basically against this background that I'm going to discuss the human rights impacts or human rights-based claims that can arise in climate change litigation. I was asked to only talk about Canada, so I am keeping it to that category. And the first one that I'd really want to talk about is this idea of customary international law. Now, I do have to give you sort of a caveat here, which is that these are potential claims that could happen. So as Hassan mentioned, there hasn't actually been any climate change litigation against corporations in Canada, but we suspect that these are the bases that could form new types of litigation. So really, I'm drawing from a Supreme Court decision from 2020 called Nevson and Araya. In this case, there were 3 Eritrean workers who brought a civil claim in the courts of British Columbia against a British Columbian-based corporation called Nevson Resources. Now, Nevson owned this mine in Eritrea, and unfortunately, the claims worked at this mine, and they were subject to pretty horrific treatment. And so they made a claim in the Canadian courts that there were breaches of customary international law, including the use of forced labor, torture, slavery, cruel, inhumane, or degrading treatment, and crimes against humanity. Now, Nevson, the company, brought a motion to strike this claim. So, and it is this claim that made it up to the Supreme Court of Canada. So I don't even have any real substance to give to you, except to say that the Canadian courts decided that they were not going to strike the motion. And instead, what they said is that because of something called the doctrine of adoption, which is that really that customary international law and other types of international law have been incorporated into the domestic legal system of Canada. Therefore, they found that customary international law applied to corporations. And so they also said that this would lead to a new tort, which they call the tort of the breach of customary international law. And then they said it wasn't really obvious that a corporation could not be a party to this type of tort. And so really what they did was they sent it back to trial to have the trial court really look to see whether or not there had been a breach of customary international law. But I have no more law on this to give to you because, of course, the parties settled out of court. Anyway, so that's where we're at. So what does that mean in terms of the climate change litigation? So if I draw from Nevson, I would say that we could ground climate change litigation, at least in Canada, in violations of customary international law. Now, you know probably already that customary international law involves both state practice as well as opinio juris, that is the sense that there has been, from these state practice, that there is a legal obligation to comply with the custom in question. And if you recall from the earlier slide, there are a number of human rights that have been implicated in climate change litigation, and several of these human rights could easily constitute customary international law. So of these, I would say that the right to health is probably going to be the strongest one. I don't think that there would be too much discussion that this is not customary international law. We see it in lots of different treaties. It's found in the World Health Organization. It's in lots of different international human rights and domestic treaties as well. We could also probably say the right to life would easily not be contested as customary international law, again, found in the International Bill of Rights, lots of different international treaties, and in domestic law. I think some of the other rights could be a little bit contentious. So first of all, I would say that the right to water or the right to housing could be a little bit contentious in the sense that that's not necessarily widely accepted throughout the world. Where I think is a more interesting argument is the right to a healthy environment. So I think if that formed the basis of customary international law, then we could easily bring a lot of different human rights-based claims based on that. And I think this is the definition of the right to a healthy environment. So it's the right to clean air, safe climate, safe and sufficient water, healthy, sustainable food, non-toxic environments for living, working, studying, and playing, and healthy biodiversity and ecosystem. So it really does encompass a lot of the impacts of climate change. Small question though, does the right to a healthy environment, does it amount to customary international law? So if I want to make this argument, then I'm going to have to do this. So we've already heard from several different commentators earlier this morning that the right to a healthy environment is found in lots of countries' constitutions. It has also been found in lots of state charter, trade constitutions, right? That's what I learned this morning. So that's a good sign. And we also, I'm sure many of you know, that there is an advisory opinion gone to the International Court of Justice, who may be making a declaration any day today, whether or not this is going to be a state customary international law. So the small caveat that I have that this is not going to be is that at that decision, there were 10 countries, including Australia, Canada, China, Germany, Kuwait, Saudi Arabia, New Zealand, Serbia, the UK, and the US that all fought this idea that this is not customary international law, or that there isn't really a recognition of the right to a healthy environment. And as you know, one of the things that prohibits customary international law from forming or saying that it doesn't apply to you is if a state makes a formal declaration rejecting that approach. So I do have a little bit of concern that these countries' position at the ICJ case suggests that maybe that they are going to reject this. Okay, so that sounds like a great idea. Anyways, if we get customary international law, we at least have like the right to, I think the right to life and the right to health, that will give us enough customary international law. But I just want to point out two shortcomings. So the first is the problem of forum nonconvenience. So the Nevson case, where I told you that formed the basis of this customary international law argument, that was a case that occurred where there was a company operating in Eritrea, and it was the Canadian courts that were in charge of deciding whether or not there had been breaches of customary international law. In that case, the forum nonconvenience argument, that the idea that there is a better jurisdiction that could take care of this issue, that was addressed easily in that case because it was found that Eritrea's judicial system was not well recognized as providing an appropriate rule of law. But there's been a subsequent case in Canada called John and Barrick Gold, in which they made the exact same argument. They wanted to hold Barrick Gold, which is a large gold company, mining company in Canada. They wanted to hold them responsible for human rights violations that had occurred in Tanzania. And in that case, the court dismissed the claim on the basis of forum nonconvenience because they said Tanzania had an appropriate legal system. So I think forum nonconvenience could be a problem here. The second problem is that I'm not really sure that if the Nevson case had actually proceeded to trial, that actually liability would have been attributed to the corporation. And that's because if you look at sort of like who actually committed the harms in this particular case, it wasn't actually Nevson. So I tried to do like a really quick state of us, who's doing what in this particular case, but Nevson owns 60% of the Bisha mine. The Bisha mine is the company that was basically involved in bringing in these individuals against whom these customary international law harms were being committed. But they weren't themselves the ones who had actually brought these individuals in. Actually, they had entered into a contract with a South African corporation called Senate, who then outsourced that or subcontracted that to two other Eritrean companies called Maghreb and Sagan. And it was Maghreb and Sagan basically acting with Senate, the South African corporation, that had actually brought in these individuals against whom these customary international law harms were committed. So I think that if we had gone to trial, this whole idea of corporate law and separate legal personality and limited liability would have ensured that Nevson actually wasn't responsible. So I think that's something that we need to be wary of and going forward. Okay, and then I also want to just, I still have time, I can talk briefly about human rights generally under Canadian law. So Hassan sort of touched on this, but I'm just going to go into a greater detail. In Canada, we have a constitutional, and we have as part of that constitution something called the Charter of Rights and Freedoms. And in it, it's basically like a Bill of Rights for us. So two of the rights that I think are very relevant for climate change issues are the right to life, which we find in Section 7 of the Charter, and the anti-discrimination provision found in Section 15. So there have been a number of different cases in Canada brought under the Charter. There's just three cases. I'm going to talk about them really, really quickly. So the first one was there was a youth NGO in Quebec that claimed that there had been a violation of their Section 7, that is the right to life, rights, because they said that the government hadn't put in the necessary policies to limit climate change. In that particular case, it was dismissed because the court found that the argument was not justiciable. However, if you fast forward to 2023, we've had two cases called La Rose and Denis Z, both of which they're two separate cases, but they were handled together by the Federal Court of Appeal. And in both cases, the claimants argued that their Section 7 and their Section 15 rights had been violated. And both of them were allowed basically by the court. So what they found was that Section 7 claims are justiciable. So, and in fact, they were very much persuaded by the Adinizi, which is a group of actually indigenous people that had brought this case. And they found that the indigenous people had actually made a really good case showing that their Section 7 rights were being infringed by links or by reference to the Paris Agreement. So the court was really persuaded by that argument. However, they dismissed this claim and sent it back for the parties to reformulate their arguments. The reason being is because neither of these parties had actually specified which specific laws were infringing on their right to life. And so they basically are allowed to replead their claims. So we're just waiting for them to go through. And then finally, the most successful case in Canada so far has been this Mather decision, which was brought by a group of youth that claimed that, and this was brought against the Ontario government. So in Canada, we have different provinces. This is one of the provinces. And they claimed that the government had lowered their greenhouse gas targets by enacting a new piece of legislation called the Cap and Trade Cancellation Act. And they said that this violated their Section 7 and their Section 15 charter rights. And so in this particular case, the court did agree and said that the government had assumed a statutory obligation to combat climate change, and they had a responsibility to ensure that any type of new law that they put in place had to be charter compliant. However, what they were unwilling to do was to actually give a remedy to the claimants. And so what the remedy that the claimants want is that they actually want the government of Ontario to set a target for the reduction of greenhouse gases. And the court actually said that they thought that that was a legitimate target that could be set. They said it would be set in accordance with the science-based target. So as long as it, complied with science, that they were happy to do so. They were just unwilling themselves to do that. So it's been sent back to the lower court for the lower court actually to be able to set this target. However, at the same time, both the Ontario government and actually the claimants in Mather are appealing to the Supreme Court of Canada. And I just texted counsel while I was waiting to say whether or not they've heard. We still don't know if the appeal is going to go forward. All right, so I've got 5 more minutes. So a couple of other things I want to talk about. So I mentioned before, right, that you could have specific rights that come from other international treaties. So in Canada, and specifically, we have it's very important to us to the recognition of the protection of Indigenous peoples. And so it's found, their protection is found in Section 35, and under Section 35 of the Constitution of Canada, effectively, there is a duty to consult. So anytime that the government is going to interfere with the lands of the Indigenous peoples, they are required to consult. And that also brings in the United Nations Declarations on the Rights of Indigenous People, UNDRIP, which you might have heard of. It's been implemented in Canada as a particular act. So there has been a case called, and I'm going to mispronounce it, Watu, in which case the Indigenous peoples of Canada did challenge the government's approval of a Trans Mountain expansion project, which was designed to increase the carrying of crude oil between different parts of Canada. And they challenged this expansion on the grounds the duty to consult had not been adequately respected. And the court agreed in that particular case and said that Canada had first failed to consider the marine impacts in their environmental assessment. And second, that they had failed to fulfill their duty to consult with Indigenous peoples. And so initially the Trans Mountain expansion was not allowed to go ahead, but then Canada followed the recommendations from the court and actually put in the changes that were necessary. That is, they did the proper consultation that the court had advised them to do. And in that case, they eventually allowed this Trans Mountain expansion to go ahead. Okay, so why do we want to talk about this in the context of corporations? So most of the claims that I talked about, particularly with the charter things, those are directed at governments. But I think that we could still say that there are situations in which this would be relevant to corporations, even if we're focusing on constitutional or charter litigation. So the first way that that would work is that if they are actually part of the government, So either by their very nature or due to extensive governmental control, or if they implement a specific government policy or program. In addition, there can be situations if a corporation is a crown corporation, i.e. it's effectively a state-owned corporation that is, it's owned by the government. In that case, we would also say that they are bound to charter and constitutional obligations. And we also know that it could work if the corporation is implementing a government policy. So currently there's a corporation called Saskatchewan Power Corporation, which is a crown corporation, which is in charge of delivering electricity in Saskatchewan, and they're being sued by a number of different individuals claiming that their charter rights have been violated. So we'll see if they're able to stop them going forward. Okay, and then finally, the Canadian government is in the process of developing an implementation framework to complement an existing Environmental Act. And what they're trying to do is they're trying to give meaning to the concept of the right to a healthy environment. And this implementation framework will allow for things like principles of environmental justice, the principle of non-regression, and the principle of intergenerational equity to be incorporated into these laws. So I would say once this, these laws come into place, perhaps that will give greater basis for the right to a healthy environment to be recognized and therefore form the basis of future litigation. Okay, so that's just a quick lay of the land here in Canada, and I'm happy to take questions at the end of this. Thank you very much.
Huge thanks, huge thanks. As somebody like myself who was involved before the ICJ as counsel for IUCN, I also reflected quite a lot on the role of customary international law in corporate climate change litigation, which was only hinted by countries and almost indirectly. So I'm happy to go into that discussion in the Q&A with yourself and with members of the audience. So last but definitely not least, I give the floor to Christine Perry.
All right, thank you very much. Hello, everyone. Thank you to our organizers, my colleagues at ELI for having me today. I'll give a little brief background of how I approach this, that I work primarily in the Americas. So most of my work is not based in the US. And I also come to my work from a human rights background, international human rights law. So I primarily work on the intersection of international human rights and the environment. I'm very pleased to be here today to talk more about US-based issues. Also very pleased to have my colleagues in the audience if there are more specific questions, but yes. Okay, so I did not see my name, but I see my name now. So we will get started, and I think no worries.
Just go for it.
Yes. So this is a bit of a continuation of my colleague Gerrard's presentation this morning, that some of the issues are overlapping, but I will try not to repeat what's already been discussed. So this is just a brief overview of procedures and evidence that are involved in climate litigation against corporations. And so looking at the actors involved in these types of cases in the US, that climate litigation involves parties from all levels of the government, federal, state, local. It also includes non-governmental organizations, NGOs, industry, and individuals. And taking it away from the strictly corporate lens that sometimes is individuals, NGOs looking to hold both government actors and companies, industry liable for their actions or inaction on climate change and climate issues. They seek a wider range of remedies in these types of cases that we'll talk about in a little bit. However, looking at the corporate side, so bringing cases against corporate, in the beginning, that it was a lot of NGOs, subnational governments were the most frequent plaintiffs in these types of cases, as well as industry also being plaintiffs in that case. So kind of the flip side of what we have been talking about. While government and federal agencies, so thinking about EPA, Department of the Interior, were the most frequent defendants in those cases. And that was more historically, so I guess 2017, 2018 doesn't seem that historic, but several years ago, that as Jared mentioned, there have been waves of climate litigation in the US. And then looking at the different procedural issues involved in the US, claims around justiciability in the US have largely been revolving around challenges that climate change is a political question. So it's best dealt with by Congress and not US courts. And that's really been what's big stop against what cases can be brought, because people are saying, defendants are saying, hey, you know, our hands are tied. This really is best handled by Congress and not judges in different levels of courts. So that's big issue to think about here. And just given time, I'm not going to talk about every single one of these. I want to make sure we have time for enough questions and comments, discussion, as well as I know we're right up against lunch, so this is one of the harder spots to be in. And looking at arguments and defenses that have been found in climate litigation against corporations in the US, the defendants were largely successful in their defenses in the first wave, that they argued that this was a political question. Again, we're not going to be handling this in the courts. This is a question for Congress to address. And then in the second wave, plaintiffs reworked their arguments. They saw that, hey, this isn't what we're doing isn't working. But in that wave, defendants were saying, hey, there's jurisdictional issues here, that this really doesn't belong in state court. We need to remove this to federal court. So we will talk a little bit more about choice of venue, jurisdiction between state and federal, but that's a little preview of it. And now looking at the type of evidence in these types of cases. So climate science plays a really central role in the type of climate litigation in the US. It's relevant for establishing injury, causation, and liability. That we will talk about the case a little bit further, but the Supreme Court's decision in Massachusetts versus EPA, which again, it's not a corporate case, but it's a big player in the climate litigation portfolio in the US. In this, the case did rely on evidence given from IPCC reports, evidence of sea level rise, and a declaration from Michael McCracken, who was the former executive director of the US Global Change Research Program. So we do have different types of evidence being used in that seminal case, Massachusetts versus EPA. And something that you may have heard of is Judge Alsup's tutorial on climate tutorial. So this was really a novel approach to how climate science can be introduced to a courtroom, to a case, that it was a 5-hour tutorial on climate science. And he ordered it in connection to a case brought by cities of Oakland and San Francisco against the world's 5 largest producers of fossil fuels. And so we had, both sides present evidence, arguments on climate science for 8 different questions. And the questions included: what caused various ice ages, including the Little Ice Age and prolonged cooling periods? What is the molecular difference by which CO2 absorbs infrared radiation, but oxygen and nitrogen do not? What is the mechanism by which infrared radiation trapped by CO2 in the atmosphere is turned into heat and finds its way back to sea level? Does CO2 in the atmosphere reflect any sunlight back into space, such that the reflected sunlight never penetrates the atmosphere in the first place? Apart from CO2, what happens to the collective heat from tailpipe exhaust, engine radiators, and all other heat from combustion of fossil fuels? How, if at all, does this collective heat contribute to warming of the atmosphere? And then the final questions were: in grade school, many of us were taught that humans exhale CO2, but plants absorb CO2 and return oxygen to the air. Is this still valid? And there are a few follow-up questions to that. What are the main sources of CO2 that account for the incremental buildup of CO2 in the atmosphere? And finally, what are the main sources of heat that account for the incremental rise in temperature on Earth? So that really, he wanted those answers before they got to the case, that it was important for him to understand, what are we talking about? What what are the facts? What's the science behind this? Because it does play such a pivotal role in what's being decided. And if you don't have the facts, if you aren't really oriented with what's going on, really easy to go over your head. And I don't know the breakup in this room, but I'm guessing a lot of us are lawyers. And if you ask me to wade into an IP case on something I've never even heard of, I'm not going to do that well. So I think that this approach, well novel, is a really interesting approach that helps the judge know what's going on and also gives the parties a chance to say, hey, this is where we're coming from. This is what we're working off of. That's a little background on procedures and evidence. And now we're going to talk briefly about the types of remedies involved in these types of cases. So there's injunctive relief, damages, declaratory relief, remanding a court, there's vacator, civil penalties, accounting, and then awards of cost and not seeing the bottom of that slide. So let me pull it up on mine. Oh, there it is. And attorney fees. So in the US, that it generally is, unlike Canada, that people pay for their own attorneys fees unless it's in the judgment that fees will be covered by one party or the other. So there really isn't the risk associated with some jurisdictions such as Canada, although you might be hit with it at the end, depending on the judgment and the decision by the court. So looking at these, they're pretty conventional remedies. And I'm sorry, need to look. There we go. So it can really, vary. So damages for climate-related harms, that can really vary in the amount that's being sought. So some plaintiffs have looked for more untraditional types of remedies. So looking at directed at making changes of energy and transportation policy. So really kind of thinking outside the box of the traditional toolkit of remedies. And as Gerrard alluded to, the first wave of climate litigation cases in the US, the AEP versus Connecticut case, an injunction was sought in this case to cap CO2 emissions and decrease them on an annual basis moving forward. And this type of remedy has never been sought again after this case, that this was really the only time that we saw something like that. And as cases kind of adapted to what were successful, what was unsuccessful, types of remedies sought have also changed throughout the waves and the types of cases that have been brought. But I will not go too far into that just for sake of time. And now we're going to talk a little bit about where are these cases being brought and what's kind of the gaming behind this, because there is strategy between bringing a case in state court versus federal court. So this is kind of a typical timeline in what might happen in a type of case being brought. So the plaintiff will file in state court if they find that the state court will be more favorable to them. And then usually the defendants will remove to federal district court. The plaintiffs will then ask the federal district court to remand to the state court. A little bit of a dance, we're going back and forth. The federal district court remands to the state court, and then the defendants appeal to the federal court of appeals. And then we go to the federal court of appeals, which affirms the district court's remand order. So now we're going back to state court, but defendants have, one last play. They can petition the US court to review court of appeals decision. Normally the US court declines to review this. So it's not really something that happens, although we generally do go through this song of dance of we're going to state court, no, we're going to go to federal, no, we're back to state. And a good example of this in practice is a case that's been discussed today, but the city of Honolulu versus Sunoco. And in this, that the city brought a suit against a group of oil and gas companies in 2021. And it followed this play that recently the Supreme Court denied cert on this. So it is going back to state court. And looking at these types of cases, it does take a long time. That this, back and forth between where are we actually going to hear the case, it doesn't mean that there's been a failure. It just means the court hasn't reached a decision on the merits. This is really the procedural elements of where we're actually going to hear this case. And we have talked about Hawaii a fair amount today, that Hawaii does have that right to a healthy, clean, sustainable environment in its state constitution. And I'm going to give a little plug for something that we did at ELI several years ago when the UN General Assembly was debating recognizing this right at the international level. At ELI, we had a three-part webinar on this right at both international, the national, and the subnational level. And during our webinar on the subnational level, we had an associate justice from the Hawaii Supreme Court come and talk about that right in Hawaii, how it really is reflected in the cases, in the decisions. So if you are like, wow, I've heard a lot about Hawaii, I can't really book a trip there because it's far and expensive, I'll watch the webinar and hear more about it. I would encourage you to do so. It's a wonderful, wonderful series and really gets more into this right at the subnational level and specifically in Hawaii, and really why we hear a lot about Hawaii in these types of cases, because there are laws that support and have kind of a grounding for these types of claims. So now we're going to talk briefly about standing. So again, this is another procedural issue in these types of cases. Standing has sometimes been a bar for plaintiffs in bringing climate litigation cases in the US. And standing in the US is a person's ability to bring a lawsuit to court. It is essentially making sure that the plaintiff has sufficient stake and connection to the claim. So I can't bring a claim on whatever I want. I actually have to have some connection to the case. There has to be injury that was caused by the defendant and that a favorable court ruling could redress or can redress. So those are really what you need to think about when you think about standing. Big case for standing, again, it's not a corporate case, but it is the Massachusetts first EPA case. And Massachusetts and several other states petitioned the EPA, the Environmental Protection Agency here in the US, asking the EPA to regulate emissions of carbon dioxide and other gases that contribute to global warming from new motor vehicles. And EPA said, no, that's not really our wheelhouse, that the Clean Air Act does not authorize the agency to regulate these types of emissions. And the court determined, yes, Massachusetts and the other states do have standing to bring this type of claim. Typically, the injury of greenhouse gases would be too tenuous for an individual to claim for a direct injury. However, the state is filing this and not an individual, so they did find standing in that case. And that brings me to the end of my slides and giving us enough time for conversation and discussion.
Thank you very much. First of all, a huge thanks to all three of you for allowing us to have this discussion before lunch. I think there's a lot of aspects here that in a way are not immediately linked to corporate climate change litigation, the human rights arguments and so forth, but actually you showed very clearly that it's also an aspect of corporate climate change litigation. And I'm very keen to hear from the audience, more comments, more questions. I take it we're still online? Yeah. Okay, so if you do ask a question, very briefly introduce yourself so the person that is online also knows who we are. And if there are any questions from our colleagues online, please give me a shout, maybe put it on the screen so I can also refer to those. I have my own comments, but I'll leave them for the final remarks when you'll literally only have me between this and lunch. But first, I'd like to hear some people in the room if you have any further comments or questions. Okay, we'll start with Amelia and then the gentleman.
Amelia Burnett, PhD candidate at the University of Strathclyde. I have a question about carbon sink litigation. I think that's one of the sectors that's likely to be, I think, any sector involved in forestry practices, other extractive industries are one of the industries likely to be impacted going forward, and all of the regions sort of represented through the Americas have large carbon sinks. So what are your thoughts on the future of carbon sink litigation Just as a backdrop, I would add that the Hawaii case that we've been talking about had in the background, sort of the unsustainability of industry harvesting in the background. So in a sense, the idea of this could come up even when it comes down to biomass facilities. That has an impact.
Thank you very much. I'll get a second question and then I'll bring it back to the floor.
Yeah.
Yes.
My question has a couple parts,
So we'll go directly here. So carbon sinks litigation in the Americas. Is there anybody who wants to give it a go? You have a lot of forest in Brazil, so I'm afraid.
Justice Faquin, in his opinion, in our most important case, the climate fund case, wrote about the importance of this sinks, no? To keep the forest, like the integrity of the forest in Brazil, the rainforest, the Amazon. This issue is in the mind of our justice, mainly in our Supreme Court, because this debate for us in Brazil is a constitutional debate, specifically.
We'll go to our second question. The one thing I would say is that this links very much also with the very few aspects that are still to be finalized completely in the Paris Agreement implementation package 6.4 carbon markets. And that, although that will create even more complexity to a possible corporate climate change litigation. Yes.
Thank you. Cam Brewer at File. I appreciate all the excellent presentations. A couple questions. So first to Bernali about the Nevson case and customary international law in Canada. Hassan mentioned earlier that the Nevson case hasn't really had much pickup in 5 years since it was decided. I'm wondering if you could opine as to why that might be. Maybe it's the forum nonconvenience issue or some other point. And secondly, about the right itself, customary international law, you mentioned the right to life. Would that be interpreted in Canada according to the Section 7 Charter jurisprudence, or would it also capture sort of a broader global understanding? And my second question is actually to Francesco. You mentioned that the right to a healthy environment was only touched on by states at the ICJ hearing, and yet at the end, one of the court's questions was about the content of the right to a healthy environment. In your view, does that give the court a good grounding to make a declarative statement about whether it's customary law and what the content is, or interested in your views?
Let's start with yourself first.
Okay, so thanks very much for that question. So the only case that we're aware of that has actually picked up on Nevson is this John and Barrick Gold case. So that was filed, I would say, relatively recently after, and it basically mimicked Nevson. So they were trying to capitalize on that. It was the same lawyers that brought the Nevson decision, but it was, it was struck down by the court. And so I don't know if there's been a subsequent one after Barrick Gold, but it was definitely a blow. They absolutely thought that that would go through, and they thought they were going to be able to set a new, following through Nevson, that they would be a lot of momentum for that. And they were very, very shocked by the decision on forum nonconvenience. So I believe that I've heard in the pipeline that there are still some more going on. So it's possible now that they'll just be more cognizant of the forum nonconvenience argument. So they will be looking for jurisdictions in which they think that they can win on that issue. And then in your second question with the right to life. So that's a really good question. So the Supreme Court did not actually define what they meant by customary international law, nor what the sources would be, nor how these kinds of issues would be developed. So we have no idea really what they would do. I suspect what would happen is that if we actually made it to an area where we're going to suddenly develop the customary international law, they would have to draw from international human rights law. This is not a piece of charter litigation. That's a different type of law. Although Section 7 draws from the international jurisprudence in this area, this piece of this tort of the breach of customary international law should be done from actually customary international law.
So just to comment on your question, let me clarify what I meant by that. What I was thinking and seeing when I was in The Hague was that very few countries really brought in front of the judges the fact that actually most of greenhouse gas emissions come from the private sector rather than from the public sector. And in a way, you understand why, you know, it's International Court of Justice, it's about states, it's not about corporates. But, and this was my comment, not so much the healthy environment, but I'll get into that. It seems to me that the moment you bring the idea or the legal position that customer international law is applicable, that the obligation not to cause significant harm is an element of due diligence, and that also includes actions that your private sector does in your country, and that part of that is the obligation to undertake a thorough environmental impact assessment. If you start connecting the dots, the ICJ could potentially strengthen the EIA procedures on private sector. Very few countries went in that direction. Whether the ICJ will be progressive enough or elastic enough to go in that, I don't really know. In terms of the human right to a healthy environment, well, it's exactly what you said. You know, plenty of countries, those, especially those who were attaching themselves to the Paris Agreement, were saying, let's not talk about this. You know, yeah, there will be some strange constitutions that have it, but this is about state practice. Just count the numbers. This is not custom international law. The extent, again, to which the ICJ will clarify, yes, this is CIL, custom international law, I'm not sure. I do think they will. This is my speculation. They will clarify the due diligence nature of human rights. You may like it, you may dislike it, but that's where it may go. It's more the Inter-American Court of Human Rights, which obviously will have more to say in that front. So, hand up there, hand up in the back. Let's start with this.
You didn't get to answer your question though.
Which one?
From Ken. Didn't you pose that question? I
No,
answered
no,
my
that's-
question.
that's-
Yeah, okay, all right. Sorry.
Great. This question is for Christine. On your last slide, you mentioned the endangerment finding. Under the current administration, they are looking to reevaluate, potentially repeal or remove the endangerment finding. I was wondering if you could talk about the impacts about that, how that might alter the litigation landscape in the US, and if there's actually a potential for it to open up corporate litigation, since the US litigation currently is limited against mitigation. It creates a potential for there to be more mitigation-based litigation in the US or not.
Thank you. I might be bringing in my colleague Gerrard, who's more in the US than I do to answer that.
Take that on. Short answer is yes, it absolutely has an implication for possible litigation. First, I think, you know, any rollback of the endangerment finding, first of all, is going to be challenged in court. And so that's going to take some time to work its way through. But, you know, under the AEP versus Connecticut framework, right, the federal common law is displaced by the Clean Air Act because the Clean Air Act is the mechanism to regulate greenhouse gas emissions. And so you sort of no longer have the Clean Air Act as the mechanism to regulate greenhouse gas emissions, then I think the argument goes that there isn't anything to then displace federal common law. And so you're back in the pre-AEP versus Connecticut or pre-Mass versus EPA world, where these claims about interstate emissions for climate harms are now on the table again, because there's no federal statutory law to displace them. So I do think it absolutely has an implication for changing the landscape of these cases, but I think we're also a long ways away from the actual pullback.
We'll get one more question in the back and then we will entertain the question online as well, please.
So I just want to pose the thing to Gerrard. What about dormant commerce clause? But my real question is.
Please ask us questions.
The judge, and it's a little bit removed, but how common is it for the Supreme Court of Brazil to have an order to the legislature to enact something? Because if this is something that happens, is this something that maybe other, particularly other Latin American countries might pick up on?
Yeah, this is a huge problem. The independence of the powers of the branch in Brazil. We have this conflict, but we have one facility, because in our constitution we have the protection of the environment, the health environment for the future generations, including. If legislative branch doesn't obey this this article of the Constitution, the Supreme Court have authority to give an order to the legislative branch. I don't know if I answered your question. Yeah, okay.
And I'd like to take the question online, and it's directed to Canada, so I hope you don't mind, you can see it all here as well. It's really about, the way I interpret this question is about life cycle of products, fast fashion, potentially done in another country, but then the interest and as Canada's increased focus on corporate climate accountability. I don't know whether there's something that you can answer to that, or whether there's elements of human rights and litigation that you can see there.
So I think this question is really asking about the integration of human rights and environmental sustainability in holding corporations accountable. I guess in Canada, and I would have to say there isn't.
Okay.
There isn't.
Easy answer.
I think I'll just say, like, we do have this thing called the Canadian Ombudsperson for Responsible Enterprise, which was supposed to be doing things like this. But they have, the government has curtailed the powers of this body to do independent investigations into these kinds of matters. So that has led to not much going on in that area. Yeah.
I feel that we could go on, but let's do it over lunch. Before I ask you to join me in thanking our amazing speakers, just 2 comments on myself, randomly from some of the points you made. You mentioned the climate tutorial. I was not aware of that. I will not comment on that because I found it a little bit awkward, the questions that were. But again, moving back to the ICJ did a very strange thing as well, where it invited to The Hague IPCC lead authors, but behind closed doors. Not everybody liked that, I have to say, because one of the good things, in my opinion, of the ICJ was the transparency of it. I want to know what Brazil thinks. I can read it. I want to know what the USA thought. I can read it. Russian Federation, I can see it. I have no idea what you just said. I have no idea what was been asked. I have no idea what they replied. That to me is not good enough. So interesting that process, again, we may think what we think about the questions, but it's a much better process than what was done there. The other thing about Hawaii, very luckily, no expert in Hawaii, but I do work a lot with islands and both subnational jurisdiction and really excellent scholars in Hawaiian law. And they will say, I may be exaggerating, no wonder Hawaii has a different approach, because our history is different. The approach to natural resources management in Hawaii has nothing to do with a lot of the way natural resources are done on the continent, if we're going to call it like that. So I'm pleased that Hawaii has it, but I'm not surprised. But definitely, like in many other parts of the world, it's these, and in international law, we always see small island developing states and islands being innovators. So I do see it here in the USA as well, as Hawaii having that punching above its weight when it comes to its legal renaissance, and I'll stop there. But join me in thanking the speakers, and let's go all have lunch together.
So we get started, so we keep the momentum. Francesco managed to get us back on time. We don't want to lose that. Just making sure there's nobody. All right. So I think I don't have to repeat. So Michael Mehling, MIT CEPR, and working with Ivano on the project here in from the US, so to speak, to help him, support him while he's based mainly in Europe. And the session or the panel that I'm very pleased to be moderating, even though I'm not an expert myself on the topic, is the procedural aspects of climate litigation. And of course, during the morning sessions and even starting with the keynote, we kept sort of coming across the importance of procedural issues. There's a lot. Christine had a nice slide that sort of showed a number of the different procedural implications or dimensions of climate litigation and also corporate climate litigation. And I don't think we will cover all of them now, but there's 2 really important topics that we will go into more depth that are absolutely essential for, first of all, any kind of environmental or public interest litigation, and Pilar will take us into that, and that's legal standing and some of the aspects and topics around that. And then we'll focus more on the complexities of climate, this diffuse global challenge that is caused by millions and millions of emitters, and how you can actually establish causality and attribute climate impacts and damages to individual emitters as a basis for litigation. So I'll introduce the panel in sequence. We'll really go from Pilar to Delta to Rodrigo. Pilar Moraga, who I've known now for quite a while, I think 20 years, we just found earlier today. And what connects us is that I'm sort of in heart a Chilean, even though I was born in Germany when I was 4 years old. We traveled and lived in Chile for almost a decade. And so she's like the, you would say, pioneer of environmental law in Chile, working at Universidad de Chile, sort of the main university in Santiago. She directs the Center for Environmental Law there and also Center for Climate Science and Resilience. But she's also accompanied many of the legislative developments in Chile as one of the main experts. So she will be, as I said, taking us through some of the legal aspects of the procedural side of climate litigation. Then we'll turn to Delta Murner, who works at the Union of Concerned Scientists, which is a really influential nonprofit organization of scientists primarily, I would assume, although I think there's also lawyers there, but really that provide scientific input. You're the lead scientist for a project or activity initiative within UCS that provides scientific advice and input for legal proceedings and litigation. So it'll be really cool to hear your sort of broader perspective on this topic. And then we'll finally turn to Rodrigo Manrique Garcia from Peru, who's now, I mean, you're listed as Universidad Científica del Sur, which is a Peruvian university, but you also bring a practitioner's perspective. You've worked as a practitioner for many, many years, are based in London now, work with a large insurance broker. And of course, insurances are one of the private sector sort of sector or subsectors that are extremely exposed to climate change, climate impacts, and also the legal risks around that. So I think we couldn't have a better panel. So many different perspectives, so many long years of expertise, and also different geographic perspectives. And with that, I'll invite Pilar to begin.
Thank you.
Thank you.
Thank you very much. Thank you, Michael. I am honored to be here. Thank you for this invitation. I will start with this topic concerning legal standing in environmental liability for environmental damage in the climate litigation. It's a long title. And I will talk about the Chilean experience. In fact, numerous studies analyze the development and evolution of climate litigation, focusing on its characterization. Nevertheless, today I'd like to present a new perspective, maybe, in particular, how this phenomenon of climate change has unfolded in a small global South country like Chile, home to 18 million inhabitants and highly vulnerable to the effect of climate change. In fact, Chile exhibits 7 of 9 vulnerability characteristics established by the UNFCCC and has an economy dependent on natural resources such as copper and lithium, which are essential for the energy transition and the reduction of fossil fuel use. These characteristics are common in other Latin American countries, like Brazil or Mexico. Now, from a judicial perspective, since 2013, Chile has a unique feature, the presence of environmental courts, composed of both legal and technical judges. Notably, Chile lacks significant strategic climate litigation, potentially due to the absence of support mechanism for civil society organizations. Furthermore, climate change is not a central element in most Chilean judicial disputes yet. Nevertheless, the climate change element is present in the environmental litigation context, like of Brazil, in environmental courts and higher court of justice. Most these cases are initiated by civil society or municipalities, addressing environmental harm, the violation of the right to live in a healthy environment, or the right to public participation, generally targeting private companies. When the climate change is present in a dispute, it influences judicial interpretation of legal provision. For example, illegal water extraction may be interpreted differently depending on whether it occurred in an area experiencing water abundance or demand growth. In particular, environmental courts often consider climate change when determining the existence of environmental damage or defining remediation measures. The second environmental court, for instance, we have three courts, one in the north of country, one in the middle, and another in the south. For instance, consistently requires climate change to be factored into court-mandated remediation plans in the damaged environmental cases. Now, this presentation will be focused on analyzing the treatment of legal standing in Chilean environmental damage litigation related to climate change. And for that, I would like to start with a description of the legal framework governing environmental damage liability, and then to continue with the characterization of legal standing in environmental damage liability cases that involve climate change. And finally, I will present a discussion concerning how courts address legal standing in these cases. So, concerning the legal framework for environmental damage, after the 1992 Rio Summit, Chile enacted environmental legislation establishing liability for environmental damage and the right to seek reparation and compensation. According to the law, anyone who causes environmental damage, whether negligently or intentionally, shall be held liable. And environmental damage was defined as any significant loss, diminution, detriment, or impairment to the environment or its components. Now, a legal action for environmental damage can be initiated to repair the environment by natural or legal person who have suffered harm, or municipalities for damage occurring within their jurisdiction. The state represented by the State Defense Council. Now, in the case of municipalities and the state, they are legally presumed to have an interest in the trial outcome. Additionally, municipalities can act independently or upon certain requests. In this matter, it's important to note the creation of environmental courts in 2013, expanded legal standing, promoted greater access to justice, and more effective environmental damage reparation actions. Now, concerning the environmental damage and climate change, we can say that of the 34 environmental damage ruling, 13 reference climate change. In this case, civil society or municipality typically file lawsuits against private companies, including salmon farming and sanitization firms. You can see that in this slide, where there is the plaintiff in three municipalities, NGOs, social society, or individuals, particular, and the state. The last is the state in different tribunals. In the social society are different, for example, farmers, organization farmers, or labor union, workers, union of workers, artisanal fishermen groups. Now, defendants, we can found mining, salmon firms, sanitization sector, thermal power plants, and others. In these cases, climate change is often invoked to justify the existence of significant environmental damage, while defendants sometimes attempt to use it to evade liability. However, courts have consistently rejected climate change as a defense against liability. Now, what is the discussion concerning legal standing in these cases? There are two important cases where defendant challenged the plaintiff legal standing of Tribunal of Valdivia in the south of Chile. The first one is the salmon case, where the municipality of Ancud, Ancud is a, we can say in the map, Ancud is a municipality in the Chiloé island. And in this case, the municipality sued a salmon company for dumping 9,000 tons of dead fish into the sea, contributing to a red tide exacerbated by increased sea temperature. The defendants argued that the municipality lacked standing because the step occurred outside its jurisdiction. However, the court, the tribunal, the Environmental Court of Valdivia, applied a broad interpretation, considering both the physical location of the damage and its environmental impact on the municipality. In other case, the Fishermen's Union sued a coal-fired thermoelectric plant in the south of Chile too, for environmental damage caused by air pollution. The defendant claimed the union had no standing as its member lived outside the immediate impact zone. Nevertheless, in this case, the court recognized the plaintiff's legal standing, emphasizing their direct interest in the cause due to their economic and social ties to the polluted area, because they live and work in this zone. So we can conclude environmental courts in Chile adopt a broad interpretation of legal standing, ensuring greater access to justice in environmental damage cases. Legal standing has proven essential for municipalities and civil society organizations to hold private companies accountable for environmental damage. The Chilean experience highlights the role of specialized environmental courts in strengthening environmental access to justice. So it's interesting experience about legal cases in our country but maybe we can open the discussion after the panel. Thank you for your attention.
Thank you very much, Pilar. So in a way, sort of the opening gambit in any climate litigation context is, will you have access to judge? Will you have standing? Once you get there, though, the question then is, are the damages that are being claimed, et cetera, is the harm, can it be attributed? Can it be causally connected with the defendant? And so Delta, maybe you can kind of take us through how scientists think about this, especially at a time when science is under so much attack, and UCS is one of the champions keeping up that torch.
Yes, thank you. Thanks so much. I'm really excited to be here today for this conversation and grateful to the organizers for bringing us all together. Looking forward to engaged conversation with this group. And as Michael said today, I'm here to speak specifically about causality. So establishing the causal link requires really a mosaic of evidence, right? It's drawn from multiple disciplines, from historical documentation, from internal communications, economic modeling, engineering assessments, community testimony. All of this contributes to the essential pieces of this puzzle, right? Each of these lines of evidence plays a really vital role in presenting a compelling case. I don't have time to talk about all of these lines of evidence today, so today I'm going to focus in particularly on attribution science. This is a body of research that allows us to quantify how much a particular climate impact, such as a deadly heat wave or devastating flooding or rising sea level rise, can be traced back to human influence, and increasingly to specific sources like major fossil fuel producers. Attribution science doesn't replace other forms of evidence. I want to be really clear about that as I'm speaking today, but it enhances and complements them. So by providing a rigorous scientific basis for linking emissions to observed harms, it helps to fill a really crucial gap in establishing responsibility in the warming world that we're all living in today. So today, my plan is to walk through how this science works, where it's most robust scientifically, and also in the legal context. All right, so what is attribution science? Attribution science is a really rapidly advancing field, and it helps us to understand the influence of climate change across a range of different factors. So from long-term shifts in climate patterns to the role of climate change in altering specific events. It can also be used to analyze source of emissions, so allowing us to understand how those emissions contribute to climate impacts. By analyzing data, models, observations, attribution science shows us how climate change has altered everything from temperature trends to extreme weather events. It helps to distinguish between natural variability and human influence, helping to answer really critical questions like, did climate change play a role in this event, or what emission sources are contributing to climate change? So kind of in short, attribution science can explain how climate change makes a heat wave hotter or a hurricane-related downpour more intense, as well as quantify how emissions from specific sources contribute to climate impacts. All right, to dig in a little bit further, I want to break it down kind of briefly. So often when we talk about attribution science, we kind of use this overall header, but there's 4 important subfields that I want to just mention to provide kind of some specifics on what the field really looks like. So the first is trend attribution, and this is science that's identifying patterns of change over time. The second is event attribution, and this is probably the most well-known area. And when people hear attribution science, this is probably what you're thinking about. This examines specific extreme weather events, such as particular hurricanes, a particular heat wave, or a flood, and asks how climate change has altered that event. There's also source attribution. Source attribution determines the relative contribution of different emission sources, such as fossil fuel industry or the agriculture sector, or even a specific country, to the overall rise of heat trapping gases in the atmosphere. And then finally, there is impact attribution, which is the newest area of study. And this looks at how climate change is affecting ecosystems, economies, communities, kind of what those overall impacts really are. Altogether, attribution science can help us understand not only what is happening, but also why and who or what contributed, right? So this is important to note because these subfields are slightly different, They're asking different questions. They're using some slightly different methods, providing different answers. But kind of regardless of the subfield, what's important to know is that attribution science is a powerful tool in this space because it moves beyond correlation, and it offers a way to establish causation between climate change and climate impacts. So I want to dig into a little bit of how this actually works, right? So what attribution science is really doing at the heart of it is it's comparing two different scenarios. So it's looking at the world as it is today with current greenhouse gas levels compared against a world, what's called a counterfactual world, where we can say, what would have happened if those emissions hadn't occurred? You know, what does the world look like without those emissions? So really what attribution science is doing is comparing these two different models against each other. I wanted to kind of demonstrate this in one figure from a paper. So illustrated here, this shows how attribution science works by comparing, real world model to counterfactual models, those models with the additional emissions. So just to explain a little bit of what you're looking at here, on the left-hand side, you have a graph that shows the observed and modeled global sea level rise. So this is what the sea level rise actually looks like today, human-caused sea level rise from climate change. In the center, we have that counterfactual. So this is the model that's been run over and over again to really show what would have happened if we didn't have those added emissions. So where would our sea level rise have been without those additional emissions? And then very simply, the third kind of panel here is looking at the difference between those two. So it's saying, all right, we have these two different worlds. What's that difference? And this is how we really get at attribution. And we're saying, again, like what's the variation between these? This side-by-side approach is core to attribution science. It quantifies how much worse climate outcomes have become due to carbon emissions by asking, again, what if we hadn't warmed the planet, essentially, right? That's what it allows us to do. This slide, for time, I'm just going to mention really quick. This is just another kind of representation of the same idea of what the modeled world looks like compared to the existing world, and can show kind of some of the statistical differences that we see for the potential for events to happen. So if there's more questions, we can come back to this, but I wanted to, but again, this is just kind of another representation of the same idea. So now that we've seen how attribution science works, the next question is, what are we actually applying it to? So this is a graphic from the IPCC 6th assessment report that summarizes what the science now clearly shows, right? So climate change is making extreme weather events more frequent and more intense. We see that there's more extreme heat, there's longer, deadlier heat waves, that heavier rainfall events are happening more often, increasing flooding risk. Drought is becoming more severe in some regions. Fire weather, the hot, dry, windy conditions that fuel wildfires are on the rise. And our oceans are not only warming, but they're acidifying, they're losing oxygen, and this is damaging marine life in coastal communities. These are not general trends anymore, right? Attribution science is helping us connect specific events, again, like these deadly floods or record-breaking heat waves, to human-caused emissions, often with very high confidence. And again, that's what makes this science so powerful in legal and regulatory settings. One of the things that I wanted to note with this slide is that it's important to kind of understand the inclusion of attribution science in the IPCC 6th assessment report. This marks a real turning point in the evolution of this science and of its acceptance. So what was once a developing field is now recognized as a critical part of climate science, rigorously peer-reviewed, methodologically sound, and broadly endorsed by the scientific community. This I'm just going to show really quickly. I wanted to show the range of attribution studies and variations in the findings. So this chart is pulled from Nature. It's specifically looking at 170 peer-reviewed studies, and it's showing those broken down by different types of events. And in the colors here, you can see where the studies show that there's been more severe or more likely, the event is more likely to occur because of climate change. There's some purple occasionally where it's less severe or less likely to occur. And there's blue, there's still areas where we don't have enough data or where we don't see an influence of human, any discernible human influence on that event. And I wanted to show this for transparency. And I also think that in a lot of ways, this really strengthens the science, right? There is variation that exists within it. And we can see that when we look through the literature. That being said, it's also important to note that attribution science isn't equally advanced for all types of events, right? So the strengths of science varies based on the type of an event, the region, the availability of data, the maturity of the methods used to model the different types of events. So here, these are two kind of variations of the same figure that are about a decade apart. So on the left here, you see a figure from 2016 that is looking again at the confidence of attribution science. So about a decade ago, events like extreme heat were already highly attributable to climate change, while events like severe storms or tropical cyclones, they were harder to link with confidence. In panel B here, you see the increases in just over a decade, right? So it shows how much the field has progressed. And today we have robust evidence, not just kind of around terrestrial heat waves, but also marine heat waves, extreme rainfall, different types of drought events. Again, just to kind of show that overall relationship and the progress that we've seen in the field. Now, science is shifting to not just be able to look at climate change resulting from human-caused greenhouse gas emissions. Science is also able to attribute changes to specific emissions of sources. So here I'm showing a graph in blue of the global carbon emissions from all fossil fuel producers and cement manufacturers since 1850. This is in millions of tons. In red, you see the emissions from just the top 90 producers. This is work that was published by Rick Heady. Overall, what this is saying, or the study here found, was that 2/3 of all industrial carbon emissions starting from the Industrial Revolution onward can be traced to 90 carbon producers. This research has been updated and continues to grow. So Influence Map now holds it. There's over 122 companies that are involved, but I wanted to show this graph, one, because a lot of the initial studies on source attribution are based on this data. And also this study is very well cited in the toolkit from BIICL. All right, so before I jump into source attribution, I want to say kind of why we're looking at it. So source attribution is really important to make clear the causal chain kind of in these cases, right? So what we're really looking at to be able to attribute for attribution to industrial polluters is looking at kind of the causal chain of evidence. So you have fossil fuel production by companies that leads to increased greenhouse gas concentration in the atmosphere, which causes higher global temperatures, which then drive extreme events and damages that we've been discussing. So again, this is kind of the legal framework that is really important, kind of this chain for understanding these studies. So quickly, I'm just going to mention a few studies, source attribution studies over time. This first one was done by my colleague, Brenda Eckwurzel, who worked to run kind of simple climate models to look at those emission data, calculate the average temperature, global surface temperature, and sea level rise tied to emissions from those 90 producers. Here she found that from those 90 producers that, between 42 and 50% of global temperature rise can be attributed to just those 90 companies. Similarly, for sea level rise at the time, 26 to 32%. Again, total global sea level rise connected to just those 90 companies. There's since been a study on ocean acidification where we see more than half of ocean acidification tied to those same carbon producers. This is a graph that's actually from the appendix of that study, just to pull out the specific actors. So here you can see, again, why this type of science is so important is because you can actually look at the individual companies, you can look at their contributions and the role that actually plays in the overall piece. So this is something that is published alongside that research. One of a more recent study that I was a co-author on looked at wildfire weather. And here we can see that 37% of forest area burned in Western North America and Western Canada since 1986 can be attributed to these companies. And then the most recent study, this is a study that was published just a couple of weeks ago that I'm a co-author on. Here, what's interesting about this study, what's new here, is that we don't just look at the contributions of emissions of sea level rise up in today to today. We looked at how past emissions from fossil fuel companies will shape sea level rise into the future. So looking into some of those questions, the legal questions around future generations, some of those pieces. But we also modeled counterfactual scenarios to say, what if emissions had been reduced at different points in time? So if they hadn't come, which is what a lot of these cases look at, but also what if the emissions had started to reduce at the point when industry knew about climate change based on the historical research? Or what if we actually started to reduce when the global climate negotiations started, right? What's the difference that we see in the world today? So again, these are research questions that I think are really informed in the legal context. So for time, I think I just want to talk a little bit, again, kind of driving this home. Attribution science is powerful, but it does have some limitations. Again, we have to be really specific about the actual question that we're asking. Attribution science isn't going to tell you that an event was 100% caused by climate change. That's not how it works, but it does help you to understand the role of climate change in altering an event. And that's really where the science lies. Attribution science plays a role kind of across the evidentiary chain that we have. So from source attribution, helping us to understand who emitted what and when. Global change attribution shows us how those emissions altered the climate system. Impact attribution explores how climate change affects physical and social systems. And then extreme event attribution quantifies how specific events have become more likely or more severe due to climate change. It's all of these pieces together that kind of help us to build this evidentiary chain and help us to get at these overall questions that we're asking today. So with that, there's my contact if there's additional questions, and look forward to conversation. Thank you.
Wonderful. It was fascinating. I'm sure it'll also spark a lot of questions.
Sure.
And from what I understood and seeing briefly Rodrigo's presentation, you'll kind of zero in a little bit and give us a more specific example of, you had some.
Sorry, those were like the question slides.
Absolutely.
Well, thank you very much for the opportunity. And well, after those presentations, it's going to be really hard now. So I would like to come a bit. I feel that it's really important also to bring different voices to the table. So I'm going to lean into my perspective from a Peruvian practitioner and also from a Peruvian perspective. But basically on the evidentiary challenges and the burden of proof from this context. So for that, I'm going to focus on context and people to understand where it's coming from. So 1970, we had a slide in the Andes. There was an earthquake that produced a slide from the Cordillera Blanca that landed into a lake. That lake overflowed and created a huge slide that killed, that says 30,000, but that was after the weekend when they went there, actually ended up in 60,000 people, which is the most deadly earthquake in the global south. It's the deadliest earthquake in Peru, and it completely destroyed several towns, including Yungay, where you're gonna see it here. So with this mining context, that there is evidence, even from the 70s, the impact would be different without climate change. But nonetheless, this is where it's these circumstances about slides in this situation. So saying that, 45 years later, Santiago Luciano Yuya, it's impossible to be Peruvian and not talking about climate litigation without talking and engaging in Saul, he's a rock star. I really admire him. So he's a farmer and a guide, mountain guide in Huaraz, which is kind of like the same zone. And he contacted some people from German Watch after they went to COP in Peru, and they were talking about, and he was very knowledgeable about floods, risk, and he was really concerned because they have this situation on the back of their mind. And they said, but you know, Saul, this is increased because of WRE and the polluters and the climate science attribution. Would you like to be part of this thing that we're thinking about? And they were all in 10 years ago, and everybody was thinking these guys are crazy. Like the thing that they're trying to get into the court, there is no way on earth that will go fly. So in a nutshell, they were based in the case in the Nuances case in Germany. They were going against one of the biggest emitters in the world. I'm not going to say the name, so I'll just sort of stick to RWE. So in a nutshell, the case, what it's trying to say is that due climate change, it will increase the risk of slides on the Cordillera Blanca, continuing the circumstance that they're coming. And then on the other hand, RWE is clearly responsible of some part of this CO2 emitted in the atmosphere. Those circumstances create higher risk. And then therefore, the government of Huaraz and also Saul will have to go for further costs to create defenses to this flood. So therefore, RWE should be taking the bill according relatively to their responsibility to the CO2 emitted. Very linear, very sophisticated, very fascinating train of thought that everybody thought they were completely impossible to win. So we'll see. I will go back after that. Starting my career as litigation, I clearly understand why Amaru is that face. He's trying to put the numbers on every page when you do litigation in Peru. So it's that's a very complicated issue going through litigation. He's not happy, however, Amaru Alvarez and against some other people. Emilia, she's very happy with the outcome of this lawsuit. And these guys, there were 7 kids who filed a lawsuit against the government of Peru, engaging because they feel that they failed to formulate and implement a national public to reduce deforestation in the Amazon. And then therefore, without the action of the government, they will be increasing the risk of their livelihood. This is also connected to deforestation. So even though I'm bringing cases against the government, there is an implication and there is a connection with corporate activity. Sadly, in first instance, the government, the judge ruled against this case, mainly to the fact that they feel that the government has not provided enough evidence to comply, that the policy did not provide exact actions for the government to protect the Amazon, and also because the separation of powers, and there is not the role of the court to impose policy, which is common situation. There is also 7 cases brought by, okay, you can see that, I cannot see the big. So Yanua is the president of an organization that she, as a representative of the community in the jungle, they are a representation that goes on environmental policies. So they brought court to Peru of many circumstances, and they brought seven actions against the government to comply with the laws of the national climate change laws. There was a specific point where the government had to implement investment in renewable energy, research, ecosystem services, development and innovation, and they haven't done it. So they just brought the court to Peru in the court, and they failed on 5. The government saw that there were not enough action from there to increase the government pressure, but they were successful in 2. And finally, the other case that I wanted to bring is the broader participation of the advisory opinion of the Inter-American Court of Human Rights, and how has this galvanized Latin America and in general America against bringing this point to the court about the actions of the governments in relation to protecting from a human rights perspective. So in this case, there was an amicus curiae from the universities, including Universidad Científica del Sur, and then there was the participation. They decided that the people who were going to speak on that event was going to be a student. So I just wanted to bring, not going deep into the cases, but I feel that this is going to set the case for understanding from the perspective of litigation, from a global south perspective. So 2 things about, only so far you realize all the people who bring in this case into the court are people who have not only the disadvantage from this global south, global north perspective, that they have to, go against the giant, but also there are the communities who bear the cost of the climate change. So indigenous communities, youth, campesinos, and it brings how these circumstances, even though they have those challenges, they've been able to bring these cases to court, and they have huge challenges, including and mainly evidence and burden of proof. There is a variety of circumstances and avenues that this can happen, and I feel that it's important to acknowledge that there are many circumstances where these can continue on the path based on, theoretically, these legal avenues that these cases are opening. So we're looking, for example, subnational levels from the global south against fossil fuel majors. We have the case from, for example, many municipalities and states in the US for this case, but it can be replicated do the relevance and the actions of these companies in the global south. There is civil society from the global south against fossil majors in their country or in the global north. Again, the challenge there will be the possibilities, the actions, and the proof that they will have to bring to the court. There is also the governments, which is the global south as a government. In this case of Saul, part of the money that it will go for the defense will be paid by the municipality of Huaraz. So Huaraz can be part of this lawsuit. Is there a chance? Is there a case where subnational and vulnerable states can bring action and justice to these to courts? And there are different approaches, different perspectives of reviewing this case. But we're gonna go back to Saul because I feel that it's very relevant to understand a bit the connection and the case, specifically about the evidence. So the case started with what we saw, but it was dismissed on the first instance, mainly because the judge in first instance did not consider that there was a linear cause link, because the participation of WRE, it was not enough to be liable for the whole climate change. And the other point is, even if it was part of this, it wouldn't change. So even if you accept that RE was responsible, even taking that in consideration, it will change nothing in Saul's case. There was an appeal, and the higher court of Ham brought in 2017, which I believe it's going to be it could be the relevant arguments for the climate litigation in the future. So the first one is that it overturned the first instance and accepted the case to go to evidentiary phase. It was the idea that it has to be set in court scientifically to prove that the position that it was brought to the case. So there was an increase in expansion of volume of the lake. So if that will lead into an increased risk, if RWE emits CO2 to the atmosphere, and then it was climate change a thing, like, believe it or not, that was part of what we need to prove in this moment. And if the temperatures in Huaraz are increasing due to climate change, and then therefore will increase melting in the glacier, and what was the proportion of the responsibility of WE in these costs that were in 2018, after there was a big win, where I feel that, again, the second stage of things that we can build from here are, first of all, the climate modeling is acceptable as a source of legal evidence. So now this is the first case in that we can understand that everything that Delta has been brought to our attention can be brought into court as a legal evidence. So even if it sounds silly in this room, it was great that it was accepted by a judge. And also, even partial causation cannot be excluded from WE, even if it's not 100% responsible. He's responsible in some extent. And finally, going from this extrajudicial and this and the connection with this global jurisdiction related to human rights, it's about how a company can be liable for their actions, not only in their state, but also globally, from this global neighborhood concept. There was a delay on the process, that's why it's 10 years. And there was a cite to Huaraz by the judge and the experts that they were appointed. And last week, there was the first stage of the evidentiary phase in Germany. Saul came with his lawyers and their scientists to brought to this case. And I feel that there was an improvement, there was a movement on the case. However, there is a bad point from this perspective, that when we say about science, there is science and there is science. So the experts that were addressed by the court, they were not experts in climate change. So their outcome, formally the outcome of this evaluation, has realized that the increased risk of Saul's circumstances, direct link to climate change, are valued at 1% of risk, and without acknowledging the fact of permafrost and also rock bouldering, which was the issue that brought Huaraz in the first instance. So even not acknowledging historical facts. If you consider those circumstances, then the risk will go to 30%. So now the question in this stage, at this day, is if 1% increased risk of the livelihood of a community is a bearable risk as a society. So some consider that 1% could be part of a risk of a human activity, and therefore there is no responsibility for a corporate actor. One consider that, yes, no matter what we're speaking about human lives. And then if you think about 1% risk of the flying of a flight going down, will you take that flight? So we'll see. So there is not everything good in this case, but I feel that it has opened the door to major circumstances. And now I feel that this is a discussion about where we sit now with everything that we have discussed. So there is many layers of evidence that we need to talk about, as Delta was bringing to the attention. And mainly it has to be rely on sources. So from the emission perspective, I feel that's the stage where with science and there is less contingency about understanding where the CO2 comes from, who are the responsibles, what have been doing, what's the amount of CO2 in the government. So this is based on two major papers, so Carbon Major Report, which has been updated, and also the consideration of the IPCC assessment report. I feel there is a lot of evidence, and it's getting to the point that non-discussion about who are the responsibles and what's their responsibility in the fact of climate change. Now, the point, I also feel that from the evidence sharing report, it's good to bring back to the attention that some circumstances, it sounds complicated to prove to the court, and even if you lose 100 times, eventually it will change. So when we're talking about the piercing of the corporate veil, for example, the circumstances where corporations used to build a corporate structure in the global north to avoid responsibility, that's an 80s idea about how the world is. Now, every time there is an increased appetite from the courts to open the discussion at the very least. And I feel that we should keep pushing that agenda. Also, I was speaking with Daniel about burden of the proof in Brazil. So for many years, they've been bringing that point to the court, and they were losing again and again until they're not. So it's a matter of using this legal evidence and these circumstances from across the globe to improve legal arguments to the courts, and eventually it will come. Peru also is being positioned up front, for example, on the rights of nature. There is also cases from the rights of the Marañón River as an entity, and therefore what is the responsibility of the government and society to protect in it, and then what will give standing to several organizations to defend that river. You can do the same argument for glaciers, or you can do the same argument for sea level or the ocean. And also the notion of extraterritorial justice and extraterritorial jurisdiction, which this is one of the cases that has been brought to the attention from the European perspective, and it can bring the case to US attention. So also there is the point about understanding how sophisticated tools from risk modeling have been improving during the years. The science is moving forward, and it's getting more sophisticated and bringing more attention and more data to climate litigators to use this not only from the attribution science, but also from the specific risk. And I feel that it can lean into the theory and the data and the tools that the insurance world has come to can provide. And that lands to the next thing. So when we're talking about these big challenges and about specifically from the global south, what can we do? So I feel that is cooperation. We need to build these contributions. We need to build this community. We need to build connections and try to understand how this litigation is not an isolated issue. I mean, coming back to Saul case, it wouldn't happen if they wouldn't met in a hike with the German guys in Whereas, which, I mean, it's kind of obvious that, of course, they're German. That's what they do. So, but it proves the point that cooperation is the way that we can overcome these challenges. And I wanted to bring a case about this. So the Imperial College of London has a storm model that is called IRIS. It's a statistical thermodynamic model. So what the idea is that they have been doing is to understand, and I'm bringing this case, you can understand from the context of community, of why it's important. So they're isolating all the information, and they're only focusing on the end game, the power of the storms, where they hit the land, where the risk and the damages of human people. So they're isolating the information, and they're doing not only with the statistical data, but also understanding thermodynamics. So again, I'm just bringing some ideas from Delta to a specific case. They're doing from a global perspective, and they're trying to understand the maximum intensity and the potential intensity of storms with this idea. The collaboration is because it's based with the information, tools, and knowledge from the insurance world, and also from universities across the globe. They're doing it in a way that no one can be able to hijack this information. They want it to be as broad as possible, so they don't have this conflict of interest concept, but the idea is to be be universal and uncontroversial, to be useful from this loss and damage perspective. So what they have done is track the storms from global storms from 1980 to understand what is the behavior of the storm, just from the perspective of the last impact. And they also have been studying thermodynamics in the tropical to understand what could be the effects of the weather and the heat in storms. They have isolated the power of the storms on the specific location. You can see the power and the velocity of the wind that decay when it hits the land. And again, what they have done is validated with reality, what we were saying. So they have used these models, the theory that they're creating, comparing with all the storms that they have reviewed in the US. So what they have an agree, there is, if you see the lines, the observation is the reality, what has happened. IRIS 1980 is the model that would be without actually climate change. And IRIS 2022 is what happened with climate change. And then you can see how the storms will go from 1 in 30 years, it go with 1 in 10 years. So the intensity is bigger, it's easier to get this quality of storms, and then also the speed. And then you can use this with 2 degrees world, so you can calibrate what will be the world, and then you can use it specifically on storms. So they have done it with Haiyan, for example, where you can see what is the power of the storm with climate change. And then when you have this calculation, you can also calculate the cost, because you have the data where Haiyan was doing in the coastlines. The same with the hurricane berries. And the idea is, if you see the angle, again, without climate change, maybe there will be that storm, but it will be less often or less powerful. And so if you can isolate that data and then you can compare the costs, then you have the case to understand who is responsible, and then you can go for, well, that's the idea. Well, thank you very much. Happy to have any questions from you.
Excellent. Thank you. I think this was like a menu that was really structured one on top of the other, and great narrative. I'll open it to the audience right away. I have questions, but you have precedence. Attendees online, of course, as well, and here in the room. Any questions to Pilar, Badelta, or Rodrigo? Yes, please, Bernard.
Okay, so nobody else wants to ask, well, I'll ask.
Thank you.
So first question to Pilar, and that is, how did these environmental courts come about? You know, what sort of drove them? And again, you know, for me, it's all about lessons. Are there other jurisdictions that can learn from Chile's experience to create such innovative courts? That's question number one. And then I think the question is really for the two of you. So I was amazed by this idea that you can really pinpoint through attribution science, like how, I guess the increased propensity for a corporation to have created climate change. Is this science, is it like refutable? Like, is it, you know, how concrete is it? You know, and if it is really strong, you know, why aren't we using this to go after more corporations? And, you know, is that factoring into the Saul case? Are they using, like, I don't know exactly how this works. Like, Delta, are you like the world leading expert on this kind of stuff? Or are there like a whole bunch of scientists around the world that are doing this? Or I guess.
So the environmental court were created in 2013, and these tribunals know the environmental damage request, but the administrative decision. So the tribunals review the administrative decision, for example, environmental assessment, or control decisions, sanctions, or another in environmental law context. And the climate change was introduced by the defendant, plaintiff, or judge. So in different cases. I don't know if I answer your question, or we know a specific.
I guess the court itself as a structure.
The structure.
Yeah.
So it's the 3 judge, 1 technical judge, we have three tribunals, one in the north, another in the center, and another in the south. The jurisdiction is north, middle region, and south. And the structure, it has two lawyers, a judge, and one technical judge in each tribunal. So this is the structure. And there are the technical professional who support decision, or they prepare report to decisions, for example. But this is the structure. Yeah.
Yes, before we get to the second question, which is also a big one, but there are other countries that have environmental courts, right? Anybody in the room that can just, that would be for which country?
There are many, there's actually 2 reports that have been done that go through and describe the various courts, but the last number I remember was
Brazil, right?
350 some odd.
Kenya.
Kenya.
India also, yeah.
Costa Rica.
Look up the cranes are the ones that done categorization types of courts.
Right, so something I'd also like to look at more. And how has it improved decision making, having the technical and legal expertise? Now to the second question about the attribution, the precision.
Yeah, so one of the reasons, so I guess to start, something that's important is that there's different scientific communities working on those different subfields, right? So for event attribution and the type of work that Rodrigo presented, there's a much larger community that's working on event attribution. And that work is incredibly strong and incredibly rigorous. And that's really what you see cited in the IPCC. That also trend attribution, I would say, both of those are very well established. For the source attribution, the pinning, that's a much smaller group. So we are one of maybe 3 research groups that are doing that. We're the first to be publishing in this area, and again, one of the few. Some of the limitations that are important to understand is one that, it's coming off of, all of this is really based off of the data set from HEDI, right? So we have a single data source. And with anything, right, when you have a single source, you can then go after that source, which is something that can be, it's a strength and a weakness. That source of data is really coming from the companies. It's from their own reporting of emissions, generally to their shareholders on what they have sold. That's how a lot of those emissions historically have been calculated. But that also means moving forward that the companies control a lot of that data, which is really important to understand. And there's a lot of black boxes that exist around understanding that data. So I think that's one piece that's really important to understand about it. The other piece is, I showed that one graph with the different companies, and even the largest producers that you're looking at, that was for ocean acidification, and it's going to look slightly different for different types of events, because emissions, it's not a consistent relationship depending on different impacts. But the biggest contributors there, you're talking about 3.5%, right? So if you're going after single companies, right, you're talking about small margins, and that's where you get into some of the things that Saul is dealing with, where if you have a company that's 1% or less than 1% of that total emission picture, what does that look like in the courts? And does that fall often? It might fall within the margin of error. And then how do you talk about that? So that's something I think, like in the US litigation, which again is not emissions litigation, but you often see it brought against several companies, right? And those numbers look different, and it can be tricky when you're looking at individual companies. And we see that with the E&I case in Italy, some of those things, right, of how you address those issues. The other piece that's important to understand is that the HEDI data set is including scope 3. And the courts, we've had strong wins to include scope 3, but I think the debate in court that the companies would bring up is whether or not you include scope 3. If you don't, then these numbers look really different. So again, I think we have scientific and legal reason to include scope 3. I don't think that's a debate, but that is something that would come up in the courtroom for sure with this type of research.
Do you want to add something?
Yeah, I think from a litigation perspective, this IRIS case is linked and supported by insurance brokers and US litigation law firms. So there is a real interest on that. Moody is creating a model about climate litigation liability modeling for reinsurance from a legal perspective. So even though it's not massively available, it's brewing there, like the idea that eventually, mainly because of the circumstance of the litigation from this strategic perspective, eventually when determined cases will go, then it will ramp up, basically following the model of asbestos litigation or tobacco litigation, which also leads to the question that you were saying, that science can be challenged. And yes, they will be challenged, and the defendants will have models that said completely the opposite. So that's the world that we live. But and also in this context, as we know that now science can be challenged because for different reasons, political reasons, let's say. But yes, so there is a challenge. But I mean, at the end, the idea is that the more and the bigger and the better, the argument will win on its own. So I feel that we're aiming the right direction. I hope.
We have to hope that facts or scientific
Sorry,
observation.
there is
Can I add one?
Yes, of course, of course.
Yeah, so I just wanted to sort of call attention to, I know I mentioned the Climate Judiciary Project to everybody at the beginning of the day. We just published last week sort of a primer on attribution science that I think would be really useful for everybody, on the idea that there's been a ton of climate science attribution studies published in the last couple of years. And so one of my colleagues sort of went through and talked about all of those, and I'm sort of drawing your attention to that. We also published a module on climate litigation in Europe that talks about the UU versus RWE case. So if you're interested in that. And last point I want to make is just from the litigation perspective. I know there's, you know, your question about like, why don't we just sort of use these tools if they exist? And there's literature out there to suggest that, you know, lawsuits are not incorporating the state-of-the-art science a lot of times. And so I do think there's a study on the evidentiary gap that exists in litigation between consensus studies and some of the state-of-the-art stuff. And so I do think there is some room for what's being used.
And the publication or the primer you mentioned is on the website, ELI's
On the
website?
website,
Okay.
cjp.eli.org.
Perfect. Thanks for that
You're welcome.
addition. So any further questions? And again, I'm mindful that there might be some online.
Yeah.
Do we have some already? A very specific one. Is it okay if I take one or two from online while our in-person audience collects further questions if they have any? So there was one from, it doesn't matter, I'm done, but a greenwashing case in Brazil initiated by IDEC against Go, which is an airline, and Localiza, which I don't know. But I don't know if there's a question there.
Yeah, I feel that.
It's more like a comment, you know?
Yeah.
Yes, please, Amelia.
So this was really great, interesting. Thank you. This question kind of gets at, while we're talking about gaps, the space between standing and attribution science, which I see as attribution science having a level of scale, and then like a broader scale, and then have to get into court sometimes, bring it down to a very local focus to support standing. And so sort of what are your thoughts about connecting those dots, how the science is developing to help do that? And then the flip side would be, do you see value in, or are you aware of efforts to empower communities to recognize climate impacts that are happening to them as climate impacts, or sort of training communities to recognize and include those from the ground up to bridge the gaps between sort of the very sophisticated, complex science and experience. And I guess the German case is an example of bridging those areas, but I would, litigation perspective, see that as an area of ongoing development in the law right now. So I'm interested to hear your thoughts. Whoever wants it, sure.
Ladies first.
So the environmental court in Chile considers science a little bit. So for the environmental tribunals, the climate change, for example, is an evidence. So they assume the climate change exists. So, and sometimes in some cases, the tribunals said that it's an evidence the climate change is here. So after that, sometimes, for example, in a case where a mining company work in the mountains and affect a glacier. The tribunal compares this glacier with another glacier outside in the zone affected by the mining company activities. And this methodology conclude that both glaciers are small than before. So it's climate change. It's not the mining activity. So, but the tribunal don't consider all evidence existing in Chile. So we start to consider that, but not a lot.
Yeah, so to the scale question, so it's true, the majority of the source attribution that exists is at the global scale and it's looking at global data. The wildfire study, their wildfire weather study that we published was the first one to do regional downscaling. So to be able to take some of those models and look at a specific region. But again, that's not, we're not looking at a specific city or a specific community. But so the science is advancing to get more local. Alongside that, though, I think it's really important that we're asking questions about what science is really needed for these courts, right? So we can't expect there to be a local study for every single event that happens. And I don't think that we need there to be. So different jurisdictions and different courts require different standards of evidence. And we really have to ask, like, what's the least amount of science that's needed to answer the questions that those courts need? And often, I think kind of the global scale, at least on the source attribution side, should really cover what is needed for a lot of those questions. That's different on the event attribution side, and event attribution can be much more local, and as well as impact. So we already have studies that show in the US at a census scale what economic costs of flooding from sea level rise have been. Again, this is something that we create data disparities though, right? This is something that is possible in places like the US, and it's not possible in places where you have data gaps or you don't have that data available to model those things. So we also have to be really careful about how localized we get the science in some ways and make sure that we're not limiting courts in other areas because there's a new standard of evidence that's being required by courts, right? So I didn't say that very eloquently, but I hope you get the idea there. So I think there's really important play between the two communities that we need to be talking about in that space.
Yeah, also regarding the communities that you brought the point, I feel that, I mean, there is a sense, in reality, communities have more knowledge that we as a Western acknowledge, like the communities that live in the jungle, they really understand weather, and then they know that the climate change is a thing. So it's not that we need to go then and explain to them. It's a matter of, they don't go to court because they don't believe in the system. There is a legitimacy issue, especially from the global north in their courts, and even more in the global north. No one from Peru will believe that a case against a German company in Germany will win. So I feel that it's not the science that is missing the piece there. It's creating the environment where people feel and believe in justice. Because at the end, the reality is we're having high hopes, but we don't have justice yet. So it's a hard sell.
Thanks. Any other one?
But maybe if the tribunal has scientific evidence, local knowledge is not possible. Don't consider scientific evidence. So it's maybe local knowledge is less strong than scientific evidence.
True.
in a concrete case.
Thank you all. Really interesting. My question, I think, is for Delta. I'm trying to understand the consistency of source attribution. So, if I understand correctly, the proportionate role of anthropogenic GHG emissions varies depending on the trend. So, temperature increase versus sea level rise versus frequency of floods, whatever. But you also showed a slide that had the sort of top of the 19 list with Saudi Aramco at the top. Would it be that Saudi Aramco is most responsible for each of those trends, or does that vary?
Yeah, so you're right. So the proportionality, what changes is the physical dynamic of how those events are impacted by greenhouse gas emissions, right? So most of the cases that we see are heat, because modeling heat is the most closely tied. So events that are connected to heat are most closely tied to emissions. So scientifically, those are the strongest cases. You're going to see the same general order. That's absolutely true. It's just that those numbers are going to look a little bit different depending on the type of impact that you're looking at. And even as you see, right, so for heat, you had upwards of 50% of all heat to those 90 companies, but for sea level rise, it was only upwards of 42%, right? So there's differences there. So while you might have 3% of responsibility for a Saudi Aramco on heat, you know, for ocean acidification, for the different events, it's going to look different. Yeah. Does that make sense?
Yes.
Okay.
Anyone in the room? Still, Ivano,
Maybe if I can.
of course.
But okay, one for Rodrigo, and then I will try to. So, Rodrigo, I really appreciate all your presentation. I just want to understand how much we can use this case that in a way is a case against a German company in a German legal system in Peru. Is something that we can really learn. And this moment, my real question is, in this moment, the legal doctrine, the legal scholarship, the judges are taking into consideration this case that, you know, it was 2 weeks ago, the hearing, so we know that we don't even know how it's going to end in the next weeks. So it's something that is moving in Peru, considering that you are at the origin of this case, at least physically, and there is the possibility of a sort of cross-fertilization in Peru in terms of legal innovation, or do you think that?
Yeah, well, there is a saying in Peru that says no one is profiting in his own land. So
Yeah.
A lot of people know about Saul's case outside Peru, ironically. But answering that, yes, I feel that there is a point about understanding how an argument used in court in some country can be used in another court. I mean, there is not direct specific scientific connection, but there is, especially when you talk about global circumstances or countries that people on the global south look for in the civil legal system. So if an argument, well-defined argument, is used in a court in Germany or in Spain or in Italy, judges in Peru tend to accept that argumentation. So even though there is no direct clear connection, the reality on the ground is if everybody is accepting, then the judges are more keen to accept. That is a point of truth. So, and I feel that it's the same other way around. Like this right of nature, again, 10 years ago, it was kind of like ludicrous until some countries included into the constitution, and there have been cases that moving forward. And I just had in the BIICL event that we launched that you invited us on London, I had a conversation with Mark, with a barrister from London. He promised his daughter to do a case to save jaguars because his daughter loves jaguars.
Yeah.
So he's like looking forward to bring some argument in the UK court about the rights of jaguars. So where is he going to get that argument if it's not from courts from the global south? So it's a cross-pollination, and it's not a direct path, but there is.
Then Marquez is a great lawyer that was also behind the Climacinerian case.
Yes.
So we know that, when he wants to do something,
Exactly.
he contribute to do something great.
Yes.
But yeah, anyway, it's a great, and I take advantage that I'm still speaking, so I'm asking also the other speaker a question. So I would like to understand from Delta, because, for me as a lawyer, attribution science, even though I'm really trying to use as much as possible and to study, I want to understand if it's possible that attribution science can help us identify major emitters operating, for example, in a particular country like in Peru, and if we can establish the contribution to that particular country. I mean, I know that climate change is global, but there's something like this, or?
Yeah, so the closest thing that we have to that right now is that wildfire study, which is, like I said, that's the first time that we have regional downscaling. So it's the first time that instead of looking globally at how emissions, so to the first part, you can take emissions from any entity. It can be a company, it can be a sector, it can be a country. Like, as long as you understand what those emissions are, we can put those into the models and understand. So if it's all of the companies in one country, as long as you have that data, then we can absolutely do that. The question then is about how it traces to impacts. So the majority of the studies that are out there are looking globally. The wildfire study was the first one to look regionally, and we are looking to continue to advance that. So we have some other studies in the works to continue to look regionally. But the questions there become these data limitation questions. So it's a question of, do you have the data in that region to be able to downscale the impacts, to be able to make those connections? So I don't have a straightforward answer for you.
So regionally, but nationally is not still something that we have done.
We haven't, no. So even with the regional one that we did, it was a part of the US and Western Canada. And it has to do with the physical characteristics. So those climates were similar. So essentially we were able to use the same mathematical relationship to make that calculation. So if there is a lot of diversity within a single country, then you're going to need several different models to be able to assess that.
And sorry, Pilar, just to ask you something that I was thinking since the beginning of your presentation, because in a way I was thinking of what Michael Gerrard this morning mentioned, which are these backlash cases, the slap lawsuits. And so in a way is related to the fact that we were talking about the different actors, that we had the different plaintiffs. So have you observed in a way some sort of tendency also in Chile of from the part of these companies that want in a way to avoid this kind of litigation, and so they are trying to bring suits against, for example, NGOs. We have example in France with Greenpeace against, for example, Total. In Italy, it's any that goes against, of course, Greenpeace and the others. So in a way, we see that there is this trend of companies that's trying to protect themselves by attacking for defamation these NGOs. So do you see something like this also in Chile, or it's not that it's not happening yet?
Yes, a little bit. We have a case, but it's not a climate change case. It's a Dominga case. It's a mining in the sea, in the ocean, Pacific Ocean. And in this case, the company put a lot of money to talk to mal or to against the NGOs, which defend the ocean. So that exists, but it's a little bit, because the environmental cases and climate change cases is related with more adaptation than mitigation. So it's a little bit different. Yeah.
But might be interesting also because when we're starting working on that with Chile, it's also interesting to understand how much, we have to be careful about that part, because, corporate climate litigation, as I was saying, is also a definition, a sort of terminology that we want to use, just to say that we are not talking about climate litigation against corporations, just to create, two fields, but considering that they are part of the solution. But it's true also that we decided to call corporate climate litigation, the object of this study, because we know that there are the slap lawsuits and all these backlash cases. So we have to understand that they might be also the plaintiffs, and there are many cases in this moment, that, especially in the US, that have been brought by them. So that might be, Anyway, thank you very much.
Thank you.
We're looking in the room. I have a question for each of the panelists, so maybe that'll be the last round, unless there is one more, which I'm sure we could still fit. Now let's go in. And I'm curious to sort of take some of the observations, et cetera, from, we've been backward looking, kind of the progress, the developments, a lot of which is really very positive, to the world or the situation we're entering in now. And the first one is to you, Pilar. So expanding access to justice, expanding the circle of those who are considered to be, whether it's individuals or public interest groups, et cetera, something that's been a decadal process in Europe. We had the Aarhus Convention, and so it's really been something that's been moving in the right direction for many years. But now in recent years, and really just, I would say, in the last 3-4 years, we've been increasingly hearing that actually the energy transition, the green transition has been held up increasingly not by technology availability, technology costs, et cetera, but by the difficulty of permitting and citing any large clean energy project, infrastructure project, et cetera. And so at least in advanced, whether it's North America or Europe, there's really been a debate about rolling back some of the public participation and access to justice rights that have been created over recent decades. And so I'm curious, do you observe something, since you were speaking about legal standing and access to justice in Chile, but also the other panelists, how do you see that potentially playing out, since there has been that trend? The second question is more than perhaps Delta and Rodrigo, but again, all of you, please feel free to weigh in, and from the audience as well. So you kind of hinted, it's so important to have robust emissions information. So emissions transparency in order to construct particularly the source attribution part of this equation. And there too, we're seeing a rollback, whether it is, like in Europe now, Milieu Defense, you mentioned things like the Corporate Sustainability Reporting Directive. You might have seen that the EU is now having a political process to push that back because it's seen as kind of counter to business in Europe, competitiveness of European business environment, et cetera. The SEC disclosure rule, Michael Gerrard mentioned, that's most likely going to go out. So that we may be entering a world in which at the policy level, at least the emissions transparency will be a little bit less transparent. But I also think we can safely say that in the US, at least, there's active destruction of data repositories and institutions and institutional capacity that has helped us better understand emissions reporting and emissions from companies. So how do we deal with that? Do you see that as a real risk going forward? Or do you think institutions, organizations like UCS, universities, et cetera, have enough of this data? And finally, it seemed to me like, you mentioned 2017, was it Landgericht or, climate attribution science back then was a very different thing from where it is now. So it's improving so rapidly. Does that introduce, you hinted a little bit that you could also have a dynamic where almost tactically you're like, should we file now? Should we initiate lawsuit now? Or will we have better data in a year or two? Will we be better able to create, the causal connections? That's another thing. I'm also curious, how does this sort of progression of the scientific basis influence strategy and tactics in litigation? So number of questions, but
so that's right. The last decade, maybe the public participation was fundamental. For example, that's allowed stop big projects in Chile. So hydroelectrics or thermal coal plants or others. So it was very, very important to define the type of economic growth. But now it's the first time I see that exists a consensus in the political context. It's not possible to open to public participation because that stops the development of the country. So it's necessary to go quickly with the investment and the project. Mm-hmm. So it's maybe that will change or not, I don't know. But it's a critical moment to the public participation because the Congress discussed to reform the laws, the present laws concerning public participation in different areas. So yes, we will see.
So it's not just Europe, North America, it's also in the South.
Yeah, so I mean, science generally is as good as the data that it has. So it's a huge thing for us to be looking at, a huge concern. We have people on our team who actively works on disclosure specifically, because again, we need the data to be able to do the scientific assessments that we do. I think the one saving grace again is looking back to how this data was initially collected, and it was through reporting to shareholders. You know, these are the business's best interests to show their growth over time. It's those places that the data actually comes from. I think part of the concern becomes will come moving forward, will actually be different reporting methods that companies will use to share that information with their shareholders, and us being able to interpret what that actually means. So yeah, in short, it's devastating. It's really hard for there not to be strong disclosure rules, that it's necessary for us to understand the role that these companies are playing. But I think we've figured out workarounds before, and the communities will continue to do that.
Ironically, I'm gonna link both questions that I feel it's very different from the red tape, from the reality. So the case in Peru, for example, they've been pushing forward to get the Espoazú Accords, which is kind of like a parallel to the Aarhus Convention regarding environmental defensors and especially protecting access to justice and information. And eventually the Congress didn't accept the accord that we were pushing, because the argument that they will go against the mining industry in Peru, which is the heartbeat of the economy, in a nutshell. But the reality is, with or without the accord, with or without the law, the people will object. The people will go out. They will block. They will burn if you don't have what it's called the social license. If you don't have sustainability from a broader concept, then no matter what you do, then it's over. The biggest gold project in Peru has been blocked for 20 years. Like, they have all the licenses, all the presidents wants to do it, all the majors want to do it, but the people doesn't want to, and it's not gonna happen. So no matter if you have or not, the reality is gonna build on you. And I feel it's the same with disclosure and information. There is a point about how this trend, it's pushing forward the agenda of ESG or disclosure or being green, but I feel that also it's just cleaning some bad elements. There was a lot of greenwashing in the world. There was a lot of just entities trying to just comply with the law, do any report that it was meaningless, no connection whatsoever what they do. So you have a lot of data, but not relevant data. So now it's going to become to the point that the people will say something if they mean it. And if they don't, then they will have to accept the consequences of not being completely honest or not being real, or just saying for the sake of it, just because they need to comply for some random law in the other side of the globe that they don't believe in. So I feel that it's a silver lining about the reality will mandate eventually, and circumstances will pass.
Good. I like that message. It's not a straight line, but we're still optimistic, and then we'll get in the right place. Join me in thanking our excellent panelists.
Well, welcome back, everyone. Thank you for the lively, engaging discussion so far. I'm excited to be joining you again as your moderator. You don't remember me from panel 2. Sabin Perry, a staff attorney at the Environmental Law Institute. I'm really excited to be joined both in person and online with our group of panelists for today. They will be giving some concluding thoughts on the day, as well as looking for future directions for corporate climate litigation across the Americas. So we'd like this to be interactive, engaging. They'll give a brief reflection on the day, looking forward, and then we'll have time for questions and discussion. So I'm going to introduce all 4 panelists now, and then move into their presentations. So our first panelist is Randall Abate, and he is the Assistant Dean for Environmental Law Studies at the George Washington University Law School. Prior to joining GW Law in July 2022, he held full-time law school teaching and leadership positions for 3 decades at 6 U.S. law schools. He has lectured and taught courses in more than 25 countries on 6 continents. And if you're connected on LinkedIn, you will always see him going around, but he travels quite a bit. He has published 6 books, including Climate Change and the Voiceless, Protecting Future Generations, Wildlife, and Natural Resources, and more than 40 journal articles and book chapters. He holds a BA from the University of Rochester and a JD and MSL, Environmental Law and Policy, from Vermont Law School. Thank you for being here with us. Our next panelist is joining us online, and this is Dr. Maria Antonia Tigre, and she is the Director of Global Climate Change Litigation at the Sabin Center. She manages the Sabin Center's Global climate change litigation database with the support of the Sabin Center's peer review network of climate litigation. She is a leading expert in the field of climate change law and climate litigation, having published dozens of articles on the topic. She also co-heads the Sabin Center and the Global Network for Human Rights and the Environment's project on climate litigation in the Global South. Her research particularly focuses on rights-based climate litigation in the Global South, and the forthcoming advisory opinions on climate change. As a member of the IUCN World Commission on Environmental Law, she actively contributes to developing and advancing environmental legal frameworks. She has authored numerous publications on regional and international environmental law with a specific focus on environmental rights, the evolution of international environmental law, and climate litigation. Her research also encompasses the protection of the Amazon ecosystem, emphasizing the importance of regional cooperation. She completed her doctorate in political studies, SJD, at the Elizabeth Hobbs School of Law at Pace University in 2022. In 2013, she earned a dual LLM, magna cum laude, specializing in environmental law and comparative legal studies from the same institution. She obtained her LLB from the Pontificia Universidad Católica of Rio de Janeiro, Brazil. Thank you for joining us online. Our next speaker will also be joining us online, Rosalia Ibarra Sarlat. She holds a PhD in environmental law from the Alicante University from Spain, a diploma in advanced studies with recognition of research sufficiency from Alicante. She has a bachelor's degree in law from the law school at the National Autonomous University of Mexico, diploma in environmental law at the Bar Association of Madrid, Spain, and legal advisor to the Environmental Law Center, ELC of the IUCN. She is a full-time researcher at the Institute of Legal Research at the National Autonomous University of Mexico. She is a professor of environmental law in the postgraduate law school at the same school and coordinator of the seminar Climate Change Law and Governance at the National Autonomous University of Mexico. She is also a visiting researcher at the Center for Environmental Law Studies in Tarragona at Rovira Virgil University. She's a member of the National Systems of Researcher and a member of the Mexican Network of Scientists by Climate. So thank you very much for joining us. And our final speaker today is Maria Juliana Pedraza, and she is a bilingual attorney dedicated to delivering exceptional legal services and making positive contributions to society and beyond. She holds a Master's of Laws with a specialization in international legal studies from American University, Washington College of Law, where she is honored with the Outstanding Graduate Award from the LLM class. Prior to that, she pursued specialization in business transaction law and relations at Universidad Externado de Colombia, following her bachelor's degree from Universidad Autónoma de Bucaramanga. Her work experience spans various sectors, highlighting her adaptability and proficiency in government, supporting the legal processes of regional development plans and assisting environmental and social projects. In the financial sector, offering comprehensive legal assistance and guidance on banking and financial operations, further demonstrating her adaptability and expertise. She is currently working as an associate attorney at the Inter-American Institute on Justice and Sustainability. Thank you for being here. And without further ado, I will turn it over to you, Randy.
Thank you so much, Christine. It's great to be here. Thank you to Ivano and Michael for this invitation and really a very impressive round of panels and topics today. And not surprisingly, there's going to be some overlap, but the idea is to reinforce and highlight in this panel what you've heard and integrate it in a way that will hopefully generate some discussion. So you heard from Gerrard about waves of climate litigation earlier today, and I'm calling them the lines of climate corporate accountability litigation. So I want to give you kind of my take on these different stages of where U.S. climate litigation has been, and highlight some things that you haven't heard about each of these stages and their significance for corporate accountability theories, and briefly mention some obstacles to success in these efforts. So the first, third, and fourth here are most relevant to our discussion, and you've heard a little bit about each today. I want to try to get into some pieces of what we haven't heard as much about. I include the atmospheric trust line of cases just very briefly for context as part of the evolution of these cases, even though that was against governments, the US government and state governments, and not against corporations. It's still relevant to get a sense of how these theories have evolved. So you've heard about two of these cases today. So the American Electric Power case versus Connecticut, the first public nuisance case, is something that Mike Gerrard described very well for you. One thing that I want to stress about that is the pivoting that happened, going from the American Electric Power case to the next two cases. So basically, American Electric Power versus Connecticut was seeking injunctive relief. And even as a hopeful and optimistic environmentalist that I am, I wasn't sure that this was the right way to get climate action in the US. This was using the court system to essentially compel a percentage reduction in these major power companies' emissions of carbon dioxide. These were the leading emitters that I think represented 25% of carbon emissions in the US at the time. And the effort was to have an injunction lowering their emissions by a certain percentage. And not surprisingly, this was dismissed in part on political question doctrine grounds, because this was perceived as something the legislature should be doing and not doing an end run around the legislature, you know, when dad says no, ask mom kind of a thing. I mean, this is supposed to be done by the legislature. If we're talking about emissions reductions across sectors in our society, that's something that the Clean Air Act is available to do, and didn't happen there. And so this effort to get it done through the courts was a good way to convey the urgency that we need these reductions in addressing climate change effectively. But the political question doctrine dismissal of this case was disappointing in some way, but not surprising. This federal displacement theory, the idea that you've got the Clean Air Act, therefore these federal common law claims should be considered displaced. Okay. Where I was much more troubled is when this theory pivoted to not seek injunctive relief, but to seek damages. Now I was more on board. This made much more sense to me. So the first case, the Comer case, which was the case involving Hurricane Katrina victims that brought a lawsuit against corporate entities for their significant contribution to climate change, which in turn exacerbated the intensity of Hurricane Katrina that ultimately affected and displaced these plaintiffs that were seeking recovery for the losses they sustained from Hurricane Katrina. And that's not to say that these emitters caused Hurricane Katrina. They just made it worse than it might have been because of the influence of the warmer waters from the higher greenhouse gas emissions. So this actually didn't do so poorly in the courts. It was ultimately dismissed on different grounds, but ultimately it did prevail at the trial court and then went up on appeal and was ultimately dismissed en banc. But here, the fact that it was seeking damages, and this wasn't the very first case, but it was building on another case against auto manufacturers that was filed previous to this one. The idea was that damages are not necessarily the same thing as seeking injunctive relief, and therefore compensating these victims for their losses is a different thing than asking the court to issue an injunction and regulate climate change from the bench. So that case ultimately did not prevail, but it showed some promise. So when Kivalina came along, I felt much more hopeful that this might be the sweet spot. We're using this theory, and again, it is involving communities that, in this case, a Native Alaskan community that are burdened by the effects of climate change same kind of group of defendants, about 24 oil and gas companies significantly contributing to global climate change, making this sea level rise and coastal erosion that you see in this picture in northern Alaska more severe, life-threatening. And this was, interestingly, an opportunity to expand the standing that had been established in Massachusetts v. EPA. The idea that there, the state of Massachusetts was able to have standing because of that special solicitude reasoning. The court acknowledged that the state has standing on behalf of its citizens to sue for the loss of coastal land in the state. So here we had a federally recognized indigenous people that has a quasi-sovereign capacity, very much like what we saw in Massachusetts v. EPA. And I thought the standing theory could have extended quite appropriately to this Native Alaskan community along the same lines that it had been established in Massachusetts v. EPA. That was not the outcome. So that's one piece that I wanted to highlight here, that this case was dismissed, trial court and on appeal, on standing grounds. But perhaps most memorably about the standing decision was the idea that causation was not established. And this is what ties back to Delta's presentation and what I'm trying to learn as much as I can with my philosophy major background, trying to understand climate science. Is to call it a steep learning curve is an understatement. So the causation standard for standing is very loose. You know, this is not cause and fact. This is not proximate cause. This is fairly traceable. There must be some kind of relationship from the action or inaction of the defendant and the harm suffered, allegedly suffered by the plaintiff. And here, you can imagine the attorney for ExxonMobil standing up in court and pointing to this photo and saying, there is no way to connect that coastal erosion in northern Alaska to my client's emissions. And in 2007, that was absolutely true scientifically. Perhaps in 2025, with Delta's confirmation, we might have a different outcome on that standard anyway. That fairly traceable standard, what we know about attribution science now compared to 2007, this might have survived in terms of going to trial and not being held to be limited on causation grounds because it is such a flexible standard. So it was also dismissed on jurisdictional grounds, not surprisingly, the whole political question doctrine arguments all over again. The postscript here is another thing that I want to mention, in the sense that here's how, even though this case raised so much good publicity about the need for vulnerable communities to get relief from somewhere. I mean, this was a community of 400 Native Alaskans that had a price tag of $400 million to relocate them 10 miles inland, and the federal government was not providing that money. The state of Alaska was not providing that money. So they filed this lawsuit as the last ditch attempt to get some support for their survival. They were given this essentially, death notice that they had no more than 20 years to live there without being submerged. And mind you, that was 20 years ago, and they're still there. They're still trying to, in a piecemeal way, get themselves out of harm's way. But just about a year and a half ago, because there was no action, 20 years after this failure in this lawsuit, they filed a petition before the Inter-American Human Rights Commission, along with some other indigenous communities around the US who had similarly been ignored, about the need for climate adaptation and relocation assistance. And that's where we are today. I mean, you literally have to grasp at any straw if you are being disproportionately burdened by climate change impacts affecting your human rights. You just have to, resort to anything. And this reminds me of how a lot of this thinking got started with the Inuit petition way back in 2005, framing this problem as climate change, but human rights as much as it is climate change. So it's interesting how far we've come and how far we have not come when you look at 20 years of strategic climate litigation. And then you've heard a bit about what I'm calling the BP v. Baltimore line. You've heard about cases that are part of this group of cases 38 apparently, according to Mike Gerrard. I've lost count, but that's higher than I thought. Around the country, states, cities, counties suing that same set of about 24 carbon majors, whatever we're going to call them, for their contribution to what these states, cities, and counties are experiencing in terms of climate adaptation costs. They didn't cause this problem. They're having to build seawalls. They're having to engage in mitigation plans to adapt to wildfire threats. All of these things cost a lot of money, and they're seeking contribution from these large emitters to address those concerns. So the creative theories here is something that you've heard a little bit about, and that's something I want to continue to look at as these theories unfold. But it was really telling that there was so much evidence about what they knew, when they knew it, and what they did with that knowledge. And that whole evolution of climate denial science was very much part of this evidence, and it's really, really powerful. So you've heard that these are starting to get to trial. Win, lose, or draw, this is a huge success. When this information goes to trial, it's going to be transformative. And we're almost at that stage where it is so widely known that it's having a big impact on how these corporations are going to have to do their business. The postscript that I want to add to this line of cases is just a few weeks ago, the Supreme Court rejected a challenge by Republican states trying to keep these cases from going to trial. So this is very much reminiscent of what we saw with Juliana. Juliana was another case where, I mean, it was like an advanced course in civil procedure, trying to follow what the federal government was trying to do to get that case from not going to trial. I mean, procedural motions I hadn't even heard of, unprecedented efforts that the federal government engaged in to keep Juliana from going to trial. This is something I also hadn't heard of the states trying to get this kind of a case from proceeding to trial, but it failed, thankfully. So that's where we are. It's looking hopeful on that front. And this is just a summary of the information about why these cases are so strong when they get to trial. There's just really potent legal and scientific evidence at their backs to I think, do well in trial. I don't make predictions about climate litigation. I learned 20 years ago not to do that, but it's essentially about as strong a case as I've seen studying these cases for 2 decades, in terms of not having a standing concern, not having to navigate around that federal displacement barrier and so forth. So the climate washing line is something I'm going to get into more tomorrow if you're going to show up online for that discussion. But I did want to talk about how this builds on the BP Baltimore line, in the sense that it's very much about that deception, and how the deception is part of the accountability in that effort to seek damages, but it's also a separate legal theory to hold them accountable about how they're communicating with the public about what their practices are all about. So there are some cases that I'll go into more detail on tomorrow, but there was a discussion earlier today about what greenwashing cases have happened, have been successful. And there's certainly a wide scope of what these cases involve. There's product cases, there's cases that talk about action or inaction. And so one product case that I wanted to just throw out there, and I say it because I'm a plant-based eater, and so I'm a big fan of oat milk companies. And there was a lawsuit against Oatly, some company I support. I don't think of them like Exxon Mobil, but they overstated the purported climate or carbon footprint benefit of drinking oat milk compared to traditional dairy. They said it was like 75% better, and it was only 50% better, and they were held accountable for that. That's misleading. And I'm all for that, don't lie. It's not nice. So we're seeing this with other efforts in all aspects of what climate washing is about. So I'm going to get into this in tomorrow's discussion, but I think it's important to know that these 3 categories are really what we're looking at when we categorize the climate washing universe. And we'll certainly be able to talk a little bit more about that tomorrow. Different theories, that have been used here. And so as far as obstacles to success, I mean, these are things that we've heard about all day. I wanted to highlight a couple of things, just remedies and causation very briefly. So with remedies, one thing that really stalled the atmospheric trust line of cases, and again, I agreed with it. What the youth plaintiffs were asking the federal government to do there was create a climate recovery plan. Again, this is not something for the courts to do. This is for Congress. And so even though I fully believe that these youth plaintiffs deserve to have a climate change law that's going to protect their futures, the remedy there was a problem. It was dismissed for lack of redressability. Causation at trial is another thing to think about. I mean, if we've got cases like Kivalina getting thrown out, not even meeting the standard of causation at standing level, the causation at trial is significantly higher. So that's also something to think about in terms of barriers. And you've already heard about the slap suit concern with that, the reference to the Dakota Access Pipeline decision against Greenpeace recently. So I'll stop there. Thank you very much. Look forward to your questions.
Thank you. And now we're going to go online for Maria Antonia.
Hi, everyone. It's a big pleasure to see you. I'm really sorry that I can't be there in person. I had a childcare emergency and couldn't come. So, it would have been really nice to be there and meet all of you in person and have a proper chat. But here we are. It was really interesting to hear from all the speakers today, and I'm gonna try to talk about a couple of aspects that stood out to me with respect to South America. I'm from Brazil originally, even though I've been here in the US for over 13 years at this point, and I manage our climate change litigation database at the Sabin Center. Professor Gerrard mentioned it this morning, sort of how the numbers are increasing quite a lot, as well as the regional diversity. Coming from Brazil, I'm obviously particularly interested in cases from the Global South and trying to give visibility to cases in the Global South. So I've written quite a lot about Latin America, in particular, climate litigation and Latin American climate litigation in the Global South as well. And what's interesting, I think, to see is that, there isn't too much on corporate climate litigation yet, even though there are, as was mentioned throughout the day, several sort of avenues to pursue that and some examples of cases as well, but not a lot of decisions yet. So I think it's good to see from that perspective that everything's still sort of blossoming in a way, and there are a lot of interesting things happening around the world that could be, from a comparative perspective, replicated regionally, as well as some other topics. So I'll talk a little bit sort of about all of that. I think, similarly to the rest of the world, there are lots of cases related to environmental impact assessments and permitting procedures. And I think that sort of has been the traditional and unsexy piece of climate litigation as it developed. And these cases are usually brought against, the government bodies that are responsible for the permitting procedure, as well as in some cases corporations as well. So a lot of sort of the traditional corporate climate litigation that has happened in the region relates to these types of cases. We haven't seen yet a lot of climate washing cases, which it was just mentioned as well. And as far as I know, we haven't seen any type of sort of the ambition type cases like the Shell Milieu Defense case either. Although there are obviously conversations about that. I think Brazil has a couple of interesting examples. Daniele mentioned this morning potential cases related to climate disasters, which could certainly change the landscape of cases as well. And Brazil also has a lot of pending cases related to climate damages, which have been brought against individuals that cause deforestation in Brazil, as well as some corporations in certain cases. And I think that is really interesting to see. And I keep mentioning these cases as really really crucial examples, because there really haven't been a lot of climate damages case around the world. So Indonesia has a very limited number of cases, and there's sort of early cases. The methodology to assess those damages is very different than what's being proposed now. The numbers are, it's a different scale from these types of cases that exist in Brazil at the moment. So I definitely think these should be studied from sort of a wider perspective, beyond Brazil. There are language limitations for sure, for scholars outside of Brazil to understand them, but I think it's really crucial to see that. And there was a whole talk about the Peruvian farmer case as well earlier today, which, even though it's a case based in Germany, it has a transnational aspect that's really interesting. And potentially could be replicated if that case is successful. A judgment is expected next week. So everyone's in 2 weeks, I think, actually on the 14th. So everyone's sort of expecting, waiting for that and to see what's happening. But I actually just heard recently that some people in Germany think it's very likely that the case will be dismissed, which I think will sort of be on the opposite end of the expectation that's been going around sort of this community. So we'll see on that. But I think the interesting piece of that is obviously we're holding companies in the global north responsible for the damages that are being caused in the global south. So there's a way to sort of address that type of north-south disparity with respect to the climate injustice aspects as well, which is really interesting. And there's a similar case in Switzerland that was brought by community of fisherwomen and from Indonesia. So it's sort of a similar type of model, but obviously testing out this theory in another jurisdiction as well. So another thing that I wanted to mention that I tried to follow as much as I could today, but I didn't hear anything on that, but maybe I missed it, but is on just transition litigation, which I think is really, starting out in around the world, sort of in like a new-ish type of climate change litigation. And it's sort of like a weird animal in a way, because I think traditionally climate litigation has been defined as sort of the, categorized between the pro-climate and anti-climate cases. And I think it has become so much more complex than that initial assessment. And I think just transition litigation is a big piece of that, right? It's a big, it's a good example of like neither here nor there, right? Because just transition litigations really relates to cases that are brought by communities that are being, can be workers traditionally, but also indigenous communities, traditional communities that are being impacted by projects that relate to an energy transition, right? So these could be, solar projects or the critical minerals projects as well. And a lot of the critical minerals are found in the global south. And it's, there's this real danger that we'll sort of just replicate some of the mistakes of the past of during the fossil fuel boom of actually failing to consider all the human rights aspects that need to be observed during this energy transition as well. And losing sight of obviously we have this goal of the energy transition. We have net zero goals around the world, but really it's crucial to do this properly and not lose sight of the human rights that are being impacted by these types of projects as well. So we wrote a report, maybe it's like 2 years ago at this point, on just transition litigation in Latin America, which really sort of starts conceptualizing some of these types of cases. There are more cases now, and I think there are a lot more that are not on our radar yet. These are not often brought in as climate cases either, even though obviously climate change is a piece of that, considering how these projects are really have this overarching goal of an energy transition to reduce emissions, right? So, but it's really interesting because then they're sort of comparing these types of cases, right? And these are, you know, some are brought against the government, and several, like similarly to some of the EIA cases, are brought against corporations as well. So I think that's sort of another piece of that I, at least now, I haven't really heard a lot of yet today. And then the other type of case that I wanted to mention too is cases related to carbon markets, which we have some in Brazil, and I think in Chile we have a few examples as well. So, you know, again, it's sort of like, it's a little similar to the just transition in the sense that, you know, these are usually REDD+ projects. These are projects that are, you know, have this overarching climate goal, but again, not being done properly. So usually these claims relate to lack of free, prior, and informed consent of indigenous communities, or really just like, you know, some people mention is as sort of a new type of colonization, because they are just using the land and to without the consent of the people that are actually there and protecting the forests and so forth. So that's sort of another type. There, you know, again, an interesting example in Brazil and in Chile too. So, you know, another type of like corporate climate case that I think should be, you know, people should pay attention to as well. And then the last thing that I wanted to mention, which was mentioned earlier today too, it relates to the Inter-American Court of Human Rights advisory opinion. I've been following these processes very closely, the ITLO's advisory opinion, ICJ, and the Inter-American Court. And the Inter-American Court's request for an advisory opinion was really the only one that specifically asked about corporations. What's the responsibility of corporations with respect to the climate crisis? And, you know, that largely relates to, you know, the processes that went behind asking for these advisory opinions. You know, for the Inter-American Court, there's a lot more flexibility. So the question is a lot, it's longer, it's more detailed, specific on a lot of issues, including, you know, loss and damage and migration and corporate responsibility as well. So, and it's a more progressive court as well in comparison to the other ones, which are more traditional in a sense, especially the ICJ. So it's more likely that the Inter-American Court will actually address this question of corporate responsibility as well. Again, it's an advisory opinion, so there's no obligation necessarily for countries to follow what the Inter-American Court says, but traditionally it has been it has a lot of weight. So a lot of Supreme Courts in the region have mentioned you know, the prior advisory opinions in their decisions. So, you know, and it has in some cases changed policies or influenced policies as well. So hopefully that will have a similar effect. South America has a big issue on implementation. I think it's something that bothers me quite a lot, because we spend a lot of time finding climate cases and analyzing climate cases and then looking at the decisions, obviously, but then it's really hard to track what happens in the aftermath. And you know, one of the big examples of cases, of climate cases, you know, against the government in that case, but in Colombia, the Future Generations case, there were a lot of reports in the aftermath from the NGO that brought the case that the decision was actually not implemented. And I think until this point, it hasn't been fully implemented yet, even though there's really been years since that decision. Since the court made that decision, so published that judgment. So, you know, it's not a problem that only happens in South America, the global South in general, but also countries in the global North face similar issues, especially because really some of those decisions really take years to be implemented. They require changes of policies, and so for corporations, it's a little easier in a way to have that accountability, because you know, it's easier for the government to track that. So, you know, that's sort of the last point that I wanted to make of how crucial it is to also like think carefully about the remedies that are being first requested and then granted, if that's realistic, if it's easily implemented or not, because it really can render certain decisions moot to a point, because sometimes, I think especially the cases against the government, what happens that the government doesn't really have the capacity to implement that according to what the court has said. So I'll leave it at that for now, and I'm happy to answer questions as well. Thank you.
Yeah. Thank you very much, Maria Antonia. So now we're going to go back online to Rosalia for an intervention from you.
Hola, ¿qué tal? Buenas tardes. Los saludo con mucho gusto desde la... Hola, buenas tardes. Los saludo con mucho gusto desde la Ciudad de México. Agradezco muchísimo la invitación a Ivano y a Michelle. Para mí es un placer compartir estas reflexiones en estos temas tan interesantes. Y pues bueno, voy a hablar en español porque me siento más cómoda hablar en mi idioma, sobre todo al tratar estos temas tan técnicos. Bueno, respecto a todo lo que hemos visto en esta mañana, yo quiero enfocar sobre las visiones diferentes que se tienen en los litigios climáticos, y en especial quiero aterrizarlo al tema de derechos humanos. ¿Esto por qué? Porque es el enfoque que nosotros aplicamos en México en la litigación ambiental y climática. Nosotros, en comparación con Estados Unidos, no tenemos un caso corporativo representativo. Estamos igual que Canadá, o sea, no tenemos un litigio climático catalogado en materia corporativa, porque, pues bueno, nuestro enfoque es más en derechos humanos, donde el principal responsable es el Estado. Digamos que en esta línea nosotros entendemos y nos vinculamos con este marco jurídico de Hawái, el que se destacó, en donde el derecho constitucional a un medio ambiente limpio y saludable es la base más sólida para las reclamaciones ambientales. Y eso en México nosotros lo entendemos porque es algo que nosotros lo tenemos como un marco jurídico bastante sólido y muy fuerte. Entonces, quiero hacer este comparativo de lo que sucede en México para destacar este enfoque que para nosotros es muy relevante y que por lo visto también es replicado en el sur global, como lo comentaban los colegas tanto de Chile, Perú y bueno, otros casos que se han presentado en Brasil, Colombia, etcétera. Para nosotros este enfoque de derechos humanos es primordial porque justo el Estado es el principal y obligado de respetar, proteger y garantizar los derechos humanos. Entonces, en este contexto, en México, los 22 casos que nosotros tenemos catalogados como litigio climático, que son pocos, vamos a encontrar que el demandado principalmente es el gobierno. Y lo demandamos ¿por qué? Por el incumplimiento de las obligaciones en materia de derechos humanos, especialmente por no cumplir con el derecho humano al medio ambiente sano, y esta inobservancia está vinculada además con la legislación en materia de cambio climático y normativa energética que regula la transición a las energías renovables. ¿Quién demanda básicamente en México? Las personas físicas, la sociedad civil acompañada de ONGs, organizaciones no gubernamentales que se dedican a la defensa del medio ambiente. ¿Y cuál es el recurso que nosotros empleamos para esta defensa como un medio jurisdiccional? Es nuestro juicio de amparo. Este es un medio de control constitucional en el que además nos da la vía de acción para buscar la defensa y protección de nuestros derechos humanos reconocidos en nuestra Constitución y en los tratados internacionales. Y ahí es donde nosotros encontramos la fundamentación jurídica sólida y de base para los juicios que tenemos catalogados en litigio climático. ¿Y esto por qué? Porque tan solo en México y prácticamente sabemos que en varios países de Latinoamérica hemos desarrollado ampliamente la protección del derecho humano al medio ambiente sano. En México nosotros lo tenemos reconocido a nivel constitucional desde 1999. Y nuestras leyes reglamentarias, lo que es la Ley General de Equilibrio Ecológico y Protección al Ambiente y la Ley General de Cambio Climático, Estas son reglamentarias de ese derecho humano reconocido en la Constitución, en nuestro artículo 4. Entonces ahí tenemos bastante bagaje y fundamentación jurídica, que es lo que justo se plantea en los litigios climáticos en México. Este marco nosotros lo tenemos sumamente sólido, muy amplio, en donde además se ha trabajado desde la Corte, en las Cortes mexicanas, en los tribunales, el análisis amplio del derecho humano al medio ambiente sano. Tenemos una interpretación amplia también del mismo, tenemos bastante jurisprudencia ambiental de cómo entender y aplicar este derecho, y además en México los tribunales sustentan esta interpretación amplia con lo que ha expuesto la Comisión Interamericana de Derechos Humanos, porque México, pues bueno, es estado parte de este órgano regional. Y en este sentido, en los juicios de litigio climático que se han presentado en México, ha sido sumamente relevante lo que se ha dicho en la opinión consultiva de la Comisión Interamericana de Derechos Humanos 23/17, en donde se establece la interpretación amplia de cuál tiene que ser la obligación del Estado para garantizar el derecho humano al medio ambiente sano, que en este contexto nosotros lo entendemos como un derecho que es fuertemente afectado por los impactos del cambio climático, y por eso siempre es la guía de acción legal en nuestros litigios climáticos, que obviamente se vincula con la vulneración a otros derechos humanos, como puede ser a la vida, al agua, a la alimentación, incluso a la vivienda, si es que hablamos incluso de casos de desplazamiento climático. Entonces, para nosotros es nuestra guía de acción los derechos humanos. Además de que nosotros en México, en esta interpretación amplia, en esta jurisprudencia que se ha trabajado mucho en nuestras cortes a raíz de los casos que se han presentado, también entendemos y aplicamos esas dos vertientes del derecho humano al medio ambiente sano, como es la individual y la colectiva. Y por otro lado, también aplicamos las dos visiones, que es la antropogénica y la ecocéntrica, lo cual esto ha sido ampliamente señalado en la opinión consultiva de la Comisión Interamericana de Derechos Humanos. Pero lo que quiero destacar es que en México nosotros empezamos a interpretar esto de una manera muy, muy amplia para resolver los casos en litigio climático. La visión ecocéntrica me parece que es algo que viene muy de vanguardia, justo para aplicarse no nada más en México, sino en los litigios climáticos que se empiezan a destacar y presentar en el sur global, porque esta visión ecocéntrica que empieza a evolucionar con mucha fuerza, empieza a buscar la protección de los elementos naturales por su valor intrínseco, y que en este caso, por ejemplo, contribuyen a mitigar los impactos del cambio climático, como casos que se han dado en Colombia para la protección de los páramos, por esa función que tienen para contribuir a disminuir el impacto del cambio climático. Y entonces se da la protección de estos ecosistemas por una visión de un valor intrínseco del mismo. Pero esto se vincula con la protección del derecho humano al medio ambiente sano, porque para proteger este derecho tenemos que proteger también el entorno y los elementos naturales, pero con esta visión ecocéntrica. Esto me parece que es algo que va a empezar a evolucionar con mucha fuerza y que se empieza a aplicar en los litigios climáticos, sobre todo en el sur global. Por otro lado, lo que también se discute mucho desde esta visión de enfoque de derechos humanos es la discusión de las acciones u omisiones que pueden tener los estados en la protección del derecho humano al medio ambiente sano, sobre todo alegando que estas pueden ser regresivas justo para cumplir con las obligaciones que se tienen en torno al Acuerdo de París. Porque también nosotros en nuestros juicios en México, la Corte ha interpretado el Acuerdo de París como un tratado para la protección de derechos humanos y por tanto ocupa una posición supralegal en el ordenamiento jurídico. Y esta conclusión de esta naturaleza es particularmente relevante para países como el nuestro, donde los tratados en materia de derechos humanos integran el contenido justamente de esta jurisprudencia constitucional, en donde México tiene que alinear su constitución con esta protección. Entonces, por eso es interesante y es importante esa visión en derechos humanos que nosotros aplicamos y en donde peleamos que incluso se aterrice este derecho, se cumpla este derecho cumpliendo principios de progresividad y no regresión. Esto frente a los actos que puede tener el gobierno al determinar una ley, al implementar un megaproyecto, al establecer un plan o una política pública que justo siempre estén alineados con los derechos humanos. Por otro lado, lo que también se discute en los litigios climáticos en México con este enfoque es la aplicación del principio pro persona. O sea, siempre también buscar que se cumpla el derecho al medio ambiente sano con esa interpretación más amplia. Y por eso comentábamos que es importante esta amplitud que se da en el sentido de que hay que atender los tratados internacionales donde México, por ejemplo, es Estado parte y donde puedan tener una interpretación que contribuya a la mayor protección de los ciudadanos. Todo esto vinculado con los litigios climáticos. Por otro lado, otro principio que nosotros también aplicamos muy fuerte es el principio de indubio pro natura, donde también siempre se tiene que resolver a favor de la naturaleza en caso de que haya alguna duda o bien, lo que se comentaba hace rato, no tengamos mucha certeza respecto a los impactos y que podamos aplicar el principio de precaución, pero ligado con el principio de indubio pro natura. Entonces, todo esto empieza a ser muy representativo en México, insisto, en esa aplicación de ese enfoque de derechos humanos donde el principal responsable va a ser el Estado, porque de hecho, si tenemos megaproyectos donde incluso, desde luego, estén vinculadas empresas, pero aquí el principal responsable va a ser el Estado porque es el que otorga las autorizaciones, es el que otorga las licencias y toda esta normativa que debería de cumplir una empresa y que el Estado tendría que revisar, tiene que tener el enfoque de derechos humanos porque la normativa ambiental en México es reglamentaria del artículo 4, que es el que nos garantiza en México el derecho humano al medio ambiente sano. Y entonces, en este contexto, tenemos varios casos, sobre todo los 22 casos que tenemos catalogados de litigio climático, tienen mucho que ver con la mitigación de emisiones. ¿Esto en qué sentido? Reclamar al Estado que ha ejecutado acciones o bien ha sido omiso en ejecutar acciones para reducir los impactos del cambio climático. Por ejemplo, tuvimos un caso en 2020 debido a que el Congreso mexicano reformó la Ley General de Cambio Climático y eliminó el Fondo para el Cambio Climático. Es decir, para dar financiamiento, ya sea con recursos públicos, privados, nacionales e internacionales, para implementar acciones ante el cambio climático, porque ese era el objeto, y el gobierno federal lo elimina. Entonces, al ser omiso en determinar algún recurso económico para las acciones, es una afectación para garantizar nuestro derecho humano al medio ambiente sano y es una acción que es regresiva a la protección que ya teníamos. Por eso vino un litigio climático para reclamarle esa omisión al Estado. En otros casos, nos hemos movido en el litigio climático, como se ha mencionado en la mañana, creo que en la mayoría ha sido sobre el sector energético. En México no es la excepción, también tenemos la mayoría de los casos contra sector energético por acciones que no contribuyen a la transición energética. Pero, insisto, si está involucrada alguna empresa energética, aquí al que se le reclama en principio es al Estado porque da la autorización y la licencia de actuación. Ahora, un punto que hay que tomar en cuenta es que en México los sectores que tienen que ver con emisiones de gases de efecto invernadero son empresas del Estado, o sea, como puede ser Pemex o la Comisión Federal de Energía. Entonces, al final, el demandante tiene que seguir siendo el Estado, porque es una empresa que además depende del Estado. Ahora, por otro lado, es cierto que vienen muchas empresas transnacionales a implementar proyectos en México, pero quien da las autorizaciones es el Estado. Entonces, por eso reclamamos directamente primero al Estado, porque es el que autoriza o bien se hace omiso en la violación de derechos humanos. Entonces, en este contexto tenemos varios litigios en el sector energético para reclamar al Estado y por otro lado también empezamos o creemos que deberían empezarse también a catalogar dentro de la rama del litigio climático los reclamos que tenemos en transición energética justa. Y esto pues se vincula mucho con justicia climática y se vincula mucho con los casos que comentaban, por ejemplo, los que se han dado en Canadá, cuando se da violaciones a los derechos humanos de derecho a la consulta, en la información previa, libre e informada para comunidades indígenas. Y es lo que también pasa en México cuando se implementa un proyecto de descarbonización, como puede ser un proyecto de parque eólico, pero donde hay mucha violación a las comunidades indígenas y no se cumple con el derecho a la consulta. Es decir, se da la descarbonización a costa de la transgresión a los derechos a la tierra y el territorio. Entonces aquí los derechos indígenas empiezan a ser muy vulnerados y además, obviamente, vienen afectaciones al derecho al medio ambiente sano, y esto es un principio que debería de cumplir el Estado, pero esto viene obviamente vinculado con las autorizaciones que se dan a estas empresas. Y bueno, solo para ir cerrando, comentar que esto es fundamental por la vulneración que se da a los derechos a la información, participación, que son también derechos humanos que tenemos reconocidos, y además México es parte del Acuerdo de Escazú, donde además tendría que trabajar fuertemente para la protección de estos derechos y que son derechos que también empezamos a ver que empiezan a ser una fundamentación jurídica importante en la litigación climática, pero en este sector. Entonces, yo ahí lo dejo, o sea, solo para destacar el enfoque de derechos humanos que ha sido la línea principal a seguir en los casos de litigio climático en México y que, bueno, se han replicado mucho en el sur global. Gracias.
Thank you very much, Julia. And our final intervention for this panel, Juliana.
Thank you so much, Christine, and thank you all the speakers. It's truly an honor to share this space with all of you. And thank you everyone for being here today after an inspiring day, still keeping up in this last session, last panel. I'm speaking to you today on behalf of the Inter-American Institute on Justice and Sustainability, where I work as an associate attorney. And I would love to give you just an overview of our work. So at IAJS, our mission is strengthening the rule of law and good governance for public and corporate environmental and social impact. And our work focuses on Latin America. So this allows us to identify some key issues, challenges, and opportunities that on the topic that bring us together today. So also I'll mention some reference to Colombia, just given my background. And so how does this connect to the conversation on climate corporate climate litigation? Sorry. For us, this all comes down to the rule of law. So we have identified tools, challenges, and opportunities, but I want to highlight 3 viewpoints on this matter. So first, global commitments on climate shape us to develop development pathways of business activity, and clearly have an implication of the legal domestic level. So we have seen developments on the ground to advance a legal framework on for corporate accountability by addressing, as earlier was mentioned, the UN principles on business and human rights, the OECD guidelines on multilateral enterprises on responsible business, also the EU CSRD, CSDDD, and also these have influenced other recent legal developments, such as the European Green Compliance Directive, US Climate Accountability Act, single-use ban plastic bans, just to mention a few. But focusing on Latin America and the Caribbean, I would like to highlight the Escazú Agreement, the relevance of accountability and dispute resolution. This by serving as a gateway for enforcement. This also aligns with the pillars 1 and 2 of the UN guiding principles on business and human rights. And this in particular, the Escazú Agreement ensures that the environmental decisions involves the public with a focus on vulnerable groups, and businesses are also required here to facilitate participation and consultation with the guiding of principles. The second point, we all know the countries of Latin America and the Caribbean are extremely dependent on natural resources and as of this, result more vulnerable to these threats. And according to the World Bank, at least 16 countries of the Latin America region are developing countries and are more likely to suffer for climate change. So meanwhile, as governments and businesses continue to find ways to approach and tackle this climate change, we have been talking, and we have this great tool that is climate action and strategic litigation. So this tool for promoting climate justice at the country level and advancing corporate accountability. We have seen a rise in these legal actions, and all of this driven by scientific progress, the growing experience from similar cases, misinformation, physical and transitional risk associates also with the climate change. And in this universe of climate disputes, the trends show that existing tensions result in actions against states or against corporations. In the case of states, we have seen this for not displaying sufficient ambition on climate targets under the Paris Agreement, or not living up to these commitments. And I would like to highlight here the Amazon case. In this case, claimants were able to demonstrate that the higher deforestation rate of the Colombian Amazon will continue to increase greenhouse gas emissions. The court ordered to formulate and execute plans in a short, medium, and long term. The court also ordered to create an international pact for the life of the Colombian Amazon to support the adoption of these measures. However, the effectiveness of this decision is limited by administrative difficulties, lack of governance in the territory, continuing armed conflict in the area, illegal mining activities, and so on. So I would say this decision has marked a trend in Colombia regarding the protection of nature and environment, but still we have a long way to go and develop this. Regarding corporations, at least 86 legal proceedings are currently ongoing on major oil, gas, and coal producers. But in this one, I would like to highlight the Ecooro Minerals Corp versus República of Colombia, or Santurban case, also known. And this is also a landmark, and also this ecosystem is the source of water for my hometown, so it's really something that matters for me. In this case, the Canadian mining company claimed for compensation against Colombia because after a series of regulatory measures undertaken by the government protecting the Paramo ecosystem, because the concession was already granted and the contract was already given to the Canadian mining company. However, the constitutional decision analyzed all the legal and scientific arguments and conclude that the Ministry of Environment and all the authorities must carry out the delimitation of the moors or the Paramo with ecological criteria, seeking the deceleration of climate change, but we are still ongoing with the process. So we can keep categorizing all of these disputes, but in sum, all these emerging and present challenges in the region related to these topics are always testing those legal frameworks. As my third point, I would like to highlight the evolution of dispute resolution mechanism. One of the main emerging challenges is the need to balance investment protection with state sovereignty in line with climate commitments. Also, the rise of climate litigation highlights the urgency of responding to society demands through the justice. Sorry, I went here. I forgot to move the slides. Yeah. And given my background, as I mentioned, I would like to say and to talk about Colombia. And Colombia is not a stranger to these global tendencies. We have developed a regulatory framework, I would say strong, from the constitution, laws ratifying treaties, recently the ratification of the Escazú Agreement that foresees the materialization of lawsuits similar to those seen in other countries. But I will say our future directions on these cases are that claims are not focusing on compensation for climate change damages, but on the lack of public policies and environmental protections. The claims also are normally filed against public authorities rather than against the governments itself or private actors. Colombia may have to incorporate international trends on climate change. We have seen and we have around La Oroya, we are going to have soon the Peruvian farmer case, so we can highlight our pathway with these decisions. And we also are going to have always issues that change as change of government, armed conflict, economic needs, and intentions to increase capital using biodiversity in an unsustainable manner as a serious risk in this context. I promise I was gonna be brief because I know it's the last one, but I would just like to conclude saying that to ensure legal security for investments beyond 2030, it is essential to integrate the UN's 8R framework. Also, there are always different ways to meet climate change obligations, but a greater integration and coordination of government, communities, and private actors will always improve these procedures. And enforceability. Also, legal actions may expand beyond environmental regulations to include broader considerations of corporate responsibility. So I would like to just wrap up with these conclusions.
Thank you. So thank you so much to all four of our panelists, and I'd like to open it up to both people online, people in the room, if you have any questions, any forward-thinking questions that this panel really is looking what's next. I know we don't have a crystal ball, but we can pretend. And if there are no questions right now, I'll start one. This is for the group, but after your own experience in your own countries, in different areas of the Americas, what's the most promising either theory for these corporate cases or trend that's emerging that you think is going to show success or has the potential to be successful going forward? Maybe not tomorrow, but it could be 10 years, it could be 15 years.
Well, I think in the space of climate litigation, when you think of how long these cases are and how likely they're not going to succeed based on the stakes that are at issue and how creative the theories have to be and just how time consuming it is to navigate all the procedural hurdles, I think the climate washing line of cases is where the opportunity for most short-term success lies. I think the scope of the claims are narrower, the pathways for legal recourse are clearer and more accessible. And I think there's just more established law blazing that trail. So when you're talking about consumer protection law, there are really straightforward standards that identify where there has been a false or misleading claim. We have the Federal Trade Commission's green guides that are supposed to be updated. They were supposed to be updated last year, any day now. And we have good precedent, I think, that's evolving about what it means to hold corporate actors to a transparent, accountable kind of relationship with the public when it's about complying with climate change commitments, because the stakes are so high and it's so important to be transparent and accountable. I think certainly the EU is taking the lead on this, but there are promising developments in the US where climate washing claims are certainly gaining traction, and they're building on a long history of greenwashing and humane washing cases in the animal law context that has built a cohesive body of jurisprudence that has been more successful, I think, than a lot of these other theories that are ambitious but very difficult to succeed on.
Thank you. Anyone else from the group? Yes, Rosalia?
Gracias. Gracias. Creo que una línea donde puede empezar a evolucionar y ser efectiva es lo que tiene que ver con la normativa en debida diligencia para las empresas en materia de derechos humanos y que ya se empieza a aplicar en la Unión Europea, especialmente la norma que deriva de la ley de vigilancia en Francia. Creo que este tipo de normativa, en donde empieza a obligar también a la empresa a cumplir con derechos humanos, que en varias jurisdicciones por ahora es un contexto sobre todo más voluntario, si lo empezamos a aterrizar en cuestiones obligatorias, como lo que sucede en la ley francesa con los planes de vigilancia, creo que esto puede ser una tendencia que podría empezar a replicarse en diversos países. Y tan solo, pues bueno, por ejemplo, ahorita en México hay un caso de un parque eólico donde estuvo involucrada una empresa francesa, donde hubo violación de derechos humanos y que tiene que ver con la descarbonización, pero ya se presentó un litigio transfronterizo en Francia a raíz de esta ley donde se exige derechos humanos a la empresa y que se vincula con todos estos temas en materia de cambio climático. Entonces, creo que por ahí podría ir la visión a futuro para buscar más fundamentación jurídica, para exigir a las empresas el cumplimiento de la protección de los derechos humanos. Y otra línea que yo veo también es la normativa que se empieza a dar en la Unión Europea ante las prácticas perversas que tiene que ver con la obsolescencia programada, que también empieza a haber normativa en la Unión Europea para ir en contra de estas prácticas que al final contribuyen a la emisión de gases de efecto invernadero. Entonces me parece que es normativa que también sería vías para la protección y los derechos del consumidor, que se vincula justamente con la contaminación que se genera por estas emisiones y que contribuyen a impactos de cambio climático. Creo que son fundamentos jurídicos que pueden ser fuertes para el litigio climático en un futuro a nivel corporativo. Gracias.
Thank you. Maria Antonia?
Yeah, I think I just wanted to emphasize this issue of the transnational cases. I think that's really, it seems like there are a lot of different types of alternatives that are being brought up across the world. So Rosalia mentioned some of the French cases as well, based on the duty of vigilance law, if I'm not mistaken, that's what she was referring to, with respect to deforestation in the Amazon rainforest and certain other. So like looking at that type of corporate accountability across the whole supply chain as well, and seeing sort of all the different stages. And just because a company is not necessarily based in, in a certain jurisdiction doesn't mean that it doesn't affect what's going on there. So in the case of the deforestation case in France, it was against a supermarket chain, and thinking about that responsibility for deforestation caused by meat, cattle ranching and in Brazil and Colombia. So I think these types of different legal theories are really interesting, and to see sort of which jurisdictions are more open to that, and which types of legal claims could be explored elsewhere as well.
Thank you. Juliana?
I will just leave the experts.
Okay. Yes, any questions in the room or online? Ivana?
If I may, I would like to know if you can make an example. I mean, Maria Antonia mentioned this, she mentioned the just transition cases that is a new sort of movement or phenomenon that we see, especially in Latin America. Do you see some particular possible cases or that in your country is happening or might happen related to just transition cases, but involving corporate actors? This is something that I would be interested to understand. Where are we in Colombia, Mexico, and of course in the US? It's a little bit more difficult because it's not really.
Yeah, I'm trying to think of a particular example. I think we do have, I I think probably most are against the government, but I thought we did have a couple of, I'm not going to remember from the top of my head, but like I think in any case, I just like I would sort of conceptualizing it there. I think there might be a case in Chile, but if not, it's sort of similar to something similar, but that relates to, you know, really sort of the workers that are being affected by like a say like a fossil fuel company closing down, right? Due to certain policies that are climate related. So I think like sort of that part of like you know, the just transition of the workers in that case like would be obviously, you know, according to human rights law and to workers' compensations, you know, like all of those things being considered as well. But I think in addition to that, I think like part of those EIA requirements in a permitting procedure as well for like critical minerals mining or things like that. I think that could be potentially be brought against corporations too.
Well, I would say in the case of Colombia, as Rosalia mentioned, usually it's against the government because they are the ones like given the license. So yeah, but I think and I believe the Escazú agreement will help to open maybe that line.
All right, any other comments on that? I do see, and I saw another hand. Yes, please.
Yeah, so from what you're saying and from the talks today, it seems like there'll be an increase in cases in the upcoming years that are being heard on their merits across the Americas. I'm curious, I guess my assumption is that we're gonna have a mixed bag of rulings. There'll be the good and bad that comes from that. And I'd love to hear thoughts on how we, even if there's negative rulings, kind of how we continue to build this work, how we think about kind of mixed rulings within this space. Yeah, and how, I guess, how we like push through if there's setbacks or if there's problematic precedents that get set at all in these upcoming years.
Yeah, my approach to climate litigation for 2 decades now is it's a process of losing the battles and winning the war is really what's going on, in the sense that certainly we don't want to address the climate change challenge one case at a time. We'll all be dead. So it's really about kind of raising awareness and putting together information that will subsequently mobilize something that is in a more top-down manner. So I'm really convinced that the climate justice strategic litigation that happened during the Trump 1 administration is largely responsible for the IRA passing. I mean, I was shocked that we had anything resembling climate litigation. And I think the amount of awareness that was built through all the litigation that happened in 2016 to 2020 was mobilizing a grassroots movement that was leaning on their elected representatives, and you know, that legislation just wouldn't have passed without that awareness building. So I also think there's the science and the legal theories behind the litigation ultimately helps inform how legislation should look, what you know, angles it should take, where some limitations might be. But in the short term, in terms of structuring those legal theories and just looking at it from a litigation perspective, I think we heard earlier today that it is dangerous to be too ambitious, because you win and then you lose. So we've seen these fantastic strategic climate litigation victories that, including in the US, Mass v. EPA, that took a decade to implement and then imploded. If it's too ambitious a victory in the court, it's going to face backlash and it may never be implemented. So we have to be very strategic about what we're looking to accomplish in the courts, because even a win could be a loss if it's too ambitious.
Other responses to this? No? All right, I think we have time for maybe one more question. Online or in person? Jared.
Sure. A lot of these, this is such a fast moving and active field, and it always feels like there's a new bit of news each day. So I'm sort of curious, from each position where you all sit, what is like the next thing on your horizon, or what is one sort of thing you're waiting on, whether that's a court decision or a hearing or a report that's coming out, or sort of what is one thing that we can look forward to this year or in the coming months in this area?
I'm encouraged by the slow but steady movement of that BP v. Baltimore line of cases going to trial. I mean, I think win, lose, or draw, that's going to be a very important victory for promoting corporate climate accountability. And it's not clear what form that might take, but there's just a lot of evidence that the writing is on the wall, and I think it's going to be a very pivotal moment when there is that sense of, okay, now we're on the hook to whatever degree we're on the hook. We've got to pivot in a way that's going to be better for the climate because we have to, because they won't do it before they have to. So I think those cases really do have the momentum that will create some positive outcome. It's just a matter of how soon.
Anyone online like to chime in? No. Liana?
Well, I would say from my point of view, and I'll be insisting on this because I'm actually working related with the BIICL agreement, and this was just a huge change for us in Colombia, and I'm just waiting to see if this is gonna lead to somewhere else, maybe encourage some other cases, or maybe corporations will gonna be now as the international trend. Maybe it's gonna be a national adopting that. So I would say I'm just waiting on how evolved this path.
Well, thank you so much to everyone on this panel, to Ivano, to Michael, to Jared, to Helene, to Sarah and Madison that have been running the back end. So I will give the word over to you, Ivano, Michael, if you'd like to close us out.
Okay, so just two words, because I know that it's very late, and I think that we have really the chance of listening to great speakers and experts. So I'm not taking more time. I just want to thank all of you, all the speakers, all the people participating in person, online. I would like to thank Michael for his support, the organization that we had together, Jared, Ellen, everybody that contributed and organized this. It was impossible to do without you, especially that we are coming from the other side of the Atlantic. And it's really a pleasure, and it's been an honor to do this at Eli. So thank you very much, and I hope that you can follow our work. As I said at the beginning, the Global Toolbox on Corporate Climate Litigation is an ongoing project. We are just, I would say, at the beginning of it. We just starting scratching the surface, and we would like to, with your help, with the help of all the different experts in the different areas, with the judges, with the scientists, of course, the practitioners, to try and find the better way of working together in this complex but also exciting part of climate governance. So thank you very much, everyone, for contributing to this. And I look forward to meeting you again very soon. Thank you.